emergency room is equipped to handle life-threatening conditions quickly. Your emergency or concern is our priority, and we're here when you need us. Lifesavers 24-hour emergency room is your ER for immediate care. Now with 3 convenient Houston locations, open 24/7 to get you feeling better fast.
May I approach and have the smarts?
Yeah, will they be taking the stand?
Yes.
Okay. For the profit?
Yes.
Okay, Mr. Paschel, sir, if you please come to the witness stand.
Good morning, everyone.
Sir, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat.
Oh, he's on the stand.
State your name for the court.
Geoffrey Paschel.
And Mr. Paschel, you've been in the courtroom today. You've heard the testimony from Ms. Wilson Chapman, correct?
That's correct.
And during the relevant time period from June 9th of 2019 to some months forward, did you in fact have a smartphone?
I did.
And tell the court what make and model of smartphone that you had.
I had an iPhone during that time. I think it was an iPhone 8 possibly.
Now, after the evening of June 9th, 2019, did you receive any text messages from Kristen Wilson Chapman?
I did.
May I approach? Mr. Paschel, let me show you what has been marked as Exhibit 61 and ask if you can take a moment to review that document. And if the court would like a copy of the exhibit, what would... And Mr. Paschel, if you'll tell me when you're finished reviewing
I'm finished.
Exhibit 61.
Yeah, I'm finished.
Oh.
And can you tell the court what is depicted in Exhibit 61?
They're text messages between us.
When you say us, tell the court who us entails.
They're text messages between Kristen Wilson Chapman from the time of when prior to the incident onwards, after all the way up to December 22nd of 2017. Yes, it says metabolic bone disease. That was when there was a squirrel at my house, and she had sent that to me concerning what was wrong with the squirrel. So that was when we were on good terms.
So it encompassed a time period before June 9th to sometime forward, correct?
That's correct.
And can you describe to the court what these pages represent?
They represent text messages upwards of 2-3 months, up to 5 months after the incident, where she wishes me happy birthday at one point and tells me she misses me.
Well, let's not go into the content right now.
Oh, God.
How did you obtain copies of the screenshots of your iPhone?
I physically screenshotted them.
That was a dumb question.
And specifically, when you have looked at, let's just say page 1, 2, and 3 of Exhibit 61, did you screenshot these text messages contemporaneously when they were
Exactly,
received?
Ashley. Exactly.
I did not, no.
When did you take screenshots of these messages?
Sometime after the last one, preparing for court.
So you basically searched your phone and
Oh,
looked to see
Barbie,
if
I
you had
saw
any
that.
communication from Ms. Wilson Chapman.
Well, I knew they were there, but I looked at it and brought it up and screenshotted it and then sent them over.
And let's look at page 1 of Exhibit 61, and you refer to metabolic bone disease emergency treatment, henryspets.com. Who is that communication from?
That was from Ms. Wilson Chapman.
And can you tell from the screenshot when you received that text?
I cannot. I'm assuming it was around January 7th or June 7th of that year.
You assaulted her
Now,
on June 9th. Well, allegedly.
Above the metabolic bone disease text, there is a screenshot of an icon K. Underward, it says Kristen with 3 emojis.
Thank you, Sally.
Female smiley face emoji with hearts, another one with hearts, the other one a couple with a time of 7:55. When did you receive that text message, if you know?
No, the 7:55 is when I took the screenshot of the day I took them. It said June
Oh my
9th,
God,
2019
this attorney is dumb.
at 7:18 p.m.
Yes.
In my
That's when
opinion.
she stopped. That's after the incident, and that's when she had stopped sharing the location with me. She had been sharing the location at that time.
All right, there is a text that says, "Hi, happy belated birthday. It's been so long, I've really missed you." What is the date of that text?
That is September 13th at 2019. at
And she got
10:29.
married in October.
And who is that text from?
That was from Ms. Wilson Chapman, and my birthday is September 12th, so that was the day after my birthday.
The next text is September 18th, 2019. Can you read that text in the record and tell the court from whom that text message is from?
I really feel bad about everything, Geoffrey. I think things have just gone too far, and I'm too deep in. I'm not sure how to make things right with you. I had to get a new phone, by the way. That was in the same groupage of texts, and that was September 18th at 1:23 p.m. of 2019 from Ms. Wilson Chapman to me.
Okay.
The next text is somewhat cut off and it continues on the next page. Can you tell the court the date of the following text?
That was the next day after the previous text on September 19th, 2019.
And can you read into the record what that text says?
Was really looking forward to seeing you today.
Who is that text from?
That was from Ms. Wilson Chapman.
And can you put that in context for the court?
I believe we had a hearing that day that was put off for some reason. So we had a hearing where she was going to end up seeing me in court, I believe.
That could have been a sarcastic text.
The next text is dated September 29th, 2019, 11:02 p.m. Can you read that text and tell the court from whom that text is from?
That's from Ms. Wilson Chapman, and it says, "Hey, sorry for the late text. I've been thinking about you a lot."
Okay, the next text, same day.
Same day, same time frame. I feel like I'm just settling with everything.
The next text is Tuesday, October 8th at 8:01. Can you read that text for the record?
It's really wish you wouldn't ignore me, and then an emoji of crying.
Oh
Now-
my God.
It looks like these texts are from Ms. Chapman, but I don't see a response. Did you respond to her text?
Oh, absolutely not.
And why not?
Honestly, I thought it was being set up in some way. I didn't want to respond.
Why
to
would
it.
you be set up,
Was
Geoffrey?
there a pending order of protection or other?
There was.
Thursday, October 10th, can you read that text into the record and tell the court from whom it was received?
This could have gone away.
Don't start that.
Over a month later, Sunday, November 17th, can you read that text into the record?
You should have responded to me. This is your fault by acting like you were above me. I told you not to leave me. All you had to do was take care of me. This has blown up, and now I can't stop it. In fact, I don't even want to now. I'll do everything I can for you to lose Caven.
Oh, damn.
And who is that text from?
was from Miss Wilson Chapman.
And who is Caven?
Caven was at that time a 4-year-old son. He's 6 now.
Sunday, December 22nd at 9:36. Can you read that text message into the record?
Got you now! Exclamation point. You should have never messed with me.
Who is that text from?
That was from Miss Wilson Chapman to me.
3 days before Christmas. Do you have any idea the context of that text message?
Honestly, I don't. I don't know if there's court that time or not. I'm assuming not.
Same date, earlier in the day at 4:45 p.m., Sunday, December 22nd. Can you read those texts into the
New little family in peace. It didn't have to be this way. You should have responded back to me. Good luck proving everything. BTW, which is by the way, exclamation point, with a happy face. Erase all the pics and texts and I'll tell the truth, exclamation point.
Oh, damn.
Who is that series of text messages from on December 22nd at 4:44 p.m.?
They were from Miss Wilson Chapman from her phone to me.
She said erase all the texts and pics and I would tell the
these
truth.
text messages start on June 8th and they are sporadic and they culminate on December 22nd. Did you receive any additional text messages after December 22nd?
I have not, no.
And Mr. Paschel, describe to the court how you took the screenshot of your phone to obtain these messages.
I had it up on the screen. This is her name and the emojis. That's the one she put in the very beginning. But I pushed the home button and I believe the power button at the same time, and it screenshots the picture. And I did it for each of those. So I scrolled down, screenshot, scroll down, screenshot, scroll down, screenshot.
Why are you texting him?
And
Oh, come on, you hurt
Does
yourself.
Exhibit 61 truly and accurately reflect the texts that were received on your phone?
Absolutely.
I have nothing further.
Ooh, come on. Come on, prosecution. Come on. Come on.
All right, Mr. Paschel, you say that these purported text messages came from Ms. Wilson Chapman, is that correct?
That's correct.
All right, I want to talk to you about some statements you've made and some civil depositions that you had in one of your custody cases in the months prior to this
Hi,
incident
Stephanie.
to June, okay? So on, let's see here, January 9th of 2019, so about 6 months, actually exactly 6 months before this incident took place, do you remember going and having a deposition in your pending custody case against your ex-wife, Brittany?
I did. I don't know if it was that time frame, but yes.
Okay, do you remember Robert White being there, the attorney, or Brandon White, I'm sorry, Brandon White, the attorney who represents your ex-wife?
Yes.
And Mr. White asked you at the time who Ms. Wilson was. You stated Kristen wasn't.
We would object to her reading from the deposition. I think the proper way would be under Rule 612 to use it as present recollection and fresh. She can ask a question, he can admit or deny it, if he denies it, she can show him a copy of his prior sworn testimony. But reading testimony from collateral ancillary proceedings would not be admissible or appropriate. So we would object unless she uses it in the appropriate way under the rules.
Well, I don't know how she used it, I don't know what it says. If it's a prior inconsistent statement from something that he said here during his testimony during the proffer,
Yep.
she could read it to him under those circumstances.
Yes, she can.
But if not, she would need to follow the appropriate method.
And Judge, I wasn't reading verbatim, I'm just telling him kind of what he said. So,
Well, it's the same principle. If it's a prior inconsistent statement, you can confront the witness with it directly. If it's not, if it's being used for some other purpose, the appropriate method would be to ask him the question and then go from there with the exhibit if necessary.
were you asked about Ms. Wilson at the deposition?
Honestly, I don't remember.
Would it refresh your recollection if you were able to see your deposition testimony.
Yes.
May I approach it?
There you go. Show it to him.
All right. Show you the sort of highlight portion here. Just more that I read it and then look at it whenever you're done.
Why is his mask on? He's sitting over there by himself. Show your face, Geoffrey. Show your face.
All these?
Yeah. There you go.
Oh, Ashley. I actually have it on my TV too, so they actually froze a minute ago.
Okay, he's reading over this deposition from another custody issue before this.
No,
incident
Cooch, you haven't
took
missed
place.
much.
What did he say? And were these text messages that were just tried to be introduced by the defense, legit? Where's the cell phone expert? Where's
Yep.
the
Thank you. I need the
validity
cell
here?
phone
A lot
expert.
of, questions to be answered here. Philip Dubé, what's your initial reaction to hearing all those text messages?
Well, first of all, he can lay the foundation for his own text. They're on his phone. He's familiar with them. They're writings that were going on between the two of them. But what it shows
But can't you
me
fake
is-
that? I mean, can't you make that, have your buddy somehow, I don't know. I feel like there should be a cell phone expert here.
Me too.
Well, then it goes to the weight of the evidence. If the jury decides they think he's, a big put on and these are just fabricated, then so be it. But they don't really have any evidence to counter that from what I've seen. Well, I'll tell you what I have seen, if you're to believe these texts, is that she's not afraid of him. If you don't have fear, then what are you left with? Maybe vengeance, retribution, retaliation, as opposed to saying, you should have responded back to me. You'd think she'd say, you should have never put a hand on me. But you don't see that anywhere. This is what you get for harming a woman. How dare you lay your hands or put your hands on a female?
Well,
No,
let's listen in.
instead, yeah.
I agree with that
I
too.
mean,
but
if
let's
that's
see what.
the true transcripts, then yes, he asked me. I don't recall that. It was 2-3 years ago, maybe.
Okay, and after reading that, do you recall what your answer was?
If I knew Miss Wilson,
Mm-hmm. Yes.
yes.
What did you say that your relationship with her was?
I'm not. Do you mind if I have a copy of that to refer to?
Oh my God. You should know what your relationship was. We keep saying what it was. You said you were engaged. Yeah, he's stumbling. Let's get your lies together,
Okay,
Geoffrey.
so let's start on that first page there. Were you asked whether or not you knew Miss Wilson?
But he asked me who's Kristen, and I
And
said
what was your response?
Kristen was a friend.
Okay.
Ooh,
Let's go to the next page.
get him.
And look at the top portion there. And what did you state your relationship was with Miss Wilson?
Kristen was a friend on the prior page.
Well, and continue on to the next one. Did you say that she was your babysitter actually?
Oh,
No, actually, I didn't. I said, did you meet her just as being a child care provider? I said, I met her. Yes.
Again, she can ask him the question, show him the document, ask him to refresh his recollection. If he can't, then I think that she is left with his answer. And those excerpts are not inconsistent statements that would otherwise make it admissible. So we would object to asking her to say ask you, Mr. Paschel, to read a deposition in a custody case.
That's sustained. It's not being offered an inconsistent statement of anything that he said during the direct portion of his proffer. So you can't just read in a prior sworn testimony. You have to rely on his testimony from the witness stand.
Well, do I need to get the paperwork back, I guess?
Sure. I mean, unless you have another appropriate way to use it.
Well, but, I mean, I'm kind of to show credibility here, and if I could, you know, have 5 minutes to do that without an objection, I think that this stuff is going to show that 6 months prior to this, in a sworn deposition, this defendant stated that.
Yeah, he objected. I sustained the objection. It was an appropriate objection. You're not doing this properly, so move on and.
Come on, you got to do it the
You
right
can
way,
do
girl.
anything you need
Come
to
on.
do during this proffer within the rules of evidence.
The other one. Okay, did you also have a deposition on May the 17th of 2019?
Honestly, ma'am, I don't recall.
Oh my
Okay.
God.
Would it refresh your recollection if I showed you that, just so you can see the dates and stuff?
Possibly.
That first page, like, is that- show you the date.
It shows me a date, yes.
Does that appear to be the transfer between you and your ex-wife? To have your names on it?
It has our names on it, but I can't authenticate it as a transcript, though.
What day is that?
May 17th of 2019, so about 2 weeks before this. Do you recall being asked to provide text messages between you and Ms. Wilson at that deposition?
I don't recall. No.
Whoo.
Again, would it refresh your recollection if you looked at your prior testimony?
I mean, I'll be happy to look at it.
Oh my God, he's trying to act so sweet, so nice.
Number versus the record.
Yeah. So I'm looking at.
Yes, he's playing games. Exactly, Teresa. He's playing games.
This would be page 108, starting at line 20. Just read that, and then you turn to the next page, and then we'll look up here. After reading that, you were asked whether or not you had text messages between you and Ms. Wilson, correct?
I mean, if that's what it says.
Well, you just read it, Mr. Paschel. Is that what it said?
Would you mind having me a copy so I can?
Oh my God, here we
That's
go
it,
with
yeah.
this bull.
After reading that, Mr. Paschel, does it refresh your recollection about the content testimony you gave in that deposition?
Me too, Sassy.
Honestly, it really doesn't. It's 3 years old.
Your Honor, at this point, I mean, if I need to call the attorney to get him to come in and testify about this, I can do that. I mean, I'm not really sure how else we want to do this.
That likewise will not be admissible to have the attorney testify to hearsay as to what.
I'm saying to authenticate the deposition itself. I do not have a certified copy right here, right now, but, you know, if that's something I need to get, then I can certainly do that.
Not my lawsuit, guys.
And that's not the basis of our objection. We're making it under recollection refreshed, and it's not an inconsistent statement.
It will be an inconsistent, there actually is an inconsistent statement in here, but he's not, with him saying that he keeps all these text messages, because 2 weeks before he told an attorney that he deletes all of his text messages almost daily.
Well, if it's an inconsistent statement.
Damn.
Earlier, you confront the witness with the inconsistent statement, so long as it was inconsistent with something that he said during the trial.
I can't hear the judge too well.
Let's go back to that page real quick.
Ooh, Tina, I just love your comments.
All right, so after reading that, just to be clear, your memory was not refreshed by reading your prior testimony. Is that correct?
That's correct.
Okay. I want you've got a copy of it up there, so I'm gonna, if you don't mind, to look at it with me. Again, we're looking at page 108, beginning at line 20.
He doesn't
You
want
were
that
asked,
attorney to
have you
come in.
obtained your text messages with Kristen? Your answer, I think per the, when we spoke in here, I didn't keep those text messages. You were asked, have you since? You answer, no, we don't even text anymore. Is that what that says there?
Yes.
And that was 2 weeks prior to this incident, was it not?
No, it wasn't.
May 17th of 2019 was not 2 weeks prior to June the 9th of 2019?
This is not from May 17th. This is from January.
No, this one is from May 17th. I brought it up there and showed it to you. That excerpt you have right now is from May 17th.
Okay. I just don't have any dates on it to know. There's no dates on it anywhere.
Oh my God.
Joe, can I have a copy of what you're showing? You're jumping around. I need to see it.
I provided you multiple.
Mm.
I will go print another one. All right, see right here. May 17th.
Can I see it before my clients ask about the document? What page line are you referring to? The highlighted portion.
Okay.
Your Honor, this deposition is dated May 17, 2019. These texts came in after June 9, 2019. This is an inference that's not correct and it's false and it's not relevant. This answer dealt with text prior to this incident even happening. I strongly object to her creating an inappropriate inference in the record.
But he said they didn't text anymore, but they were engaged. That's the point. He lied.
Because literally 2 weeks prior to this incident, he told a civil attorney in a civil deposition, he does not talk to Ms. Wilson anymore.
Thank
He
you.
does not keep text messages with her. Yet he's trying to now come in and say that he has screenshots purportedly with text messages before it, which nobody's ever seen. Before the date, he said that there's a text message snippet at the top prior to June the 9th. Yet 2 weeks before this, he tells an attorney that he doesn't even speak with her anymore, that he does not keep his text messages with her, that he deletes text messages almost daily to save space on his phone. And it goes to the authentication of these messages themselves.
Okay, so you're using that to attack his credibility as a witness? And that you're saying he was lying about that then?
No, Judge, I'm using it to say that it calls into question the authenticity of these text messages themselves that he's now trying to pass off.
They happened 5, 6, 8, 9 months after this deposition. They didn't exist yet. He can't deny it. She texted him after the fact. That was true in May of 2019. This is September 19th.
But how did you get engaged if you're not texting and talking to anybody?
There is no actual legal or logical nexus between that deposition and these text messages that came in a year later. How could he give an inconsistent statement with something that didn't exist?
It wasn't a year later.
I strongly object to her use of this transcript because it's inappropriate and it's not consistent with the rules.
Well, I think we are getting far afield with the limited scope of this proffer, which is whether these text messages will be authenticated and whether they're relevant in this.
And Judge, also, again, this is kind of events leading up to this. If I may just have a little bit of leeway here. Mr. Paschel, do you remember on June the 4th, sending a letter having your attorney send a letter providing Mr. White with Ms. Wilson's phone number?
Objection. June 4th of what year?
2019, 5 days before this.
Before the allegations in this case, I object.
Oh my God.
See how it relates to the.
Thank you. Let her keep going. She said she needed a little leeway.
So we can dig into these issues. So let me see if the responses to this are relevant to the question I had.
Do you recall your attorney sending Mr. White a letter following your depositions that were supposed to provide Ms.
I
Wilson's
don't
phone
recall.
number?
I don't know what my attorney sent.
See?
No.
I don't recall. I don't know.
Your attorney
I have no
said,
recollection.
Paul Tiller, right?
If she could ask him to review the document to refresh his recollection.
It's just gonna be that first page, really.
I think they should too. This should have all been discussed yesterday after the jury was dismissed.
You seen that letter before?
No.
You've never seen this letter before?
I agree,
Not to my
Tina.
recollection,
I
no,
agree.
not at all.
I really agree. I want to see the smirkness on his
Your attorney
face.
said in a motion, he acknowledged that you had seen this letter before in his response to the state's motion.
It's not appropriate under present recollection fresh.
I need to hear her question first.
Mr. Paschel, you have been participating with your attorney throughout this case, is that correct?
Objection to attorney-client communication.
I did not ask what you all talk about.
This is another attorney in another case.
Now, I'm talking
Okay,
about
guys,
you.
Arguments come this way. You don't ask the question. What's your question?
You've been participating with Mr. Isaacs throughout this process, is that correct?
Yes.
Don't tell me anything said, but this case has been pending for 2 years now, right?
Yes.
And we've had multiple motion hearings, multiple court dates, is that correct?
Yes.
And you are aware that your attorney has filed motions on your behalf,
Yes, of course.
and are you aware that your attorney has acknowledged this letter in a filing?
Are we talking about Mr. Isaacs?
Yes.
I'm not aware. I don't know what he's done.
Oh my
Okay. So
God.
you don't read anything that your attorney files.
I don't know what he's acknowledged.
Do you recall telling your attorney that Ms. Wilson asked you to give your civil attorney a false number?
That's not my attorney in that paper. I don't have a Paul Dillard as an attorney. I'm sorry that
You're not represented by anybody at Mears and Dillard.
I'm represented by Martha Mears, not Paul Dillard. I don't.
Oh my God. He's pissing me off. Me
You would
too.
agree with me that people in the same law firm can work on things interchangeably?
I would not know that information.
Okay.
Oh my God.
Judge, the reason I'm asking all of this is because, once
Lose
again,
your
5
temper,
days
Geoffrey.
prior, he provides a false phone number for Ms. Wilson in his civil deposition, or in his civil case. He provides a phone number that 100% is not Ms. Wilson's number, has never been Ms. Wilson's number. The defense has acknowledged that he did that in their filings, but state that Ms. Wilson asked him to do that. That's just what I'm trying to get at for authenticity purposes, Judge.
Proof's gotta come from here,
Okay.
though. This is the witness that we have. So you can cross-examine him.
Okay.
Within the rules that.
Well, and Judge,
You don't have to argue to me in the midst of your cross, just cross the witness.
Okay.
well, Judge, my point being, I think if Mr. Paschel is not going to acknowledge any sort of knowledge about any of this stuff, then I'm going to have to call other people to get it authenticated, is kind of what I'm getting at.
You know, you can call whoever you want, but
Right.
this is your witness. We're not arguing. There's no objection. Just cross the witness.
Mr. Paschel, you and Ms. Wilson do not have children together.
That is correct.
You would agree that there is a text message in here that says, hope you enjoy all your other kids. At least I get to enjoy my new little family in peace. That's what one of the messages say.
I remember it. I don't see it this very moment.
December 22nd, no year.
Of 2019. Yes, I see it.
Well, just to be
Right.
clear, there is no year on some of these, is that correct?
There's not.
Okay, so some of them just have a date, but no year.
Yes, that's correct.
And then right above that, it says, I'll do everything I can for you to lose Caven, is that correct?
Good morning.
Above that
Above
is
that
actually,
text message from June 22nd, or December 22nd, I'm sorry.
well, about the family and peace. Above that is a different text message.
Do you see a message where you say, Ms. Wilson says, I'll do everything I can for you to lose Caven?
Yes, that was sent in November.
That is not her child, is that right?
That's correct.
And this case has been pending for 2.5 years, has it not? This
Some-
case, the criminal case,
Less than that, but somewhere around there. Yes.
over 2 years,
Yes,
is that right? We had multiple court dates down in Sessions Court. You remember going to those?
I did.
And we've had multiple court dates in this court. You remember coming to those?
I have.
Specifically, just since the case has been in criminal court, you were arraigned on this case January 17th of 2020.
Yeah, possibly.
You were back in court in July
God.
of 2020.
Yes.
Back in court on September 25th, 2020.
If that's what the record states.
You did not provide these text messages.
Not at
until
all.
Over a year after you say you received the first one. Is that correct?
I provided everything to my lawyers. Whenever you got whatever you got, I'm not in control of that.
Okay. You would agree that the state did not have notice of these until September 29th of last year when the motion was filed. Are you even aware of that?
I would not be aware of that
Okay.
when you got the messages.
And these messages do not have a phone number on them whatsoever. They do not indicate anything other than Kristen. Is that right?
Oh, damn.
That is correct.
And so after, just briefly, you see the three little emojis after the name Kristen,
Yes.
right? You kept her name saved in your phone that way after this incident.
I never changed anything. She's the one that put that in there, in that name in there.
Okay. And again, can you tell me why some of these don't have years on them? For instance, the one on October the 8th, no year. October 10th, no year. November 17th, no year.
I can't tell you. I don't know how iPhone.
All
programming
messages
works.
have
I have
dates.
no idea.
But you would agree with me that there is
I'm
no
looking
year
at my
on some of
phone
these.
right now. They have
I mean, they
dates
flow
by
into
them.
and from September, and it has a year. September has a year. On the same page of the text message, September 29th has a year, and then October, it doesn't have the year. But I can't tell you why it doesn't.
And,
I have dates on
you never
mine,
did,
all
your
of them.
phone was never forensically downloaded or anything like that, correct? This is the only thing you have is just these screenshots. Is that right?
My phone had never been requested to be downloaded.
Okay. Judge, I think that's all I have at this time.
None.
Okay, you may step down.
I'm looking. I
Any
have
other proof
dates.
in the proffer?
Not on behalf of Mr. Paschel.
Okay, any proof from the state on the proffer?
November 11th, 2020.
Okay.
Dates.
We'll call Kristen Chapman.
Okay. Ms. Chapman's still under oath.
That's what they need to do, pull his phone records. I'm
Ms.
surprised they didn't
Chapman,
do that.
you've been sitting in the courtroom while we've been talking about these text messages. Is that correct?
Yes,
And did you, in fact, text Geoffrey Paschel after the incident of June 9th?
absolutely not.
And when did it come to your attention that I?
Yep, he did, Celia. I believe
Was
that.
that pretty recently?
Yes, it was. It was only when you told me recently.
And what did you do once you found out that Mr. Paschel was making an attempt to say that you had contacted him?
I provided my phone that I had. I provided all the Verizon records that I had.
Thank you, Kristen.
I believe we asked to subpoena Verizon and Apple for my iCloud information to prove that I did not send these messages.
Okay. And so you did all of that voluntarily?
Yes.
Voluntarily, is that correct?
Mhm.
And that was after Mr. Paschel produced these purported screenshots, is that right?
Yes.
Ms. Wilson,
Hi, Amanda.
what is your phone number?
My current phone number or the one that I had at that time? 585-749-7329.
And are you aware of the fact that a different telephone number was provided for you in Mr. Paschel's civil case?
Yes.
Your Honor, I object. That was in another case. Hearsay.
It's not hearsay, it's in the record.
It's not to make a fact of consequence more or less probable. That's the same information she tried to get because Mr. Paschel she couldn't do. I object.
All right, your objection be noted. We're jury out. I'll see where she's going with this.
Are you aware that a phone number was provided by Mr. Paschel that was supposed to be yours but was not?
Yes.
And were you actually contacted by that attorney because they had been given the wrong information eventually?
Yes.
That's hearsay.
didn't ask what she was told or anything. I just asked her.
That entails a hearsay response, so it's the same.
Did you ever ask Mr. Paschel to provide his civil attorney with a false phone number for you?
No, I told him to give the correct phone number, and I was happy to talk to the attorney because at that point we were on fine terms.
And as far as these text messages, you've heard that.
Don't throw
some of
anything
them
at your TV.
report to say that you're going to do everything in your power to lose his children. Did you hear that portion of it?
I did hear that.
Have you been subpoenaed in Mr. Paschel's custody cases by Mr. Paschel?
Yes.
So Mr. Paschel actually has been the one to try and drag you into his own custody case. Is that correct?
Yes,
And you do not have any children with Mr. Paschel.
I do not.
Have you maintained contact with any of his children?
No.
And let me see the messages themselves. Marked.
She is calm, baby.
Mark those by David.
Hey, I think they were 61. Do you have those, Mr. Isaacs?
I think the judge is
Do you
being
have the,
fair, Coach.
text exhibit for ID?
Yeah, he does. I do.
Thank you, Sharon.
So I'm going to show you.
Mine has the year, month, and date. I'm gonna show you guys after this.
The 61 for ID only, these are those text messages that we just
I have a
talked about.
Samsung.
Did you send those text messages to Geoffrey Paschel?
No. No, I did not.
Have you contacted him in any way, shape, or form after June 9th, 2019?
No, I have not.
Have you had anybody else contact him on your behalf?
No.
Have you,
Amanda, I just put the link underneath your, if you want to join, the link is there, sweetie.
have you had any contact from Mr. Paschel?
If you have an
He drove by
iPhone,
my
I think
house
you
and
want to
dropped
do
something
something
off
else.
once, but we had no contact. No,
Okay.
we didn't talk.
And so it is your sworn testimony here today, you did not send these text messages.
Correct.
You provided your phone for a forensic download so that the parties could look for these text messages. Is that
Yes,
correct?
I did. Mhm.
You agreed to have your phone records subpoenaed, is that correct?
Yes, I did.
You agreed to have your iCloud subpoenaed, is that correct?
Yes, I did.
You made no objection when we asked you for those things.
Correct. I did it willingly.
Cross?
Good morning, Ms. Chapman. State of Tennessee set out and they told you they were going to prove that these text message screenshots were fabricated, correct? That's what this lawyer told you, correct?
Judge, I would object to that.
You can ask the question.
Are you talking about the forensic download?
Yes.
They asked if they could have my phone to forensically download to see if the messages were in fact sent from my phone.
Well, there was a lot of information, a lot of things were sent, a lot of subpoenas were issued, correct?
I don't know how many subpoenas were issued
Subpoenas were issued, correct?
to Verizon and Apple. Yes.
Right. And actually, the case was continued to determine whether there was a determination whether these were false, correct?
They were trying to prove that those are false. Yes.
And the truth of the matter is, after the subpoenas, after the records, after all the forensic analysis, no one could prove anything other than what Mr. Paschel says is these came from you, correct?
Those messages did not come from me.
Where's the forensic information from the subpoenas to show anything other than an exercise in futility?
I'm not sure.
She wouldn't know that. That'll be the prosecution.
Thank you.
Just argument.
Rebuttal proof of defense.
There you
The defense is the preponderance of the evidence, so I'll allow them to argue their theory of admissibility.
This is very simple and straightforward. The texts have been identified, authenticated by Mr. Paschel. as
He's a
accurate.
liar.
I think when the state, you can tell, put these texts under a Hubble microscope, everybody offered to do everything they can to make sure there was no ambiguity or no inappropriate inferences. And what we're left with this morning from the state is testimony with an oblique reference in a custody hearing that happened in May before this criminal case even occurred. I mean, it's pretty simple. Taking a screenshot of your phone and your text is common. Mr. Paschel in Rhodes said these were received.
And he's lying.
Like a text
Well, I don't know if
message
he's
that would
lying.
be received, they are dated. If the state would look, there are years, and then after the same date text, some don't have years, which is consistent. We cooperated with the state when they did the forensic analysis, and we're here. And this Kristen Wilson Chapman says it didn't happen, because if she did, then obviously there would be significant implications that would involve a Class D felony. So, you know, there's bias and motivation on both sides. So, you know, the state's trying to say that they can't be authenticated. They have been authenticated. I think what the state can do is they can, in rebuttal, call whomever they want to attack these records if they want to. But I don't, the court asked us to bring this up, and this was prior to the forensic analysis. I don't see any legal basis whatsoever to exclude these.
Well, Judge, I think Mr. Isaacs hits on a good point there. As the court is aware, we have subpoenaed just about every record we possibly could with regards to Ms. Wilson's phone. And amazingly, these text messages were not found within any of those records either. Well, okay, Judge, I apologize. I can tell the court now that these messages, which were not provided to the state until over a year after the first one was sent, some of them do not even have dates. Some of them are in no way, shape, or form relevant to this case. And quite frankly, Judge, if these text messages come in where he is talking about this custody battle, then I do believe that the state then should be allowed to ask him specifically about these statements that he's made in these custody battles, where he reports that he does not know Ms. Wilson, that he doesn't keep text messages with her, things like that. I don't believe they're relevant on a number of reasons. For a number of reasons, she never references the specific criminal case at all in the text messages. Again, these are just screenshots with the name Kristen. There's nothing to say what phone number they came from. Again, some of them don't even have years on them. And text messages and screenshots can be deleted. And so I do not believe that the defense has met the burden of authenticating these records, and we would ask the court to leave them out. But if the court does allow them in, I would just like some guidance on my cross-examination as far as his all these civil depositions and stuff that we have, where he makes completely contradictory statements, one about his relationship with Ms. Wilson, and among many other things. So.
Thank you.
He just testified, Amanda. You're going to have to rewind. He just testified.
The standard is pretty low, and it's basically, is there evidence in the record to support a
Why
finding
does he
on
have them
prior
white
fact
socks? What?
that the evidence is what the proponent of the evidence says that it is. And one of the ways that you can authenticate evidence is by calling a witness to say, this is what the evidence is. Will there be questions as to how much weight the jury gives this testimony? Perhaps. It sounds like the state's going to cross-examine the defendant on the underlying credibility of this, and there might be other proof related.
No, he
to that.
testified today, Amanda, this
But
morning.
I think the only question before me is the very low threshold bar of admissibility, and I think that that has been crossed in this instance. That doesn't answer the entire question, because the evidence would still have to be relevant and otherwise admissible. I do think that the statements that I see here could be offered, again, if they're accredited by the jury. And I want to make very clear, by making this ruling, I'm not saying that the jury should or should not accredit this evidence. That's entirely within their province.
Yep.
But I do think that if it is accredited, it could be viewed as potential bias of the complaining witness, and therefore offer for a non-hearsay purpose. So for those reasons, I do believe, after hearing this proffer, that Exhibit 61 will be admissible should Mr. Paschel decide to testify in the case. Anything else we need to take up before moment?
No, Your Honor.
All right, Mr. Paschel, sir, you're still under oath. Mr. Isaacs is going to have a discussion with you here on the record about your decision to testify. Okay, sir?
Mr. Paschel, I've explained to you your constitutional rights as it relates to this trial, correct? And you know there are a number of fundamental constitutional rights that you have.
He was just on the stand a few minutes
You
ago.
have the right to compulsory process, correct? You have the right to a jury of your peers, correct? I've explained to you that you have the absolute right from presumption of innocence, correct? I've explained to you that the state of Tennessee must prove each and every element of each and every offense beyond a reasonable doubt, correct? I've also explained to you under the 5th and 6th Amendment, you never have to prove.
Okay, he testified about the text messages.
And you understand that if you choose not to testify in this trial, that the judge will instruct the jury not to create any inference that's negative, of guilt, etc., if you choose not to testify. Do you understand that? Have I adequately and effectively explained to you your constitutional rights as it relates to whether we should put on a defense in your case? Have we met and discussed those things strategically?
Hello?
Have we met yesterday?
We did.
Have we met this morning?
We did.
After hearing the proof in this case and reviewing the proof and the evidence in this case and listening to mine and Mr. Ammon's explanation of your fundamental constitutional rights, you understand that you have the right not to testify, correct?
I do.
You understand you have the right to testify.
I do.
Would you tell Judge Hickson what your decision is?
I wish to testify.
Okay, thank you, Mr. Paschel. Let me ask you just a few follow-up questions. You can have a seat if you'd like. Mr. Paschel, you do understand, you talk with your attorneys about this, you can take their advice, you can talk with your friends and family, but you do understand at the end of the day that this is your decision and your decision alone. Do you understand that? And this is your decision that you're making to testify in this case?
Yes.
Did part of the discussions you had with your attorneys deal with the advantages and disadvantages of you taking the stand?
That's correct.
Specifically, of course, an advantage would be that you could tell the jury your side of the story. You understand that, of course. There are also other aspects, however, certain disadvantages to testifying. Are you aware if you testify, you'll be cross-examined by the prosecution? And are you also aware that depending on what your testimony is during your direct examination, it could potentially expand the scope of things that they're allowed to ask you on cross-examination? Do you understand that? Specifically, yesterday afternoon, we had a discussion about certain prior criminal convictions that you had on the record. You understand, as it stands now, the jury will not hear about those criminal convictions. Do you understand that?
Yes, sir.
You understand that if you said certain things during your direct examination, there's a potential that it could open the door for the jury hearing about those things. Do you understand that?
Yes, sir.
You also understand that if you said certain things about the alleged victim in this case, particularly her character, that could also open the door to certain aspects of your past and your character. Do you understand that, Mr. Paschel?
I understand that.
Okay. And is it still your decision to testify in this case?
It is.
All right, very well. Anything else we need to take up before we bring the jury?
No, Your Honor.
I think so.
All right, let's get them lined up.
Okay, you heard it. Judge is going to allow those text messages in, and the defendant will be taking the stand. Philip Dubé, your thoughts? Did the judge get it right?
Absolutely, he did. The client can always authenticate his own text on his phone. I think what a lot of people don't know is most cell phone carriers, and it's because of what I do. I can't tell you how often digital
Yep, they did
evidence
offer him
is
a deal,
introduced
and he
at,
refused.
jury trials. But most cell phone carriers do not store and maintain the contents of text messages beyond 30 to 90 days. They just
True.
don't have the cloud storage space, if you will, to maintain all of that data cost effectively. So it gets purged. And it's no wonder that if a year later you're issuing a subpoena for this stuff, that they tell you they don't have it or that it doesn't exist, because it doesn't. They just purge it automatically. And as
No,
as
I
a
thought they
second
offered
point,
him 5
very,
years.
very rarely,
With
at least
2
in
served and 3
California, see a
suspended.
judge take a testimonial waiver from the defendant before deciding whether or not to testify, unless he chooses not to. You only go through all these machinations and advisement if he's choosing not to, so there's no allegation later on appeal or convicted that he was never given the opportunity to testify and he chose not to. But here, it seems like they're just warning him of the pitfalls to testify, and he's acceded to all those. So we'll see what happens. It's exciting.
But he's already
Concerning
testified
events,
about the
this
text
morning,
messages.
Here in Tennessee.
What about the
Would
bruises
you, if you're
and the battering?
prosecuting, which I know you don't do,
That's okay.
bring the victim back in a rebuttal case and have her get up there and say, I did not send these texts?
She did.
100% I would. Absolutely. But she's going to look like a liar, quite frankly. She's going to testify to that.
More than him? You don't think he looks like a liar? Possibly?
No, because, he's producing something tangible. And by the way, just because he has those texts doesn't necessarily mean he's exonerated from domestic violence. All it really shows is that, she might still have an axe to grind. She was very upset, but you can still be abused and upset. The two are not.
You need to get off my screen because I'm going to throw something at
coextensive,
you.
if you will. So I don't know. It could also backfire. But he comes off very charming. I think he'll do well on the stand.
Oh my
He's
God.
lucky that his priors were excluded. And we'll see what happens.
The
On
priors
another
were
note,
excluded.
this
Oh, we're in
needs to go
trouble.
back to her law school and ask for a refund because they didn't get the job done in teaching her how to lay a foundation. She doesn't know how to cross-examine a witness on authentication and foundation. And that's a big issue because, as you can see, our rules of evidence take on a life of their own when it comes to introducing this type of evidence at a criminal trial. And it looked like she was a fish out of water.
There was definitely some heavy frustration. Judge is back on the bench. The jury has entered the courtroom. Here we go. The defendant about to take the stand in his own defense.
Don't smile, Judge. Don't smile.
They working? Okay, good. You can't. Can you hear? Nothing.
No, I can't hear you. Too
Okay.
low. There you go.
Yeah, make sure it's powered on. Ms. Fasala, could you come in here if you're next to your computer, please? How's this?
Yep, she didn't do a good job cross-examining. She
Okay.
was getting frustrated
my
with
assistant
Geoffrey,
in here, and
and
she
she let
can
him throw her
help me.
game off.
My assistant's gonna come in and make sure it's working, okay? All right.
Oh my God, he does.
All right, little technical glitch there. Not sure exactly what happened. It appears though a
Look at
juror
that
had
smug-
a question.
Look at him. You know who he looks
And,
like, don't
you
you?
heard the
What's
judge's
the guy?
assistant is going to come
Oh,
in
what's
to
the
deal
actor's
with
name?
said issue.
Look at
Providing
him,
a
little
little bit more of a
smug
delay.
prick.
Philip, as we're here,
At least he
all
got a
parties
different shirt
have
on
to
today.
be, especially the defendant, have some butterflies right now.
Oh, yeah. Are you kidding?
Yes,
His
he was
life is on the
convicted.
line.
He served
I'm not
time in
exactly
prison
sure what these charges
on a
carry,
drug
but
charges and
because
a
we're
firearm
in,
charges.
felony land, he's looking at hard time for this. If
30
the jury
years.
believes that he in fact inflicted these injuries the way she characterized them, he's going away. I mean, he's going to crash and burn, quite frankly.
I can't
On
think
the
of the
other hand,
actor's
if
name
this
right
attorney
now.
can
I gotta.
get in a lesser included misdemeanor charge of domestic battery.
Not Charlie
based on
Sheen.
the
Robert
quantum of
Wagner.
evidence
Thank you.
conformed to the
Robert
proof,
Wagner.
That would be a
That's
tremendous
who he
defense
reminds me of.
victory. Anytime in felony land.
Little bit of
you
Hugh
can
Jackman,
find
too.
misdemeanor.
Cut you off, Philip. Judge talking. Let's go back in.
But sometimes trials are just fluid things. There are a lot of moving parts, and we had some things that we had to take care of out of your presence that came up unexpectedly. And please don't hold that against the parties. Hold that against me. That was my fault. Okay. So we are trying to be as respectful of your time as possible. I'm just very sorry that.
Can we just get
got a
this
later
case over
start
with,
than we
please?
intended to today. We are ready to go. However, the state rested its case in chief at the end of the day yesterday. And at this point, if the defense chooses to, they are allowed to put on proof. So at this time, I recognize the defense for proof. Mr. Isaacs.
Morning, Your Honor.
Morning.
At this point in time, the state calls Mr. Geoffrey Paschel.
Are they repeating what we've already seen? No, it's 11:13.
Sir, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Oh, his mask is off this time.
All right,
Thank
Mr.
you.
Paschel, make sure the microphone is pulled towards you so that the jury can hear you. State your name for the jury.
My name is Geoffrey Paschel.
And can you give the jury a brief rundown of your educational history?
Who cares?
Yes,
I'm an
attended
abuser.
Mississippi Community College, received an associate's degree. I then went to University of Tennessee and received an ecology and evolutionary biology degree. And then I attended some graduate
Yeah,
classes
he's
and
short.
received a
Napoleon syndrome.
communication studies graduate degree.
And can you tell us a little bit about where you grew up and about your family?
I grew up here in East Tennessee. I went to William
Thank
High
you.
School
Who gives a F?
and lived here pretty much all my life.
And you have
Abusing
children?
women.
I do. I have some wonderful kids.
Tell us their names and their ages.
Paxton, my oldest, he just got married here in May, expecting a baby. She's around 2.5 months pregnant
Who
with
cares?
his wife. Dakota, absolutely wonderful child. Couldn't be prouder. He goes to MTSU. He's in vocal performance. I have some young children that Caven, absolutely
It doesn't
awesome
matter.
child. And Crusoe
No, he's
is a
not.
wonderful child as well.
He's a prick.
Just great children. I could be prouder of my kids, to be honest with you.
And can you tell the jury a little bit about your employment history and background?
Yes, when I graduated high school, I tried to do the factory setting, and I didn't like that too much. I worked at Denso for a little while. I then started going to college and went through college and actually moved into construction and remodeling houses and
stealing
houses.
lighting from Home Depot.
I enjoy it. It's fun. I'm my own boss and make my own time, and you actually stand
Got
back. and
time to
look at
beat
the
up
work,
on
you're actually
women?
Proud of it, you know.
He's 5'9",
All right, you've been
supposedly.
sitting
Yeah,
here
right.
during the course of this trial. Tell the jury when you met and how you know Kristen Wilson Chapman.
I met Miss Wilson Chapman around December of 2017,
He's 41 years old.
and we pretty much hit it off pretty quickly, and we started dating, enjoying each other.
And so you met Miss Wilson Chapman in 2017. You began dating. Did the relationship progress?
It did.
Hi, Kelly.
We were light at first, but you know, our
Yeah,
emotions
that's
took
ex
over
Home
and
Depot.
We hit it off pretty quickly, and we pretty much were inseparable at that time. After that,
With a
And
fire
would you
on.
describe to the jury kind of the interpersonal dynamics of the relationship with you and Kristen?
I mean, we had wonderful communication. She's educated as well. She's nice to talk to. We had the same interests and
Thank you,
hobbies.
Queen. I'm gonna go look
She
at
likes
it.
to go hiking. I enjoy the outdoors, so we've gone hiking many times. She likes to travel. We've traveled multiple times. We've camped, yard work, gardening. I mean, just
Oh
the list
Lord,
goes
we had a
on.
wonderful
She has her own
relationship
house,
until
and
she
I'm
beat
good at
herself up
handyman
as she
things,
was
so
going out the door.
I did everything I could in her house to, you know, fix stuff that was broken or that would potentially go broken or stuff like that.
Oh God.
And did your relationship progress and become more serious and intimate as time passed?
It did. We progressed from, friends to girlfriend, boyfriend, and onwards up to engagement.
Now,
Oh my God.
You mentioned engagement. We've been talking
It's
a
not
lot
funny,
about
I'm
June
sorry.
9, 2019. Let me kind of rewind using that as the focal point to March. You mentioned you were engaged, so explain how that relationship dynamic changed that led you and Kristen to become engaged.
We really enjoyed each other, and it seemed like she was a good life partner for me, and I was a good life partner for her.
Oh
We had
God.
the same interests, like I said, the same hobbies. We
Did
ate
she
a little
do drug
differently,
dealing too?
but that
Did
just
she
was a
steal
quirk in
from
the
Home
relationship.
Depot?
It was funny. It was cute. Stuff like that. There's
Is she
just small
banned from
nuances
Canada?
that made it a great relationship.
Did you propose to her? Did she propose to you?
I proposed to her.
Now, fast forward to June 9th of 2019. Can you tell us what the state of the relationship was with yourself and Miss Wilson Chapman at that point in time?
At that point in time, our relationship was a little off. In any relationship, you have your ups and you have your downs. At that time, I believe that we're
Yep, he was on
kind of
ID
apart at that time.
on the ID channel.
But
No more.
we both had hopes that we were going to progress and get things back on track.
Now, when you say we were apart at that time, did you all maintain separate residences or did you cohabitate?
We stayed the night at each other's houses. I mean, I had my own residence. I had my own animals. She had her
Who
own
cares
residence.
what your
I had
animals?
my own, she had her own animal. So we just floated, back and forth.
And he was
to
a
each other's
cheater.
house,
He cheated.
when we were good.
All right, let me draw your attention specifically to Saturday night, June 9th, 2019. Walk the jury through what happened that day.
It was a normal Saturday. She had actually called up her brother's fiance, worked at a nice local
I've never
restaurant
slept in
called
a
the
Walmart
Brasserie.
parking lot, so I don't
She
know.
said, "Hey, we can go, have a meal. Katie, her name's Katie Meyer. Katie can serve us.
Happy
She works for
birthday.
us." Seemed like a great idea. So I got done with what I had to get done with at my house. I head up, went to her house. Got there around 5:30. She still needed a little time to get ready. So we left her house around 5:45-ish. Got to the Brasserie somewhere around 6 o'clock. And of course, Katie Meyer was there and she was our server.
All right, you get to the Brasserie around 6 p.m. on Saturday. Describe to the jury what type of establishment the Brasserie is.
I actually had never been there before. I believe she had been there on several occasions, but it's a higher class kind of bar restaurant. They put more emphasis, I would say, on the bar aspect. It's a really pretty place, a nice place, and I had never been there before prior to that.
He's
All
not
right,
going to
you're at
mention
the
Vario.
Brasserie, around 6 on a Saturday evening in Knoxville, Tennessee. Did you all enjoy cocktails?
We did. I mean, we went.
I'll
And
be
the
a
first
drug
thing Katie
runner.
did was already had a drink for her. Of course, they're familiar with each other. I had met her a couple times prior, so she gave her a drink, and I was like, I want a drink, and she ended up bringing a drink to me as well, and it was fun. So we enjoyed some drinks.
Did you all eat dinner?
I did. I ordered burgers.
I think he's guilty.
Which is not something I normally eat, but just felt like let myself go a little bit and having a good time with her.
Did Miss Wilson Chapman order a dinner as well?
She did not. No, she. I believe she had some shrimp or something, but she nibbled on some of my French fries as well.
All right, so walk us through. You're there. You're enjoying cocktails. You're eating an entree. How did the conversation go at the brasserie?
It was great. It was a lighthearted conversation. Katie came a lot and sat down and chatted with us. There were other people around that we spoke to. Random people, nobody that we knew per se.
Oh,
we just
because
had a good
I'm
time,
on
very
TV,
lighthearted
so
and
everybody had to come
it just
speak to me.
flowed well.
Now you're there. You have an entree. Did you all continue to order cocktails as the conversation continued throughout the evening?
She said
We
she
did.
had 3 glasses of
It was
champagne,
pretty free flowing,
which is
I mean,
served in a
she just-
flute.
She would just bring them. Being her friend or her brother's fiance.
Oh my
I
God.
don't know what that relationship's called, but brother's fiance. She kept just bringing us drinks.
How did you all
She was
travel
driving
to
Geoffrey,
the brasserie?
re-victimizing this
arrived at
woman
her
all
house.
over again.
We ended up driving her car, so I drove her car to the brasserie.
All right.
No, Katie didn't testify yesterday.
You described the drinks as free flowing. How long did you all continue to share your entree and enjoy the cocktails?
I mean, once the entree came, I ate it pretty quickly, but we were there roughly about 5 hours at the restaurant, and
Miss
a lot of it
Amanda.
was talking, and I mean, we weren't gulping drinks down one after another, but we were just enjoying ourselves and having a lighthearted time.
But you were drinking, or were you drinking consistently for 5 hours? When I say you, both Miss Wilson Chapman and yourself.
Oh yeah, we were, both of them.
So you had a number of alcoholic beverages, correct?
Oh my God.
And
I want to shoot.
that was
well, I can't say
continuous
that.
for this period of approximately 5 hours, correct?
I want to have a private
And were
conversation
you
with that
both
attorney.
drinking at
How's that?
approximately the same pace?
We were, yes.
And do you recall what Miss Wilson Chapman was drinking that evening?
Yeah, she had a number of things actually. She had champagne. She went to martini, and then her favorite is actually Tito's and soda water. So she had several Tito's and soda water.
And what were you drinking on this occasion, Mr. Paschel?
I had beer to begin with, and then moved over to 2 beers to begin with, then moved over to Jack and Coke.
He was drinking double whiskeys.
Now, during this
He's changed his
stay
testimony.
at the brasserie, how would you characterize the conversation?
It was great. It was lighthearted. It was like it was. Our conversation was like
No,
the drinks.
she
It was
drove
just
home.
free-flowing.
She
We had a good
drove.
time. We enjoyed each other.
Any argument?
No.
All right. What time did you and Miss Wilson Chapman decide to leave?
I believe the restaurant closed at 11, so I think that's why we kind of ushered ourselves out there, or we were probably ushered out. So we left around 11 p.m.
And who drove to Miss Wilson's residence?
She did at that time. I didn't think it was a good idea for either of us to drive, but
Oh my
she
God.
insisted, so I kind of relinquished.
And how far is the Brasserie Bar and Grill from Miss Wilson Chapman's residence?
It's not very far. I want to say 3 miles, so 5 minutes max.
What happened when you arrived at the house?
She had mentioned going to another place, which I was fine with. The other place was probably less than that, so maybe really 3/4 of a mile away or a mile away from a house. So she needed to get ready, spruce herself up. I ended up walking her dog, and
Oh, you walked the dog.
that's when it all began.
Okay.
And up to this point,
Oh my
11
God.
o'clock, you're walking the dog, getting ready to go, have more drinks. How would you characterize the evening up until that point in time?
Everything is great. There are no qualms, no issues, no problems.
All right. What happened
He
next?
said he walked the
I
dog.
walked the dog. Like I said, she was getting ready. And
I hope they got video footage
the
of
way
her
that
walking
her-
that damn dog.
Her neighborhood is set up. Her house is on a hill, but if you go up and over the hill, you can go down and there's a cul-de-sac. And so that was the dog walking area. So we'd walk and, you know, let her go to the bathroom and then come back up. And we've done this countless times before. And as I crested the hill, I called, like, as I said before, I have animals. So I called my son to check on my animals, and which, you know, everything was fine.
God.
Got off the phone with him. He said he'd make sure everything, you know, because my dogs have a habit of trying to escape the gate. They've gotten really good at it, actually, where they can open it and slide through. So that was always an issue.
Yeah, you sat there for 5 hours.
So I talked to him. He
So
said he would
now
take
you
care of
called
it.
your
I
son,
went to,
but she said she called her
carried
friend
on
to say they
and
were
came
on
to
the way.
house where she
Oh my
was.
God.
What happened next?
She was apparently watching me talking on the phone. And
Oh my
it was at that time it
God.
went from 0 to 100. It went from everything
said,
was
she
absolutely
said.
great, everything was absolutely fine, to I'm communicating with another female.
Oh my God.
Can you describe to the jury Miss Wilson Chapman's demeanor when you entered the house from talking on the phone and walking the dog?
It was very aggressive, very loud, very accusatory. That was her demeanor. in my
He
opinion.
said, she
So
said.
things changed dramatically.
They did.
What happened next?
She dragged
I walked
herself down
in,
the stairs, beat herself up against the wall.
And then she tore into me. And at that time she was loud. She was getting in my face. You know, I'd slowly push her back.
Slowly pushed her
get in my
back.
personal space, in a personal space. Scratch and slap. I mean, she was doing things to me aggressively, but I don't think it was an attempt to be aggressive. I think she was upset, you know, thinking that I was actually talking to another female
Oh my
out
God.
there. And I guess we both had hopes
Yes.
that our relationship was going to progress.
He was
from that
talking to
night, since we
Varia,
were on the
engaged
outs
to her,
already.
and still married to his wife.
Did
Really?
the arguing and physical contact escalate?
The arguing escalated. The physical contact really didn't, in a sense that, you know, I kept pushing her away. It was the argument where, you know, kind of enough is enough. I don't want to do this anymore.
Oh my God.
I'm gonna go home.
So why did you
At that
leave,
point,
Geoffrey? You were in there with no shirt on when the cops
you
came.
know, prior to that, you know, she was screaming and carrying on throughout the house.
But the neighbors
at
didn't
that
hear her
point,
screaming and
I went
carrying
to go
on throughout
leave.
the house,
She
right?
attempted to grab
Got you.
my keys. Well, she did grab my keys and tried to bolt out the door. And as she went to bolt out the door, this being a door, the door opened, she ran smack.
Oh
into the
my
door,
God. What
side
about
of
her
the door,
neck? What about her
as
foot?
she walked out,
What
as
about
she
her
ran out.
legs? What about her
So
hands?
she grabbed my keys and turned and hit the door, the open door.
I'm
And
pissed.
she tumbled out
I'm
of the
gonna mute
house.
myself.
The way that her house is set up there's a sidewalk, and there's hedges on the other side of that. So 3 foot over is hedges that carry on down the sidewalk.
Yes, he
So
was
she
talking to
tumbled
Varia
out the
at
door
that
and
time,
went over the
engaged to
hedges
her
and
and
was
still
in the middle of
married
the
to his
yard.
ex-wife. Thank you, Queen,
still
for putting that up because I forgot
screaming,
about that.
basically. As that time I walked around the sidewalk and the hedges, and
I don't have PTSD,
told her,
but
I
it's
said,
triggering the
"Please
hell out of me
get in the
too.
house. You know, this is too loud for out here. This is too much. You know, please come in.
No
everything will be
neighbors
okay.
heard none
Let's,
of
you know,
this.
talk about
right?
this inside.
Okay.
I don't want to involve the neighbors. And granted, this is 11 something at night.
Oh my God.
In the middle of a neighborhood, in the middle of her front yard. So she ended up coming in the house.
Her neighbor testified
and
yesterday. She was there. She was
I
banging
said,
on the
"Hey,
door.
let's get
She
some
let
water."
her in. She was asleep. You
Can-
making all
at
that
this
noise
point in
out
time,
front,
Mr.
they're going to
Paschel,
hear
Can
you.
you
I'm sorry, guys.
describe her physical appearance?
This time she had a red mark. There wasn't a knot on her head yet at that point. But it was a hard hit. I mean, you can tell that something was going to happen. But she had some blood coming out of her nose. And at that time, that's all I saw. I didn't see anything with her lip at that time.
So how did her sofa get
happened next?
overturned? How did the blood get on
she
the
made
light
it-
fixtures?
she
How did the
came
blood
back
get on
in,
the stairs? On the
willingly
floor in the
and
kitchen?
I said, "You need to get some water. Let's calm down. Let's just calm the situation down." We went to the kitchen and we got some water. We actually both drank some water. And I was like, let's have a little more, let's have a little more. So I tried to involve myself in it. and pretty much everything had calmed down. I said, you know,
Yes,
get
the
you
neighbor
cleaned
was
up.
there when the jury,
Are
when the
you
neighbor
feeling okay?
testified yesterday.
How are
The
you?
jury
How
was
bad are
there
you
when the neighbor
hurt, kind of thing.
testified yesterday.
And she said, just leave me alone. She wasn't in a good mood, but she wasn't yelling anymore. So she went.
Thank you.
She
I've
used
hit
the
myself
bathroom,
and walked into the door.
she
That
walked
never
herself
happened
up,
to me. Eyes
and,
black on both sides. Shut up, Geoffrey.
Pretty much went to bed after that.
All right. And you went to bed. At the time that yourself and Miss Wilson Chapman arrived home, can you tell the jury what your opinion was on your respective sobriety?
We were both drinking. The term drunk. I mean, we're drunk. We're drunk.
Even a cop said she was
So
upset.
when you go to bed,
Her
in
blood
your
was tested when
mind,
she went to Geoffrey. Shut up.
What did you think?
Mind that, you know, she's calmed down, that she's gonna wake up, you know, and everything's gonna be fine.
What happened next?
I was lying next to her, and she got up, started walking to
Hi,
the door,
Gina.
her door of her bedroom, and I said, Kristen, what are you doing? Where are you going? And she walked to the front door, and I walked behind her, and she walked out of the house and started walking down the road. And I said, I stood at the door, opened the door, and I stood at the door. I said, Kristen, what are you doing? She goes, I'm calling the cops. Just get out of here. And I said, this is what I was going to do to begin with. And so I
Liar.
just
You
chalked
said
it
you
up
went
that
to
she was
bed. Oh my
drunk
God.
and was going to walk it off and walk back. And
But when you got there, the house was dark. You had no shirt on, and you looked
And
like you
in
had
the
just
interim,
woke up.
what did you do?
Shut up,
Did you
Geoffrey.
leave the house? Did you stay there?
there was no reason for me to leave. I stayed there.
She said she was calling the
I hadn't
cops.
done
Wouldn't
anything
you
wrong at
leave?
that point.
If that's what she told you, I would
Did
leave.
police arrive approximately how long after she exited the house?
I want to say roughly 30 minutes.
And you saw excerpts of a body cam footage from the officers. Do you recall them responding to the residents?
I did.
And it appeared that you were lying down or asleep. Where were you when they arrived?
I was just lying in the bed. I was awake, just lying in the bed.
And when they asked you what happened, you recall you didn't hesitate. You pointed to a place on the wall. Tell the jury what you were doing.
It was pointing on the wall where she had ran into the wall. I mean, she was.
I thought she ran into the door.
And
Was it
she
the wall or was it the door?
Went into the house and.
The wall or the door,
turned on
Jeffrey?
light
Let's get it
switches,
straight.
did
The
that,
wall
all
or
that
the
stuff
door?
happened. That's the truth. So she bounced around the wall. That was one part of the wall where she come down the stairs and I bumped into.
Oh my God. And
Now,
you didn't do anything. Oh my God.
You heard
I'm
Ms.
done.
Wilson Chapman testify about an elaborate process about you having your phone and somehow being able to dismantle the screen.
It was all kind of
and
shit
then
that
putting
did
it
that
in
to
the
her.
phone and UV port and putting it in a computer, and for over an hour or so, deleting, downloading, etc. Tell the jury, did that happen?
Absolutely not. Absolutely not.
Okay.
No.
Got you, Jeffrey.
And did you delete references to yourself?
Never. No, I didn't. I didn't have a password to get into her phone. That was one thing that she changed pretty frequently. I
And
couldn't even get in.
when Ms. Chapman was testifying,
Thank you,
and
Mod
she told me that she had
148.
pictures of you all
Thank
at
you.
dinner. If you'd have deleted her phone, those wouldn't be there, I assume.
That's correct.
Did you ever see the condition of her phone that night?
I did.
And tell the jury about that.
When she had tumbled out the door.
Tumbled out the
her phone
door.
was there. I had picked it up. I brought it in. The screen had popped off. It wasn't broken. It wasn't cracked. It wasn't anything. It just popped away a little bit. And basically, I pushed it back in.
May I approach? Well, first, let me preface this by saying, after
Ooh, I
June
hope they get a
9th,
different prosecutor
did you
up
have
there and question her.
any contact with Miss Wilson Chapman?
She attempted to contact me multiple times.
Did you ever contact her?
No, never.
May I approach?
Let me find this picture real quick. Let me see how that wall did her. Disgusting liar.
Mr. Paschel, let me show you what has been marked as Exhibit 61. Ask you to review that exhibit, and if you can identify it for the record.
These are text messages between Kristen and myself.
Your Honor, may we at this time utilize the overhead? If we could, Mr. Ammons, if you could. And if we could dim the lights just a bit, Mr. Bailiff. All right. Describe to the jury, Mr. Paschel, what we're looking at on page 1 of Exhibit 61.
This is a text messages between her and myself. And at the very top is actually a website concerning a squirrel. A squirrel had
Damn
fallen
squirrels
at
again.
my house out of a tree, and it was just a baby, and I tried to nurture it back to health.
Let me show you this picture
and
real
so
quick.
she had sent me this concerning making sure that it gets the proper nutrients.
And under the icon for metabolic bone disease, squirrels, can you read into the record the date?
It's June 9th, 2019, at 7:18 p.m.
All right, and did that text that you received, did you receive the text on the metabolic?
Oh, Kelly, thank you for the Cash App, baby.
Ms.
Thank
Wilson
you.
Chapman?
I did.
When was that received?
That was probably 2 to 3 days prior to June 9th.
Then under that text message, there are 2 dated June 9th and June 13th with some emojis. Can you tell the jury who they are from?
That's Kristen Wilson Chapman, and that's how she was programmed into my phone. Kristen with a
Thank you, Teresa.
heart face
Thank
and
you
then
for the
heart
super
eyes and then a
sticker.
little family emoji.
And the one on the night we're talking
I don't
about
believe
is
him at all.
7/18, it said she stopped sharing location with you.
Yes.
Is that
As of a few months ago, him and Vari
That-
was still
that's
together.
correct.
I don't know, but now.
Also, at 8:36, same message, correct?
That's correct.
Now, the next message is dated September 13, 2019 at 10:21 in the morning. Can you read to the jury what that text message says?
Hi, happy belated birthday. It's been so long. I really missed you.
And who is that text message from?
That was Miss Kristen Wilson Chapman.
And when was your birthday, Mr. Paschel?
It was actually the day prior, September 12th.
Who cares?
All right, 6 days later, September 18, 2019 at 1:23
That's what the
p.m.
wall or the door did
Can
to
you
her.
read the next
That's
text
what-
into the record?
That's what
I
happened
really
to her.
feel
See
bad
that?
about everything, Jeffrey.
She
I
walked
think
into
things
a
have
wall.
just gone
or
too
door,
far, and I'm
or
too
whatever.
deep in. I'm not sure how to make things right with you. I had to get a new phone, BTW, by the way.
And who is that text message from?
Miss Kristen Wilson Chapman.
The next text message is dated September 19, 2019. Can you read that text message into the record?
Was really looking forward to seeing you today.
And if we could go to the next page. And who is that text message from?
Thank you, Teresa,
Miss
for the
Kristen
super
Wilson
sticker.
Chapman.
And can you put that message in context for the jury?
We actually had a court that day.
Yep, let's
a
just
court
see this
hearing that
again.
day that
There we go.
was canceled. And so I wasn't in court and she wasn't in court.
Side
so
view.
she didn't. we
Bruises
didn't
all
see
on
each
her
other.
face. Look at this woman. Look at this. Look
Two
at her.
days later,
Look her
September
nose.
29,
Look at that. Look at the
2019,
swollen. Look at that.
11:02 p.m. Can you read
Bastard.
to the jury those texts?
Hi, hey, sorry for the late text. I've been thinking a lot about you a lot. I feel like I'm just settling with everything.
Who is the text messages from?
That was Miss Kristen Wilson Chapman.
October 8th. Can you read that text message?
Really wish you wouldn't ignore me and an emoji with the crying.
Thursday, October 10th, 1:49 p.m. November 17th at 8:19 a.m.
You should have responded to me. This is your fault by acting like you're above me. I told you not to leave me. All you had to do was take care of me.
And
This is blown up, and now I can't stop it. In fact, I don't even want to now. I'll do everything I can for you to lose Caven.
and who are those series of text messages from?
They were all from Kristen Wilson Chapman.
Now, Mr. Paschel, as we're looking at these, I noticed that there's no response to you regarding these texts that are spanning the next few months.
That's correct.
Did you ever text back Ms. Wilson Chapman?
Absolutely not.
Why not?
Well, I believe with these text messages I was being set up. There was actually a
Is that
pending,
Shelby Bart? If it's Shelby
order of
Bart,
protection
yeah,
or restraining order.
that's
And,
true.
I was emphatically told, do not communicate with Ms. Wilson.
All right. December 22nd, read the next series of text messages.
And dating someone else.
Well, family and peace. It didn't have to be this way. You should have responded back to me. Good luck proving everything. BTW, by the way. Erase all the pics and texts, and I'll tell the truth.
And who is that series of text messages from?
Miss Kristen Wilson Chapman.
And in terms of placing it in context for the jury, when she says erase the pics and text, what type of pics do you know that she was referring to?
Objection, Judge.
Yep.
I'll withdraw the question.
Thank you. How would he know? Oh, I love these boots.
Now, Mr. Paschel, if we can turn the lights on, please. Can you describe to the jury how you were able to take pictures or screenshots of your iPhone? Just simply walk us through iPhone for Dummies and tell us how you did it.
I had at the time an iPhone that had the little home button and the power button, and all you do is you push the home button and the power button at the same time, and it takes whatever's on your screen, it records everything on your screen.
And do those screenshots of the text messages accurately reflect the content, the date, and time of text that you received from Ms. Kristen Wilson Chapman?
100%.
Your witness.
Can we approach?
No.
Guys, I was trying to find
Okay,
a picture
direct
of her
examination
foot.
of the defendant concluded. Philip Dubé, what do you think?
He's a very likable witness. He has a very tranquil demeanor. He's a success
I'll send him to
story.
you, crazy
He's
cat
very
mama.
relatable. The problem is there is no smooth segue or
We don't know for
transition
sure
from having
that
a
she
good
did
time to the
contact
sudden
him.
onset of
When they
aggression.
downloaded her
But having
stuff,
said
they
that,
couldn't
if the
prove
jury
one way or the
believes her
other if the
story-
messages
Yeah.
came from her.
Sorry, let's listen in. Let's
Sure,
here's the
sure,
break.
sure.
Okay. We're going to take a quick break. So pick up your thought, Philip. You know, a lot of people think the opposite. Our producer in the courtroom believes that the jury is not buying him, and at
Ooh.
least before the text messages came in, especially some male jurors.
How
were
did they see the
mad
jury?
dogging
Because
him,
they
according
haven't
to our
shown the
producer
jury
in
at
the courtroom.
all.
That may have changed after they heard the text messages. I don't know.
So someone
But
must be sitting in
pick
the
up where you left
courtroom.
off. The issue with his story is the you're saying the 0 to 100 scenario.
Yeah, I mean, they're having a lovely evening. They're at the cafe or this, bistro having a lovely dinner and drinks. They go home. I guess they're going to pick up where they left off, go out and get more drinks. And then all of a sudden, you have this abrupt transition from a lovely evening to this conduct involving physical aggression.
Mm-hmm.
The segue is weird. You would have to believe that she's some type of psychopathic drunk that all of a sudden, once the alcohol is absorbed in her system, she becomes a mad woman and gets physically aggressive. It's a very strange transition. On the other hand, on the stand, he doesn't lose his cool yet. He's very tranquil, very relatable.
Mm-hmm.
For purposes of proof beyond a reasonable doubt, if a jury believes them equally, it means he should be acquitted because the prosecution didn't meet their burden. If you believe them equally, 50-50, that's not proof beyond a reasonable doubt. So, we'll see what happens on cross.
Don't they also, if a jury is told two different stories and both are plausible and they need to go to the one that leads towards innocence?
Innocent, exactly. I mean, that's a standard jury instruction throughout this country. If the evidence is subject to two or more reasonable interpretations, one pointing to guilt and one pointing toward innocence, the jury is required to adopt the interpretation that points towards innocence and acquit the defendant. Because you should only have one interpretation. If the prosecution wants to prove its case, there should only be one final conclusion, and that's guilt. But if you really don't know, it could go either way. It means you have a reasonable doubt, and that doubt goes to the defendant. The tie goes to the defendant.
The frustration we saw with the prosecutor while the jury was not in the room during the proffer can't happen in front of the jury, obviously. What are you looking for here? What do you expect on this
Oh my
cross?
God.
Do you keep
Guys,
it short,
I just
knowing
got a
you're
message.
likely
Someone
gonna have
got
this
timed
rebuttal,
out. If you
for
get
the he
timed
said, she
out,
said
I'm sorry.
conclusion?
It's
Or do
Google
you keep
bot.
him
I
on there
have no
forever
control
and try
over
to
that.
stumble, get him frustrated?
Well, I think what I would do is try to get him frustrated, because at some point she's going to put him in a posture where he's going to end up blaming his lawyer for everything. Why is it all of a sudden now or a year later we're getting all these screenshots? So you want this jury to believe that you waited all this time, you gave them to your lawyer, that your lawyer suddenly a year into it turns it over? Okay. And that's typical. We have these situations oftentimes where the client is sort of losing and then they throw their own lawyer under the bus. And a jury might not take kindly to it because now you're putting your lawyer in evidence. It actually puts you in conflict with your own lawyer. But hopefully this lawyer, he's a solid stand-up guy, will know how to rehabilitate him and ask the proper questions on redirect.
Basically the state has to, in its questioning of the witness here, confront him, right? And say, isn't it true you fabricated these text messages? Just be very clear and see his reaction, because again, with their rebuttal witness, it's going to come down to who do you believe?
Yep.
Of course. And then I would also parade the photos of her injuries, and just, show them to him and put them on the Elmo, the overhead, so the jury can see her all blown up on the overhead screen as he's talking about it. And when you look at the injuries, they didn't just come out of the firmament, they obviously happened somehow. And I don't know, it might be a reach to suggest that these are all self-inflicted.
It's a reach.
If you think about it, Ted, how would you cause that type of contusion to your forehead?
Court TV.
Of all places, it's a weird place to have an injury. Most people, if they're going to, self-inflict a facial injury, it's going to be to the cheek, maybe to the chin, but to your forehead, as a practical matter, how would you even inflict it? Are you going to take an object and just slam it into your own head? It kind of doesn't make sense, and the jury might have a hard time believing that. Now, on the other hand, her injuries do not jive with what she said went down. The way she characterized that whole course of conduct, the way he was dragging her around
Both
by her hair,
eyes.
almost like a caveman, you would think she would be far more injured than how she presents in the photos. So a jury might think that maybe she was cuckoo and, as we say in the public defender world, cray-cray, and just fabricated this whole thing to take him down.
Well,
we don't know. We'll have to wait and see.
He just said under oath that she ran into the door, that the door was open, and they were going from 0 to 60. He comes back with the dog. She sees him on the phone and freaks out, and then runs and boom, hits her head on the door. This is a fascinating case. It's the ultimate he said, she said.
The foot. What happened to
It's
the
a very
foot? Looked like it was
plausible
fractured.
explanation. You know, listen,
How did
at
that
the end of
happen?
the
Did she
day,
hit the door
when
too?
somebody has injury,
What about the
the
bruises?
prosecution still has to prove causation. If there was a willful infliction of some type of traumatic injury like this, there still has to be a causal connection between the defendant and the injury. And if there was some supervening cause where she trips over her feet down the stairs or she runs into a door, you know, you don't blame the defendant for that.
Yes,
You know,
I will be
there's just like
saving it.
this causal break in that chain of causation that cannot redound to his detriment. Let's assume, you know, that's really how it happened. It's not necessarily self-inflicted. It all occurred accidentally during an argument. And to blame him for her own injuries where she just lost her footing or took a bad step or plowed into a door, it's not his fault.
The bottom line is one of these two individuals is lying through their teeth, and they did it under oath in front of this jury.
But that's
If
not
a
what happened, was
juror
it, Cassie?
If you have jurors that think, you know what, I don't trust that guy.
They
I
said
think
it was the
he's
size
right.
of a fist.
But now in closing, the defense gets up and says, here's the law.
Her
If these
back,
are
her
two
neck, everything.
viable
her foot,
stories, you have
her
to go
legs.
this way. Is that what we should expect from the defense? And isn't it kind of advantage defense when you have two competing stories that make sense?
Oh, of course. I hammer that instruction all the time in criminal cases, especially when you have a he said, she said situation. And by the way, Ted, in criminal trials, you know what my favorite number is?
I love
One.
my fire
The
stick
number
too.
one. You know why? Because we only need one juror to hold up this entire verdict. You don't necessarily have to convince 12. The law does not require that all jurors reach a unanimous verdict. They can each stand their ground. There's also a jury instruction where they are required and told that their verdict must be their own. You know, it's not a majority rule situation where you throw in the towel during deliberations just to get out of there and go home and call it a day. You have to give your meaningful input. You have to deliberate.
I want to know if he's an abuser
Otherwise,
too.
you
That's
end
what
up
I want to know,
convicting
because he seems to
innocent
have all
people.
the damn
And if you
answers,
have one or
and he
two who
seems to be
wanna hold
siding
out,
with
then so
Geoffrey,
be it. Let's
which
retry this.
is his right to do
How
that.
about the question that we all had before this proffer of, well, why didn't someone come in here from a phone company, and you already talked about, and basically legitimize these texts? How do you get that across to the jury now on cross-examination? Because right now jurors are thinking that. They're thinking, wow, these texts are real. This changes
And her foot.
everything.
You didn't
But
see
the
her
state
foot,
has to get
her
out that
legs,
they
her
think
arms.
Not only that these texts are made up by you, Mr. Liar defendant, but how do you then tell the jury, we tried to do it, but AT&T didn't help us with this? You know, we couldn't verify them. Is that in closing?
It is, but you have to be careful because remember, a foundation was already laid for the introduction of these texts outside the
Okay,
presence
here's
of
the thing,
jury,
Crazy Cat
where the
Mama.
court
There's no
found
proof that she
they
sent
were
those text
properly
messages.
authenticated
They
and a
can't
foundation was
prove it
laid.
or disprove
You
it.
know, there
And if
has
she
to be
sent
some
it, he was
evidence
still
then
her
in
abuser.
response to
She may
that,
be
showing
thinking
that
all
they were
kind of things.
fabricated, that they
So
were
there's a few
altered,
people
that they
in
were
here
just,
who've
in
gone
fact,
through
you
DV,
know, made
and
up. If you don't
one
have
woman
that
said she
evidence,
texted her
I
abuser
don't
all
even
the
think you should
time
be
as
allowed to
well.
argue it.
Dr.
So,
Ray, thank you for your expert opinion. Oh, pins and needles. We have
like your opinion,
cross-examination of
but
the defendant.
please.
Coming up next, we'll slip in a break here. You're watching Court TV, your front row seat to Justice Julie Grant's next. Stay with us.
Okay, are we back? Okay, come on. We'll be right back. Come on, guys. I mean, I'm looking at this. I know they're not at lunch yet. Why are they taking a break? I don't have time for this. So, guys, if someone wants to come up, I'm going to drop the link. You can come up and we can talk about this, but I'm just saying, they did the subpoena. They for Apple and I think forgot her company, Verizon. And they also said that cell phone companies don't store anything. Some of them past 90 days because they don't have enough room to store it. So they don't have that. They keep now. I can pull up my phone records from 5 years ago. You can see the text messages. Well, you can see text versus voice, but you're not going to see the messages. And when she said she did not text him, I'm going to believe she did not text him. And he also lied about the fact that when he did that other deposition, that they hadn't, that he no longer texted her, where she had proof that, now you're saying you texted, but she was supposed to be engaged in June when all of this happened. Oh God. Okay, crazy cat mama, come on.
I got to go here. I have to. That's what I mean is cell phone records of her actually texting him, not what the words are per se, but the fact that she is the one who contacted him first after all of this mess.
Okay, and they said everything was downloaded, her phones were dumped, and they could not prove that she didn't, and she did, because they don't have those kind of records after a certain amount of time. But he did show reasonable doubt. But then you look at it, she was allegedly abused. And you hear cases of women that keep taking their abusers back, that keep communicating with them because they feel that sometimes, somehow, or some way this was their fault.
Do you know how many times I was abused in relationships? And I
have no idea. I've never been abused in a relationship.
Yeah, no man is gonna put his hands on me, and I ain't gonna kick his ass for it, for sure. Straight up, because I'm a crazy one. That's why I'm crazy cat mama. But
that's why I'm having a hard time. And the judge did say he was going to allow it on, but she got up there and she's more believable. She looks straight at you. She holds her composure. And if she said she didn't do it, I can do a damn text message to myself too. Come on. And if you're taking screenshots, I want to show the number. He's already lied and said that he don't remember giving out the wrong number. So I would prefer, I believe her testimony over his any day.
Well, I would hope that they would have followed through as soon as she said that first text to him. I would have gotten a hold of my attorney and requested that they pull those text messages at that point in time, because he knew he was going to go to court over this.
Well, he provided them, so he should have had proof.
Yeah. So I don't know how they go about making.
Thank you, Janelle. She had blood in every room. You're right. She had. I'm gonna put this on mute. There was blood in every room. Everyone. Okay, they're coming back in session. Well, not yet.
Thursday afternoon to you, and welcome to Court TV Live. Proceed to justice. I'm Julie Grant, and we are so glad you are with us. Oh boy, it's been an interesting day in the trial of Geoffrey Paschel. He is the former 90 Day Fiance star before the 90 days. And now he's accused of domestic
That's what I want to know too. Why did they bring him in?
An incident that is said to have happened in June of 2019.
Yes, and he waited over a year later to bring that in.
Was not surprising to many. He decided to take the stand.
He's an arrogant prick. That's why he took the stand.
I've explained to you your constitutional rights as it relates to this trial, correct? And there are a number of fundamental constitutional rights that you have.
This is crazy.
You have the right to compulsory process, correct?
Okay, so he's testifying. I would testify too. I believe I'm a good actor, and they're going to believe me, and I'm charismatic, and I'm charming, and all these women want me. Really?
Correct.
Yeah, but this is where I honestly have to draw the line, is if she's the one who contacted him first after the incident.
Okay, so you're thinking that she actually contacted him first, right?
I don't know. I'm not following all of that.
That's what Geoffrey is saying. She was contacting him.
Yes.
She contacted him and said she did not. So is he said, she said.
I know, but that's what I'm referring to as far as the phone records go. It may not show the content of the messages themselves, but the phone records will in fact show you when these messages were sent.
And I said they subpoenaed her records from her old phone number. And there's no proof that they went from her, and there's no proof that she did send them. There is nothing there. Even if she deleted them, they would still have that record.
Those records are going to show up on his phone records as well.
Well, they didn't dump his phone. No one asked them to have his phone dumped. That's what he testified to.
Really?
Really?
Interesting. Interesting. Because they should have.
Now, if his attorney, is submitting all of this stuff, well, then you want the proof. You want to get his dump from his cell phone to show they actually came from an outside and came from that old number that she had.
Exactly. And yes, I kind of sort of was in and out of the courtroom stuff yesterday to answer that one question.
So you present something, okay, you took a screenshot, you have it. Fine. Where is the proof that your phone company they dumped her phone? So where's your dump?
And they can still dump his phone. They honestly can. So if he's not allowing that to happen, then
he said he was never asked. You shouldn't have to be asked. Your lawyer should. Oh, okay, they're back on the stand. Okay, let me get this.
I remodel them.
Okay.
Do rentals and stuff.
Oh no, he's not back on the stand.
That's
Okay,
what you're
they're just showing
currently
what they said earlier.
Yes.
Let me just mute.
No, I think they're going on a lunch break. I'm not sure what Tennessee is.
Yeah, but this is why I didn't hear him say a lunch break, and it's kind of early today because they went for a lunch break late yesterday. But that is my problem right there. That is my problem with all of this. He should have this, but you should have had your dump done, because I'm sure the defense team got her dump information, and that just added fuel to their fire because it doesn't show whether she sent them or not.
No, and I'm not saying anything against the young lady. I promise you that. I promise you, because those photographs are horrible.
But look at what Darnell just said. He didn't present those until a year later, a whole year. He submitted those text messages.
He could be blonde like me. And
girl, please, you're going to court and you're looking at 30 years. Why the hell would you hold on to something for a year when you're trying to say that she was still texting you? That's evidence for you. That's helping your case. Why would you hold on to it for a year?
Okay, now let me ask this question, and maybe I misunderstood yesterday's court thing or somebody's comments yesterday, but did he ever marry this chick?
No.
Okay, so he was married to somebody else.
Oh my God. He was still married, seeing Varia, and engaged to her.
Okay. And talking to Varia at the same time.
Yes.
Okay. Because I can, and that's, she might have just found out about Varia and went apeshit crazy with any woman will.
Hey.
Yes,
O'Hara.
Hey, how's it going?
I hear an echo, Jane. I hear an echo of that one.
Do you want me to leave and come back in?
Yeah, leave and come back in. Thank you.
No, Miss Heidi.
He looks really comfortable. He's cocky. It's like my SHIT don't stink. All right, Queen.
Is that better?
Yes.
Okay. I just wanted to say, they offered him a guilty plea with no jail time, and he insisted on having a trial. I think that says a lot.
Or maybe he is overconfident about presenting his side.
He's an actor. He's putting on his acting skills. Queen of O'Hara, what do you think? Do you think she ran into a wall, a door, and the concrete?
I don't. I watched all of her testimony yesterday. I do know from personal experience on trying to get phone records for court cases, what you said about them not holding them is absolutely true. I don't know if he fabricated. I do think it's a good possibility that she did text him.
about the premise.
Because when you're in an abusive relationship, you often don't make the best choices. I think that he probably was very emotionally abusive to her. As I said before, the timeline, he was married, engaged, and talking to someone all at the same time.
Yep.
So, that doesn't say a lot about someone's character.
No, it doesn't.
That doesn't make you a woman abuser, but I think that he thought that he could talk his way out of this, but I don't think he did a very good job in his testimony, saying that she ran into a door and then he later said the wall. But
And
both
the
her eyes were, messed up in the
Yeah.
pictures.
And
So it
and
just
that
didn't seem like her injuries matched his story.
well for me, in all honesty, okay, if she just had the knot on the head from him slamming, well, her nose maybe.
Okay, guys,
But
they're
it,
back on. Okay, they're back
okay.
on. Okay, let me put this on.
Okay, this prosecution
Okay, they're
has
back.
gold with those photographs. I don't know why they're not up there right now.
Okay, they're
On
back.
that screen for this jury to look at and to force him to look at them. That is how I would do it. And this is coming from someone who used to serve as a prosecutor. But here they're talking about his employment and his money. In my view, you got to start off strong. If you have it, go for it. And I don't know why they're not. I understand we've got our guest, Daryl Cohen, standing by for us in Atlanta. He was a prosecutor too, does criminal defense work. Daryl, this start to the cross. Weigh in, please.
Well, I think that we have to realize that we're looking at a jury, and juries don't understand what's going on. We know the entire story. Why the prosecutors, and I agree with you, are not starting with a smash, bam.
Yeah, with the pictures.
Shock and awe is beyond me.
Daryl,
Those
thank
photographs are gorgeous. Those photographs are
Listen in out
poignant.
loud.
Those
She's back at the
photographs
podium.
say what they need to say. So I agree with you.
You're aware of that?
Completely agree.
We all had petitions. We're characters. So many of the cast on my same season had petitions for various reasons.
So
So
you had one specifically related to these criminal
I'm
charges.
not.
You're not aware?
You know that.
Okay. You are aware that you were not invited back to the reunion special.
That's not true.
You were at the reunion special that aired.
I was not.
So you were not invited back.
It wasn't nothing to do with invitation. We chose not to do that.
No, you didn't.
That was a choice.
No, you didn't.
Okay.
No, you didn't.
If you had, you have a YouTube channel, is that correct?
I do, yeah.
You do interviews on your YouTube channel?
No, I don't think I have, that I can recall, think of an interview that I've done on my YouTube channel.
You've never done an interview on YouTube?
On YouTube or my YouTube channel?
Yes, on YouTube. You've never done an interview regarding your time on the show on YouTube?
I've never done a YouTube recording, no.
You've
It was
never
on
done an
IG.
interview that was then put on YouTube regarding the show?
I never put an interview on YouTube. That's
That
correct.
anybody put on YouTube?
I don't know what somebody else might have done.
So you're saying to right now that
Yes.
you are not aware of.
It was on his IG channel, and then he uploaded it.
So what you're saying right now is, to your knowledge, you have never done an interview that has been placed onto YouTube regarding the show.
I don't know. They use a lot of platforms. If I've done an interview, they use it for their own platform, or potentially it could have gone YouTube. I mean, a lot of people copy interviews and post them for views, so therefore they can try to monetize their channel. But I don't know.
So you have done interviews regarding the show.
Yeah, absolutely.
And if you said in these interviews that you were not invited back to the reunion because of the pending criminal case, Would that be the truth?
We chose these interviews
Again,
are not
stumbling,
based on,
lying.
They're for views. They're for a lot of stuff they do clickbait. A lot of stuff they tell you what to say. A lot of things they try to steer you in
Jeffrey.
a certain direction. So a lot of
Play
this
it,
is clickbait.
play
where
it,
people
play it.
click on it and try to make money for their channel. And so a lot of these YouTube or
I'm not sure,
YouTube per se,
Sassy.
a lot
I
of these
can't
interviews
remember,
are
to be
rehearsed, and they give you what to say prior to doing it. So I don't know if I've stated that before.
Yes, he's been on. Yes, he's
And
been on
you
John
also
Yates
said that
and
you've
Dom
never done an
and Dom
interview that you
Nettis.
personally put on your YouTube channel. Is that correct?
To the best of my knowledge, I don't recall an interview. I would do what I was saying and take other people's interviews and put them on mine. It had nothing to do with me though.
You don't recall uploading an interview to your personal YouTube channel? Let's see here.
Bring it, girl. Bring it.
That date and time.
Yes, I've seen him on John
Titled
Yates
The
too.
Allegations, the women. You remember doing that?
I do.
Oh, now you do.
And that was where somebody was asking you questions.
Yes.
And that was something that you specifically put on your YouTube channel.
That is correct.
So that was an interview you did.
Sort of. I mean, not
Oh
really.
my God.
I didn't have an interviewer.
Lying.
But yes, there was a back and forth with somebody.
Okay. Well, somebody was asking you questions, weren't they?
Yes.
Thank you. That's an interview, idiot.
And you talked about this case actually in that video, didn't you?
I honestly don't recall.
You don't recall saying that these allegations from Miss Wilson only came to keep you from a custody battle, to help your ex-wives in a custody battle?
That's what he said.
Honestly, I don't recall. I mean,
Play
that's
it.
probably a couple of years ago, and I actually had forgotten about that.
No,
upload
you didn't. You
prior to
didn't think she
saying
had proof. You're lying through your teeth still.
So you don't recall saying that Ms. Wilson made these allegations only after you wanted to end your relationship with her and to help your ex-wives in a custody case. You don't recall saying that in that interview.
I honestly don't recall saying that in that interview. No.
And you don't recall also,
I think the proper way is asking if he recalls.
Shut up, attorney.
Recollection fresh under 612, showing him a copy of the interview. I would object to her characterizing an interview without the appropriate evidentiary foundation.
I think she's appropriately impeaching as a potential prior inconsistent statement, so I'll respectfully overrule the objection.
you also stated on direct examination you met Ms. Wilson in December of 2017. Is that right?
Yes, ma'am.
And said that you all hit it off quickly.
Yeah, we started off as friends, but we moved pretty quickly. Yes.
Began dating pretty soon thereafter.
Yes, ma'am.
When did you say you all became engaged?
I didn't, but I don't remember when. Maybe the beginning of 2019 sometime.
She needs to bring it up and
Beginning of
discredit him right then and there. That's what
a
she
huge
needs.
guesstimate. I'm not sure.
Hi, Roxy.
Do you remember on May the 17th of 2019 stating that you weren't dating anyone when you were in another proceeding?
Your Honor, we would object to statements.
Keep
that
objecting, keep
prior
objecting,
to
keep
this
objecting.
case even occurring in terms of relevance.
This is proper impeachment.
And then, guys, John's going to
Do you
have an
recall making that
update
statement?
after the trial concludes today. He's
no,
going
I
to
do
do
You don't
a full
recall
recap on his
having
channel.
a civil deposition on May the 17th of 2019?
You had mentioned it prior, but I didn't. I don't recall that. No.
Would it help if you were able to look at that statement?
I've looked at it earlier, but I'll look at it again if you'd like.
No, that's just true.
Oh, Miss Manda, thank you.
I'm looking.
Thank you so
specifically
much
on
for the super
record
chat. I
59
appreciate it,
with
baby.
Beginning at line 1. Can you tell us what it said right there?
It says I'm not dating anyone.
But in fact, you were seeing Miss Wilson at that time.
In April,
2009.
Yes,
in
they're
April and
friends.
May, we actually weren't seeing each other during that time.
Okay. And also remember.
Yep, he's been on Dom's lots of
January
times,
of
and Dom is his
2019,
friend
so
as
around the
well.
time that you
So
just
is Mark.
testified you all would have been getting engaged, you also had another deposition.
So he has
Yeah,
a lot
I'm
of
not
bloggers
quite
as
sure
friends.
when we got engaged. I'm assuming it might have been.
I'm not one of them. Don't like him.
We
Never
had gone to
have.
Florida, so it had to be in March, honestly.
I like
Okay, you
Mary.
remember
I
that
like
time you
Shelby.
also stated that you had never dated Miss Wilson?
I like Amina.
If she's going to impeach him with sworn testimony, can I have the line and the page and ask if that refreshes his recollection? I don't know if we're talking about January or March.
We're referring to
To January.
transcript.
What's the date of the transcript?
January 9th,
That page
2019.
and line.
Page, well, I mean, I was asking him if he remembered saying that.
Well, you have to, I would respectfully object unless you can ask him if his prior testimony refreshes.
The rule says you have, that's how she's proceeding.
We're gonna need her
The rule says that you
to
have
read the rules of evidence,
to see.
because I think she forgot about that.
So have you had a chance to see that?
No,
Great. I've given you this. It's right there.
is this what we had now?
She said it's right there.
You don't have to visit this.
I like her.
I mean, do you have,
What page and line?
Franklin's got the whole
I need to know the page and line before, so we can pull it up.
page. That might not be the full one. Then 37. You all have the full version of it.
Okay, look.
Yeah, I'll just. All right.
He's a jerk.
Page 37.
That's what he's playing, word games.
37 line, 31.
Busted. Busted, busted, busted.
You recall in January of 2019 stating that you had never dated Miss Wilson?
I don't recall that, ma'am.
You don't
Of course
recall it?
not.
No approach, Judge.
He don't recall nothing when he's busted.
I'm going to direct your attention to starting right there at line 19. Can you read that?
Correct? Did you all ever date? No.
And that was your response, correct?
Yes, I'm not sure who it's referring to though. It just says, did you all ever date?
Teresa, I'm not sure if I said thank you for the super sticker at 1041 or not, but thank you.
Instead of reading from the transcript, we would object to him reading from prior sworn testimony.
I do not think she's proceeding here as a refreshing recollection. I think this is potential prior inconsistent statement impeachment. I think is the theory that she's flying.
So I'll allow her to proceed.
So we're going to turn back one page prior. Okay. What that says there at the bottom.
Babysitting Chasm at the time he had a seizure. My son actually had died in Miss
Oh,
Wilson's
now
care.
we're going for the sympathy.
When,
No, you didn't.
Who is being asked about there? You said you weren't sure who the questions were referring to.
Yeah.
They're referring to Miss Wilson.
Yeah, it says who, well, I don't know. It says Kristen. I know several, but it says who's Kristen?
Oh my God.
Kristen was a friend. How do you know her? She's actually the one that was babysitting Chasm, my son, at the time he had a seizure.
Oh my God. He
Look
said
to the
he
next
knows
page
many
here.
Christians. Oh my God.
Would you like to just
Semantics. Oh my God, this man
bring
is
down
playing
where it
games.
says no as far as the dating question?
No.
Start from the top.
Oh.
We can make sure that we're talking about Miss Wilson.
The babysitter. Did you meet her?
Yes, I
as
will keep
being
it up,
a
promise.
child care provider. I met her. Yes, yes. Did you find her online when you're searching for child care providers? No.
We keep going down to the part where it says, did you all ever date, please?
I was actually at the mall, I believe Westtown Mall, playing with the kids, and she was there. I don't know if, I can't remember if she was the one there with the child. or
Guys, I'll be
babysitting or
right back.
whatnot,
I
but we
gotta
just
mute
struck up a
myself.
Conversation and it went from there. Did you meet her out socially after that? Yes. I mean, I assume you did some kind of sleuthing. Yes. Yes. Correct. Did you all ever date? No.
So again, you are talking about Miss Wilson there.
I'm assuming so.
And you did say that in January of 2019, you told an attorney in a sworn deposition that you had never dated her.
I don't think the context of the word date, because I said that we went out socially. So, I mean, I don't know if date and going out socially is the same thing, I guess.
Okay.
see here.
Okay. You're welcome, KT.
All right. And I want to talk for just a second about, you said that at the time of this occurrence back in June of 2019, you said that you all were kind of on the outs. You and Ms.
Yes.
Wilson?
Yes.
Isn't it true that you had went on vacation with her and her parents just the weekend before, went on a camping trip?
I don't know that to be true. No.
Okay. You had a whole lot of stuff at her house still, didn't you?
I had some clothes. Yeah.
You had just some clothes. You didn't have a kayak, a
No.
dresser.
No.
You
She
didn't.
gave me all my stuff back, and I got clothes. That's what was. I think you ordered her to give me all my stuff back.
Well, that was actually just a couple months ago, wasn't it? You didn't actually end up getting all of your stuff out of her home until just very recently. In fact, is that correct?
I was told to have no contact whatsoever, and
Well, but my question was, you had quite a bit of stuff still in her home on June the 9th.
I had some bags of clothes. Correct. Yeah.
And a kayak.
I don't have a kayak. No, I don't have a kayak.
You didn't have a dresser there.
I didn't pick up. I don't have a dresser. No.
Okay. You didn't have. So you're saying all you had was clothes.
Yes. All she handed me of all my stuff that you told her was some clothes. I had some bag of clothes.
Okay. Yeah. You said that.
Thank you, Kendallin.
That you both were drinking the night.
Thank
at
you
the
so
brasserie.
much.
That's correct.
You were drinking Jack and Coke.
I had 2 beers, I believe, and then some Jack and Coke.
Okay, I say
And you
guilty.
said that Miss Wilson.
And I know
was
he has a
drinking
presumption of
champagne,
innocence, but I say guilty.
martinis,
That is my
and
opinion.
Tito's.
That's correct.
And yet you said you didn't think
I
that
would
she
have
should have
thrown
been
them
driving.
clothes in a dumpster.
Neither of us should have been driving. No.
But you didn't call an Uber.
Neither of us did. No.
Okay, you didn't try and get a ride from anybody else.
I believe we talked to Katie about getting a ride, but she was going to get off.
He could have
later.
sent his sons to pick up his stuff.
So you got in the car with her,
I did.
and she drove you home.
She did.
And you said that you walked the dog.
That
Is that correct? And
Yes.
and Miss Wilson became angry at you while you were walking the dog.
I think she became angry at me. The way that things went, I'm assuming she became angry at me when she saw me on the telephone.
And where were you when you were on the telephone?
I had crested the hill right there at Aldenwood and a side street. So probably 100 yards from her house, possibly.
So your testimony is you walk back in the house with the dog and she's just angry.
She was, yes.
Just everything had been going fine, right?
Everything was fantastic.
And walks in and she's just aggressive with you at that point. As soon as you walk in the door.
She was livid, yes.
Okay. You've seen your video. You've seen the body cam video of you.
Yes, ma'am.
You would agree with me that you were in the living room when
Not
police
sure, Queen.
came at the door. You were sitting in the living room of the home. Is that correct?
I came to the door. When I heard they came to the door, I heard them coming. I got up and walked to the living room. That's
Okay.
what the door is. Yeah.
And so you heard them coming even though you were asleep upstairs in the bedroom and came to the door when they didn't knock or anything first?
I wasn't asleep. I was lying there.
Okay. But you agree you were upstairs in the bedroom
The way her house
is
set
what you
up-
testified to on direct.
Yeah, the way her house is set up, there's 3 stairs, and it's right there's the bedroom, so it's really close in proximity to the living room and the door.
But the officers did not knock.
I don't think so. I don't recall.
They didn't have blue lights on out in the street.
No, they had walkie-talkies talking. You could hear the commotion, and then you had the dog.
Okay.
So there's obviously somebody was coming to the door.
You had an iPad in your hand when they opened the door, did you not?
I don't have an iPad now.
Or you had some sort of
A
device in your
MacBook.
hand when you opened the door. Do you not recall seeing that on the video?
No, I don't.
Do you not recall seeing you toss your cell phone out of your pocket? I believe you actually asked the officers if you can do that.
I did.
Were you laying down with your cell phone?
In my pocket, yes.
And you also tossed some car keys out of your pocket
I
onto
don't
the
rec-
couch?
I don't recall that, but
If it's on the video,
it's potential. It could have happened.
so you were
yes.
laying down with your car keys as well.
That's fine. Everybody can. I said, in my opinion. He's
And
guilty.
As
That's
soon
what I
as
said.
the officers walk in, I believe
You are right
said
to have
she
your
hit the
own
door.
opinion and
You
your
remember hearing
own
yourself say that?
thing, but in my opinion, he's guilty. I don't
It's
believe she
pot-
walked
yeah,
into a damn
potentially,
door.
yeah. I don't recall, but I'm sure.
But they hadn't asked you anything yet when you made that statement.
Well, the police were there. I mean, it's obvious what had happened. And then she told me on the way out, I'm probably 25 feet from the house. I'm calling the police. You need to leave.
And you remember telling the officers that you actually showed them in the video saying that she had slammed her head against the wall, correct? Not the door frame. You said the wall.
That was one of the places that she had, yes.
Okay. The wall in the stairwell is where you pointed to.
Yeah, that was one of them.
Okay. And you never mentioned having to go pick her up out of the bushes. Is that right?
I didn't. Mm-mm.
You never mentioned that the two of you had been sound asleep and she just walked up out of the middle of nowhere, did you?
Neither of us were sound asleep. No, I did not mention that.
Well, you never mentioned that the two of you were just laying there and she just got up and left.
Well, I didn't tell the whole narrative of that evening.
That's right. Say the
You actually
narrative.
said that she assaulted you and then ran out the door. Do you recall saying that on the video?
I don't recall saying that, but she had
Well,
scratched
we
me.
can
Play
watch
it for him. Play
know.
it.
She had scratched me prior to that.
Right,
Yes.
but you would agree with me that you told the officers right then that she had attacked you and then ran out the door. Is that correct?
But that's true. That was referring to when she grabbed the keys and tried to exit the door.
She
That's
grabbed
what
the
happened.
keys.
that
She
were in
didn't
your
have any
pocket.
keys.
Oh, I retrieved my keys. I mean, we had settled. This is 3 hours later. Everything had
Oh
calmed
my
down. Everything was
God.
fine.
Well, you also remember telling the officers that the scratch marks that you had all over your body had incurred just 30 minutes prior to them arriving. Do you remember that?
What I was referring to is her going to the her neighbor's house roughly about 30 minutes.
Well, I believe the officer asked you specifically what time you got the scratch marks, and you said 30 minutes, didn't you?
Ma'am, I don't recall, but my understanding of that
Now he's
situation
saying,
is
ma'am.
when Miss Wilson left to go to the neighbor's house, and it was 30 minutes.
Okay. And you claimed that it was actually Miss Wilson who had assaulted you.
It wasn't. I don't even characterize it as an assault. I mean, she was having a mental situation. She was upset. She was aggravated. We were both drinking.
That's an
It wasn't,
assault.
I'm going to beat
That's
her up.
an
She's going to beat me up
assault.
thing. She was upset.
So you believe her to be so drunk that she became that's why she became aggressive. So you think that that's why she became aggressive?
No, I believe that she got jealous. I believe that contributed to it, just like my reaction contributed to
Egotistical
it.
piece of.
I believe that she was just drinking and jealousy overwhelmed her.
You recall telling the officers that she got mad because you told her that you were leaving her?
That's pretty much when she ran out. Yeah.
Okay. And
He was
you
leaving,
didn't
but he
go
was still
after
there
her
when the cops
at
got
2 in the
there.
morning.
I stopped at her door and I said,
Oh, I want to
she
tear
she
him
walks
apart.
off. That's how she blows some steam. She either drives off or she walks off. I stood at the door and I watched her and she got 25 yards away and I'm like, Kristen, what are you doing? Please come back in the house. And that's when she said, I'm going to call the officer. I thought that she was blowing smoke.
You said you saw a red mark on her forehead.
I did.
You told the officers that you hadn't seen her face. Do you remember saying that?
Not to the point in the pictures. It wasn't like that. It was a red mark on her face.
Okay. Had you seen her elbows?
Not at the time, no.
Had
There
you
was no
seen-
inspection.
Had you
of
seen
her.
her? Had you seen her knees?
There was no inspection of her.
Had you seen the back of her neck?
No.
Had you seen her back?
No,
Had you seen her ankles?
I did not.
Okay, so you didn't see any of all those other injuries to her.
No, I focused on the injury on her head. I mean, that was
Well, the red mark.
that was more significant. And it didn't swell till later. And, I actually had spoken to her, hey, do you think do we need to call somebody? And she said, no.
So you're saying
Leave me alone.
So you're saying you saw her head as it was swollen?
No, ma'am. I saw her in the bed and it had it was small. It was nothing compared to what the photos were hours later or whatever. But it was swollen. I had confronted her about it. I said, do we need to go to the hospital? Are you feeling okay?
Well, you would agree with me that the police arrived approximately, in your own words, about 30 minutes after she left the house.
That's correct.
Okay. So what you're saying is 30 minutes after she leaves the house, You hadn't seen that knot on her head 30 minutes prior.
No, we were lying down together. We were lying down, lights were off. She got up and abruptly walked out.
Okay.
The TV was on, but I mean, that was the extent of it.
You didn't call the police though when she assaulted you. Is that right?
I don't characterize this as an assault. I wasn't going to involve the police over some scratch marks. Absolutely not.
Well, I believe actually you testified that she was smacking you. Remember saying that?
She was upset. She was visibly upset.
It wasn't an assault.
I didn't. Well, I wouldn't involve the police in somebody being upset. I didn't feel like I was assaulted.
And you never got angry that night.
Of course not.
I was angry that
Geoffrey.
the cops were there. I was upset, visibly, obviously upset. The cops were there, and in that situation, but not with Kristen. No, absolutely not.
Okay.
And were you upset after you got arrested?
Yeah, was obviously upset. Yeah.
Okay. Did you become physical after that?
I don't know what I've become other than I was highly upset. I didn't think it was right. I was being unfairly taken away, from my life at that point.
In fact, you actually had to be restrained after you were arrested.
Ask him again, girl. Ask him again.
I say it all the time on this show. You don't learn new information on a cross exam. You tell the story. You control your witness and box them in. Quite frankly, this cross is a mess. And it's a real shame because it could be excellent.
Yeah.
Bring in Daryl Cohen.
Thank you.
By in Atlanta. Daryl, what do you think
She
about
let
this,
him
please?
throw her off her game.
Julie, I'm hearing Kenny Rogers. Do you hear him? Very carefully. You got to know when to hold him.
No one to fold them.
Fold him.
No one to walk
She
away.
needs to fold it. She's abrasive. She's all over the map. She is doing herself and the state's case no good. He is a great witness. He's looking her in the eye. His body language is good. His answers are good. She is just awful. And she's searching for something. I don't know what.
She's trying to trip
Maybe
him
she'll
up,
find
just
it.
like his attorney
Maybe she
tried
won't.
to do
Yeah,
to
you know,
Kristen
it's one
yesterday,
of
but
those
it didn't
things, like,
work. She's
I say
tripping
this all the
herself
time, you know,
up.
when you are cross-examining a witness, you control them.
Yep.
You tell the story. You're not looking for new information from them. You should never, ever ask an open-ended question.
That's
You are
right.
getting the story out there and confining them to a yes or a no. Your questions have to be so incredibly tight that they have nowhere to go. But yes,
We need
or
Nancy
no. And
Grace.
you stop them from explaining anything. This guy's running the show. And I
Yes,
can
he
see
is.
him getting under her skin. And I know what that's like. Believe me, I've had defendants get under my skin, and it is hard. So I feel for her in that sense. But
Yep, he's
what I
getting under
don't
her
get
skin.
is
He
you have
is.
those pictures that are so disgusting and disturbing. And she should be having them on display for the show.
Somebody send her a message, please. Tell her.
And we're how many minutes into this
Tell
cross
her,
we
control
haven't
this
seen them
shit.
or heard
Control
them
it.
mentioned yet.
Julie, I don't understand it. I would be taking those pictures, make them the American flag.
That's what you
Let
need to do. Put
jury
the
see
pictures
them,
up.
Slam them in his face.
What you waiting
What
for?
about this? What about that? I feel like I'm watching a preliminary hearing rather than a trial. I feel like
Yes.
she's searching for answers
Don't
that
search.
will be
Put 'em up.
later
Have 'em explain.
utilized in the trial.
Did you
This
see
is
this
the real
photo?
thing.
Yes.
It's here and it's now.
Yes and no. That's what
She
you want
is
to keep
not
it to.
doing a good job, in my view.
No, I'm with you. I mean, and some of the stuff that she wants to fight him on, you know, this is a guy who's going to fight you. You know, this guy really, it appears, it thinks a lot of himself. He's got a lot of confidence.
Thank you.
I didn't watch the show.
Just said
but everyone who
narcissistic.
did said he was very confident, very charming, has quite an attitude. He's got tons of followers on Instagram. He's had a lot of time to think about this. You got to be ready for a guy like this and be ready to box him.
No, I
That
need her to put the
impeachment,
pictures up
what
now.
was that? That was not an impeachment. When,
We need the
when you've
pictures
got a
now.
witness's prior testimony, and I know you know how to do this, Daryl. You're a seasoned trial attorney. You have that. When they lie, you say to them, you know, sir, is it, your testimony today is that, you said you weren't dating her, for example. And then you say, sir, you remember giving testimony on such and such a date, right? Yes. And you took an oath to tell the truth that day, right? Yes.
Right.
Just like you did today.
Yes.
Sir, I'm going to direct you to line number whatever. You're going to
Yep.
read it silently.
There
I'm
you
gonna read
go.
it out loud. And then you contradict the witness, and all you say is, I read that correctly. And they can just say yes or no. Here, she gives him the document. He's reading it. Like he was reading it. And
Thank you.
I was cringing, Daryl, just cringing. And then his counsel's objecting and confusing things further. And I'm not crazy about his advocacy at all, but he was kind of confusing it, going, well, this
She was
isn't
much
the
better
recollection
yesterday.
refreshed, and this
Much
isn't,
better yesterday.
situation with impeachment's proper. And, he was kind of right. Your thoughts, please.
She better not blow this,
Julie,
Stacey.
I
She
think
better not
that
blow this.
The prosecutor has forgotten her role.
She
I
has.
think that they are
She's
portraying
acting like
each
the damn
other
defense
in
attorney
a
with them
reality
open-ended
show.
questions.
And that's what court actually is. It's a reality show. It's unscripted TV. This is unscripted courtroom drama that should not be there. She should have, as you say, nail him down, push him.
Where's her
don't let
second
him
chair?
move
Let
right,
him get up and
left,
question him.
up
Shit.
or down. Instead, she's giving him the entire road. She's giving him all the freeways. He's doing what he wants to do.
That's true,
and
Stacey.
He's making her look foolish. And
Put the
truthfully,
pictures up.
as he answers the questions and always says, yes, ma'am, very respectfully, he's doing the type of thing
Yep.
that, in my view, juries like to see and hear.
You're right.
See, but
Daryl.
I'm not an idiot. I see
Listen.
right through him.
You would agree with me also that Miss Wilson walked.
You
out
don't
with
have to agree with you.
Yes, but maybe. I don't know if she put shoes on or not.
Okay. You were in blue jeans still,
That's correct.
sleeping in blue jeans.
Ma'am, we didn't sleep. Neither of us
Ma'am.
slept. We were lying in the bed.
Okay.
We had the TV on. I mean, we're just lying there.
I want to talk about these text messages very quickly that were introduced.
Can we put the
You
pictures
said-
up? Forget the damn
Stay
text
on the record that
messages.
These were from Miss Wilson. Is that correct?
They were.
And these are screenshots that you personally took on your cell phone.
That is correct.
And the only thing we see up top here is just a name that says Kristen. Is that right?
At the very top. I mean, at the very top.
Yes or
Yes,
no?
right here. It just says
What-
Kristen.
it says her
with
name.
3 little emojis.
Yes.
One emoji looks like it's a kissing face.
We don't care what the emojis look like. Oh my goodness.
So that emoji there, it's got little hearts around it, doesn't it?
I think it's like a love emoji.
Guys, I got to
The
fly to
next one is
Tennessee. I need to go. I need to get in this courtroom real
Next
quick.
one is a man, a woman, and a child, like a family.
Yes.
So those are the 3 emojis after the name Kristen. Is that right?
Yeah, she put that in my phone for herself.
Okay. And you're sure that this is from Kristen Wilson?
I'm 100% positive that it's from Kristen Wilson.
Okay, but you did acknowledge a few moments ago that you know several Kristens, correctly? You did say that a moment ago.
Yep,
Well,
you said
Kristen
it.
Wilson, yeah, I do. Kristen Wilson is the one that sent me the squirrel thing. Kristen Wilson stopped sharing her location at that time. I stopped sharing my location that time with her. It's her phone.
Okay, and you would also agree with me that there's no phone number listed on here. We can't see the phone
Yes.
number from who's sending this, correct?
Because I had her programmed into my telephone.
Okay.
I got people
You would
programming my
agree with
phone
me
and their
as well
phone numbers
that-
still
that
show
only
up
You, as the owner
along
of
with
your
their
phone,
name.
had access when the time these screenshots were taken. Only you had access to your phone, right?
I had access to my phone, but I had somebody around with me when they came through.
Oh my God.
I'm saying if you wanted to go in and add a new contact, that's only something you could do, correct?
Yeah, but I can't
Oh my God.
date texts or location unsharing. I can't do that.
But
I
you
don't see
have
your
the
location.
ability to program someone's name in your phone, do you not? With their phone
Absolutely.
number.
Well, sure.
Nobody else has that ability. It's
Yep,
just
and
your phone,
anybody, you
right?
could have put
Like
anybody's name
everybody's
there and have somebody to text
my
you.
children get
Thank
my phone
you.
from time to time, stuff like that. But
Now you're
nobody
making
would
sense.
program somebody's name in there.
Okay.
But-
And what you're saying is even up to 6 months after this incident occurred, you kept Kristen's name in your phone with these love emojis.
I didn't touch anything. I was scared to even go. She was in my favorites contacts and everything. I was afraid to even take that out by accident and accidentally call her. I didn't touch anything. I got to the messages and I screenshotted them. I never edited her name.
Okay, why didn't you
edited
block
anything.
her?
I never took her out of
Because
favorites.
if she blocked
To this
her,
day, she's-
you wouldn't be
was still in
getting that
favorites.
shit.
And when did you say that this text message was sent about the metabolic bone disease?
A couple days prior to June 9th, probably maybe the 7th or 8th.
So
It's probably, I think it was around a Thursday. The squirrel fell out of the tree that week and it was very weak. And she was trying, I had spoken to her about it and she
The
was,
damn squirrel.
sent that to see, to let me know how to properly give the right vitamins to the squirrel.
So you all didn't text message at all for 2 to 3 days in between when you went to the brasserie?
That's correct. We were not on the greatest of terms. And the brasserie was a way for us to unite again and potentially work on a relationship.
Well, how did you decide to go to the brasserie?
I said yes.
Did you call one another?
Yeah, she called me, most likely.
Okay.
I called her maybe.
Had you prior to June?
I'm sick
I
of
guess,
them squirrels. I'm
6th or
serious.
7th, when that very last message that we see here was sent, did you keep your text messages with Miss Wilson?
I did.
So you've never, you wouldn't frequently delete your messages between you and Miss Wilson?
I used to, yes.
In fact, you stated
testified you
in a
did.
deposition that you deleted them every day. Is that correct?
I had to at that point. Roughly every day, possibly every day. I think is what it was. But
It's yes
I
or
had to
no.
reserve space on my phone.
Sorry,
I had a
guys, I
small
missed
phone
break.
at the time. I believe it had 16 gigabytes. So I didn't have a lot of space at that time.
And you said you only did that prior to June the 9th?
Damn squirrels.
Deleted message. It was probably earlier than that. I ended up getting a new phone that had bigger memory, so I didn't have to.
Oh my
delete
God.
That time every day.
But you would agree with me that on May 17th of 2019, you were in a deposition.
Yep, he had other women at the same
Possibly,
time.
I mean, 3 years ago, maybe.
Varia.
So about 2 weeks before this incident
May
occurred.
17th.
2 to 3 weeks.
3 weeks, yeah.
Okay. And you said, I've not texted with her at all since January.
I don't know that to be the case.
You don't know if you said that, or you don't know if you had texted with her?
I don't.
That's
know,
what I'm
well,
thinking.
either.
He was
I
deleting
stated
messages
it
so other
in
women
a
wouldn't see it.
deposition, but
May I approach
Because he had 3 at one time. He seemed to have 3 women all the time.
For the record, I'm looking at
Yes, sassy gamer girl.
2019, page 108.
Yeah, she's letting him talk too much. Yes or no? Yes or no?
Highlighted portion down.
Well, let's try. Have you obtained your text messages with Kristen? They're at the top of the page. I think per the when it's spoken here, didn't have keep those text
Oh my
messages.
God.
Have you since? No, we don't even text anymore. You want to keep going?
Please.
We don't text anymore. That's correct. You've not texted with her since January? If I had, I don't recall what the texting would
See,
have been.
even then he didn't recall.
But you would have not erased them, right? Well, I have to for memory on the phone.
So 3 weeks prior to this incident.
I got messages in my
Did you
phone from damn near
remember
2-3 years ago.
versus
I don't erase
January?
nothing.
I spoke with her since
And then
January.
they're backed up on the
And
cloud.
here, did you not just say that you hadn't texted with her at all since January? Is that not what you said right here?
But I think it's clear. If I can reread, it's clarified that if I do have the messages, I erase them. So, I mean, there was communication. I just don't, I would erase whole bundles of messages from everybody.
Girl, you and that
unfortunately.
squirrel.
Yeah.
You did say in that deposition right there that you had not texted with her since January.
And then it's corrected. It says, that's correct. You've not texted with her at all since January. If I had, I don't recall what the texting would have been. But you would not have erased them, right? Well, I have to for memory on the phone.
You would agree with me, however, that your statement indicates that you and Ms. Wilson from January 2019 to May 17th, 2019 were not dating, correct?
Could you repeat those dates again?
Oh, Lord.
January of 2019 to May of 2019. You would agree with me that your sworn statement in a deposition would indicate that
No,
you have not
nobody
been
from the
dating
server
or
thing to
seeing Ms.
testify.
Wilson during that time.
I don't know that to be the case. If I
Yeah,
said
it's
that
time for her to change
in
her line of questioning
custody
too,
deposition.
because she's
So
not
saying
helping
that you
herself.
don't talk to someone for 5 months, you would not agree with me that that's what you said, that you, if you had talked to her, you don't remember, but you may not have even talked to her.
I said if I had the texts, I don't remember what they were about.
Oh my
I would
God.
erase them.
Okay. And when did you get a new phone?
I've had to get several new phones.
No. You said you got a new
I
phone.
don't know the exact dates
After
when I
that,
got new
when did you
phones.
get it?
So which phone were these taken from?
These as in that one?
These
there?
text messages.
I believe an iPhone 8 is what it was.
When did you get that phone?
Ma'am, I don't recall.
Really?
Did you get it after the last message was sent on December 22nd?
No, ma'am.
So you got it before then?
Well,
Yes,
he
ma'am.
said you don't recall,
So
so
did
how do you
you-
say no, ma'am?
Import your text messages from your old phone?
I do.
Important.
It's 6.
I would have, yes.
Because we have messages from before June 9th on here. And then you're saying you got a new phone in between when the last message would have been, correct?
In the last message. Yes, absolutely.
Okay.
So you mean after December 22nd, have I gotten a new phone since then?
Well, you said a moment ago that you got it before then.
I've gotten several new phones. You're getting me mixed up. So when are you asking if I got a new phone? After December 22nd?
Of what
The
year?
answer is yes. Prior to December 22nd, yes, I had gotten a phone prior to that too. But I tried to upgrade, and the kids and I would switch out.
You upgrade
phones
every
that
2
one
years
had
or
more
every year. Get your
memory,
lies
and,
straight.
in my situation, I needed it.
Okay.
Yeah, what's your
Would it surprise you to know that Miss Wilson provided her cell phone to the parties in this case voluntarily? You're aware of that, correct?
Oh, yes, yes.
Would it surprise you that after a forensic examination of that phone,
He's objecting again. Damn it. Can we just get this over with? Sidebar, guys, sidebar. Okay, he's up there going, Your Honor, we've already discussed this.
We are nearly 50 minutes into this cross-examination. and
It didn't take that
why
long to
isn't
cross-examine-
the state
Ooh,
talking
another
about the
microphone
alleged
dead.
assault that is the subject of this case. I am beside myself.
You too, girl.
Watching this, where we're talking about text messages and phones and the squirrel that fell out of the tree. Goodness gracious, get to the point, get in and out. Those photos should have been up 50 minutes ago at the start of this cross. We haven't seen them. This is
Thank you. I
such a
need the
great
damn
set of
pictures.
facts for the state to work with on this prosecution. And I am, as somebody who's been a prosecutor and somebody who is a real friend to the domestic violence prevention and awareness movement, I am just,
He needs to go to jail, Mimi. He really
stunned
does. But we're
at
gonna see.
where this cross has gone, and that is nowhere at this point. Daryl Cohen, got to bring you in. Weigh in for me, please.
Julie, I couldn't agree with you
Girl,
more.
I'm coming
This
with
is
you.
the
We
worst
all gonna jump in there.
cross-examination I've seen in a long time, and I would love to
It's
see the
not.
jurors. because I've got a
Y'all with them
feeling
squirrels.
They're laughing quietly.
right, you
Daryl, thank you.
screenshotted them.
Yeah, I was never asked to do any forensic download of any sort. And so I screenshotted them.
And you're aware that, when did you provide these? When did you actually provide these text messages in this case?
I provided so much evidence to my lawyers. I couldn't tell you when that was part of the
Hi,
group
Patricia.
evidence.
Okay, and
That's what I'm
but
thinking
you do
too.
know
I need
that
to go
the
check
state
her
would not
out and
receive
see.
these until
Because she did
September
an
of
excellent job
2020,
yesterday.
Correct.
I wouldn't know when you would receive something from my lawyer, but I know that I gave him everything that I had.
Okay, well, you've been to prior hearings and things where we've discussed this.
I listen to what I'm supposed to listen to and confer to what I'm supposed to listen to.
Oh my God. Okay. It's time to take a flight.
I want to go back to some of those interviews as well.
Can you
that-
put him
that
up
you-
and show him what he was saying?
That other people have posted
To catch him in a
online,
lie.
About you, I guess.
Objection as to what other people would say about Mr.
It's
Paschel.
his
She was
interviews.
one of the things that you're-
Is Patricia here? Oh yeah, she's here. I already said hi to Patricia. I thought you meant old school Pat. Guys, I'm so sick of
I have
her.
no words.
We need the
I
pictures.
think I have no words. I'm
Leave the
just
pictures
so
up there so they
baffled
can
by
look
this.
at them the
Daryl,
whole
I
time
want you
he's
to talk a little more, 'cause
testifying.
I'm sorry
That's
you
what I
didn't
would
get to
do.
share
Put them
as
up
much
and
as I would
leave
like
them
to
there.
hear from you.
Just
That
like you
last
do
sidebar, 'cause it
in the
broke up.
red drum case.
What
Put
can
the
she
pictures
do
up.
better? What
Leave
does
them
she
there.
need to do right now to reform this cross?
She needs to take a deep breath, back up, and
Thank
realize
you.
the jury is not interested in every minute of everything
Thank
that has
you.
happened
We're not.
throughout this pre-trial and throughout the trial. She needs to
Hi,
understand
Trish. Welcome.
KISS. Keep it short, stupid. Keep it simple, stupid.
Yep. Simple,
Go
stupid.
to the gist of this trial. Go to the photographs. Show them. Make them the flag. Let the jury
Yep,
see
she's playing
them
right into his
over
hands.
and over again. And then maybe,
Yep, put
just
the
maybe,
pictures
she will
up.
shake
Leave
up our
them on that
defendant,
board.
because
Leave
at
them
this
there.
point, he's holding
Let
court.
the pictures
He
speak
could
for
just as
themselves.
easily be on his left, a little bit higher on the bench.
Because he
and
know he
wearing
was
a black
lying and she
robe.
didn't send them
He
damn
is
text messages.
definitely
I can send you a
dominating her,
message. You
and
can put
she
my
is
name in your phone as
abrasive.
somebody else.
She doesn't know when to
Yeah,
stop.
I
She
could do
doesn't
that.
know when to start. And more importantly, she doesn't seem to know what
Varya
to do.
could have did that.
She is just in the weeds and needs to climb out, crawl out, swim out,
Yeah.
get out, and get to the gist of this case. She hasn't gotten there. And but at
Yeah,
this
his lawyer
point,
seems
if we
smart
saw the
today. He
jury,
does. I'm gonna give him credit.
I think this is snormony, not testimony, snormony.
You're absolutely right. Everything you said is spot on.
Yep, spot on.
100%. If only she could hear what you're saying, because that is the best
Send her a
advice anybody
message,
could give her
please.
right now. And
Send her a message.
I
Ping
want
her.
to give our viewers some insight into how the jury was looking. At 11:34, we got a message from our field producer in the courtroom, Beth Hemphill. She manages all of
I
our court
love
TV digital sites. And by the way, we've got this trial streaming on our YouTube channel, and you can also engage in the chat there. I know many of you have been engaging with me on Twitter. I love it. We'd love to hear from you. Tweet us, chat with us, whatever you want to do. But Beth has been looking at the jury, and she said at 11:30, so this was after the direct, after his lawyer got done with him, she said the jury looks attentive, but some look angry. One man is scowling at him without his mask on. You can visibly see he's not buying it. No one looks like they're being charmed by him, in Beth's opinion. Then she sent another email
Yes,
and said
Payne.
one man is making a fist, clenching his fingers, and another man on the front row closest to Paschel will not make eye contact with him.
Damn.
She said they were looking even more upset in that second email she sent. So this is right around the 11:30 thereafter mark during the direct. So she had a perfect situation, right, Daryl, to walk into. The jury, you know, in our producer's opinion, looks angry at him and looks like they are not buying what he's selling. And then she goes up there.
Yep, that's make true,
this jury
Marie.
is receptive
True.
and does this. I'm baffled.
Come on, let's go.
Well, Julie, I think she doesn't understand. No questions, Your Honor. The state has no cross-examination. That would have been, in my view, the very best cross-examination
Yep.
she could have done.
Don't question him.
KYD,
Don't give him a
BMS,
chance.
keep her down.
Put the pictures up. This is all the state has to say. Put the pictures up. That's it. Put them up.
I like to hear myself talk. I want to hear my voice, and I'm smarter than that defendant. But the truth is, she's acting as if she's not.
Right.
She's in the abyss.
Yeah. You know, and I learned this as a prosecutor. I really learned it the hard way, because a lot of times people like Geoffrey Paschel, you know, can get under your skin. He's faring really well up there.
He's getting under her skin.
He's calm. He explains. He's doing great. From his perspective, he is faring about as well as he could up there, in my view. But I know as a prosecutor, people like that can really get under your skin when you're examining the witness, and you can't let that show. And I just feel like she's visibly seeming upset.
Yep,
and
I'm listening
scattered
to all.
and disorganized. And really, like, for me, this cross would have three components. I would really start with those photos, make him look at it, go through every one of them, and then I would go through what the state is saying he did that night, every single little thing, and then I would
She
go
should
back
be
to
because
the
they already
photos,
in
you know, and
evidence. So
essentially
she should be able to put them up. They've already been
you
marked.
expect this jury to believe this is how, you know, she wound up looking like this, from, you know, tumbling out of the house, going over the hedges, bouncing off the wall. So you say you expect her to believe your story and end with those.
Yes,
photos
thank you. I
again.
thought she
So
can
to
have
me,
them
it would be a
displayed
very
the whole
short
time because they're already in
cross,
evidence.
like photos, actions, photos again, and then sort of end on the note like you're looking at the pictures, looking at the jury. There's no way this jury is going to believe she tumbled out of her own house
Yes.
and wound up, you know, with
Yes.
her face purple and a knot the size of a fist. Unbelievable.
She punched herself in the forehead.
Julie, check mark.
Yeah.
I completely 1000% agree with you.
Mhm.
This is what she should have done. It's too late for that doubt. But
Yeah.
she could still
Thank you,
simplify it.
Mario.
Daryl Cohen, thank
I'm
you
want to
so
hear
much.
your
Great
thoughts.
analysis
When they go
from
into
you.
break, if you want to come
few
up, I
months
definitely
ago,
want to have you come up.
where
so
you
we can
claimed that you
discuss it
had a
reverse.
screenshot of Miss Wilson speaking with your ex-wife, actually on the
We don't care about the
immediately following this
screenshots.
incident.
I don't believe that's what I said on the interview.
Well, do you recall the interview that I'm speaking of?
I recall saying that. I'm not sure which interview it was.
You don't recall saying that at all.
I said I recall saying something like that. Yes.
Okay. You recall saying you had a screenshot.
Yes.
Okay. And you recall saying that they were just trying to get custody of your children from you, that Miss Wilson was trying to help take custody of your child away from you.
I don't recall saying that.
You said it.
I recall
You
saying
said
I had a
it.
screenshot.
Okay.
Yeah.
And, but yet today in court, you're saying that the reason this all happened is because you wanted to, Miss Wilson thought you were talking to another female.
That's why the occurrence, that specific situation happened because she thought I was talking to another female.
That's yes or no.
But you would agree with me that since this incident occurred, you have made several statements that Miss Wilson is only doing this to help to try and get custody of your children from you.
Objection.
Yeah, that attorney is allowing her emotions to control her. Yesterday, she did a much better job.
It's going to be used to impeach. I'd like to see
Her name is
it.
Heather.
It's
She did a
for
much
first
better job
election.
yesterday.
He needs to see it, so I object to the question. If there's no foundation whatsoever, I object.
General, your response?
No, I'm happy to play videos. I'm happy to.
That's not what the question was. He's given statements.
Well, I think the basis of the objection was asked and answered. I respectfully overrule. General, proceed.
Have you ever, since this occurred, you've given several interviews or things online where you have claimed that Miss Wilson is only doing this to help your ex-wives in custody battles, have you not?
I have, but the incident occurred at the house based on her jealousy. Ever since then, it's morphed and it's made its own way to different things.
And you would also agree with me that you have actually been the one to subpoena Miss Wilson in your custody cases. Is that correct?
Objection, lawyers issue
Yep. He knew what, yeah. He knows how to get under people's skin. He does. Because he damn sure gets under mine, but I will be ready for his cocky ass. Definitely be ready for him. I've dealt with them like that all at work. Cocky, smart asses, narcissistic little pricks.
At this
Those are the
point,
ones you
I'm
deal
going to
with.
say that she is actually helping him because she is allowing him to do so much explaining. He's able to get out his story even more so than he did on direct. His attorney kept it pretty
I'm about to
safe
drink me some
on
wine. I'm gonna be
direct
drunk at
because he was afraid
7:30
of what
tonight
might
before I
be
even go on
coming
air.
across. And now
I'm always drunk
she's
according to some
essentially
people,
letting
so
him
I'm gonna be drunk for
explain
real. No, I'm not.
the side of the story that he wants this jury to be buying.
They're not buying it.
Feel free to disagree with me. But
Yes, cupcakes, let's
I'm just
go.
being told we have John Mobley as well as our guest.
Let's go. I love a
welcome
road
you in as
trip.
well, John. I think they might be breaking up though. Daryl and John are going to stay with us. Keep watching.
16 hours from here to there.
And I'm going to get you both in here for some analysis. Our next sidebar.
And I'm going to bring these back up here just so you can look at them.
No, put the pictures up.
Provided. Looking specifically at this one here on the last
I
page.
hope she has a good close.
Looks
I
like-
hope she has a good close. I really do.
according to this, it was sent Sunday, November 17th at 8:19 a.m. There
Yeah,
isn't
he's
a
second
year
chair.
listed on there.
He needs to
If you
interject.
look here at the very last line, I believe it says, I'll do everything I can for you to lose Kagan. Is that what that says?
It does.
Okay, Kagan is your son.
That's correct.
And again, you claim that these messages came from Ms. Wilson.
They definitely came from her. Yes.
Okay.
He
And
keeps-
yet
he's doubling
you have
down on
actually
it.
been the one to subpoena Ms. Wilson in your custody case. Is that correct?
I don't think, to the best of my recollection, she has never been subpoenaed by my side. Ever. Ever.
Okay. But if, oh, fine.
That's enough.
Move
on.
Here. Make sure I got nothing else. I think that's about all I got, Judge.
Put the pictures up.
One other thing in these messages, it says if you would have taken care of me, all you had to do is take care of me. Remember that part of it?
Yeah, I'm not sure when it was sent, but yes.
But you agree that there's a message in here that
Yes,
says
ma'am.
that. You would agree with me, Miss Wilson, she has a job.
She does.
She's a school teacher.
Yes.
She has her own home
Yep. Thank you.
that you
Thank you.
actually stayed at.
I've stayed there before. I've stayed the night at her house before, yes.
You stayed there frequently. You had quite a bit of clothes there.
Same as my house. We divvied up spots.
Okay. But you would, again, agree with me that she
That taking care of me
was
part
gainfully
pissed me
employed.
off because she had a job, her own damn
She
home.
wanted to quit her job.
Oh my
That was-
God.
Yeah, that's the premise of it.
Okay.
She wanted to quit her job. Look at him.
Okay, just a second, Judge.
Eyes blinking real fast. Ooh, look at him. Yep. I want your closing arguments. That's what I want. I want them pictures to be the last thing the jurors see. Oh, he's
All right, I'm
finished?
sorry to keep you late for lunch, but I did want us to get through Mr. Paschel's testimony before we broke for lunch. Your lunch is here. Again, do not discuss the case. We're not at the point where it's time to start doing that.
I need
So
every
the
juror's
officers
phone
have
number, so I'm gonna
very
call
nice
them. I'm gonna start
I'll
texting.
rise for the jury.
Okay, Marie, do you want to come up? Because I
can't
want you to come up.
believe she just
Queen
sat
of
down.
O'Hara, if you want to come up, I'm putting
We
the link back
still
in.
Never
I
heard
really
him
want to
be
discuss
crossed
this because
on
my
those
blood is
photos of
freaking
her
boiling.
injuries, those brutal injuries. That
I
are so
am
hard to
boiling
look
right
at.
now.
How he allegedly caused those despicable injuries, and then how his story is preposterous. The prosecutor left out the three big things that should have been essential to this
Anybody wants to
cross-examination,
come
in my
up, guys?
view,
I just
as a
dropped the
former
link.
prosecutor.
Come up. I'm going to
I am-
pause this.
I am
But
stunned
this,
and amazed
I am
at this,
just
and not in a good
disgusted
way.
with.
I'm being told the judge may be speaking to the lawyers. Let's listen back in.
Okay.
In terms of scheduling, I anticipate, unless we have an epiphany over lunch, that we're going to rest.
Yes!
Will we go directly into closings or?
You might. So I guess we'll come back, you'll rest, we'll get into state rebuttal proof. I'm not going to put them on the spot at this point and ask them how long that will be.
It's going to be
We'll
over with
proceed that.
today.
Just depending on how long it is, I would like to move directly into closing at the end of the proof if we could.
Yes.
And how long would the court want to take for lunch?
I was going to leave them out till 2. Does that work for you guys?
2?
Okay.
That's an hour.
Usually it doesn't take them that long to eat, but I know we have other people involved and it can be a challenge for get everyone fed. So I generally take a full hour for lunch.
Yeah, we're
You
going
guys
to check
should
our
be
bank account.
Back in your seats at 1:59. We'll resume the trial at 2 o'clock.
Thank you.
Thank you all.
Okay, guys, I dropped the
I'm going
link.
to bring in.
I'm gonna drop it again.
Just for some
You wanna
reaction
come
here
up?
because,
Let's
as
come
I
up.
said,
Let's
I
discuss
have no
this.
words, and usually I have a lot of words, and
Because this is driving
I
me
am
nuts.
just beside myself and really disappointed at what we just saw. Let's bring
Girl,
back
get your
in
stuff done.
criminal defense attorney Daryl Cohen and criminal defense attorney John Mobley. John's joining us at the top of this hour from Columbia, South Carolina. So John, welcome to you. I'm going to begin with you. I imagine
I'm gonna
you
get
were
my
watching
nails
this
done
as
one more
Daryl and I
time
were
from
watching it.
my favorite place
Tell me your
before I
thoughts
leave.
on what the state just did and didn't do on cross.
Yes, come on, tell us.
Well, it's amazing. I mean, they're basic things. I mean, the tip is prepare for cross-examination.
Thank you. She didn't prepare.
And it just appears this prosecutor didn't do that at all. I mean, she had plenty of points she could have been scoring.
Yep.
Getting the defendant to make certain admissions and concede key parts of the state's case to establish domestic violence. And for some inexplicable reason, she just dropped the ball on that. And I cannot even give you an explanation on that.
I can't either.
Right. It makes no sense, John, right? It makes no sense. Daryl, I want you to weigh in. You watched this with me in real time. You were giving us analysis in real time. When she said, "That's all I have, Judge," I exclaimed, "What? What?" I think I alarmed everybody in the control room because I could not believe she was done after that when she never got to everything we wanted her to get to.
Thank you.
Julie, she was done before she started.
Damn.
She never did anything she should have done. And the only thing that she could have done
let me tell you.
better, because she doesn't seem to have
Shelby
that
is going to
capability
come.
handle it
I
the way
talked to
she
Shelby
should.
last night,
She
all
should
in the
have sent him
DMs.
questions, but she didn't.
She
and when
is.
she didn't, she
I
should
know
have
she's
taken those
in.
photographs. I agree with you.
She's
and
over
show
on
them
Court
to the jury.
TV's
Let them
thing.
see
Let me
what
send her a
she is
message
showing the
and
defendant.
see if she want to
Let
come up
him
real quick.
explain that.
Hold on,
And
I'm
are
gonna
you
send
telling
Shelby a
the truth
message right now
or
and
were
see
you
if she
telling the
can come
truth
up really quick
before?
since they're at break.
Or have you ever told the truth?
Let me
Which
send
is
Shelby
the
a
better
message.
lie?
Hold on a
She
second.
just
Let me
is
get there.
awful.
God damn, my
And
phone
I
is
don't know if
my
she's
hand
a
isn't
new
working on my phone. That's
prosecutor. I
weird.
don't know if she's an old prosecutor, but oh my
Let me
gosh,
send her a
rehab
message.
is something she needs to go to. And
She
I'm
was
not talking
texting me
about
all
drug
last night. Let me
physical
send her a
therapy
message.
rehab. I'm talking about prosecutor rehab. Keep it short, stupid. Keep it simple, stupid. Make it happen and bring it to the jury. She's not in a storytelling mode. She's in a directed mode, directly at the jury, directly at the defendant. Make him
Okay,
squirm.
I just sent
He
Shelby a
didn't squirm.
message.
He was holding court.
100%. 100%, Daryl. You're absolutely right. He controlled her.
Hey girl,
'Cause
I'm
she let
screaming
him.
over here, and
And that's
people
the
would
thing.
love
That
to
is
hear
the
your take on what's
beauty
going
of
on. And
cross-examination.
I don't know if
And
you're
I
able
know
to
you
come
both
up
know this.
real quick
John,
so
I'm
we
going to
can
throw this one at
discuss
you.
it.
When you're on cross, you're the star, right? You're the one doing the talking. You're the one telling the story. You know what you want that jury to know. It's basically the time where through the witness, by making them pretty
Yes,
much
he
just sit
is.
there and either agree with you or disagree with you, depending on what the question is, you get the story out there to the jury. Here, it looked like almost like she was like deposing him at some points, like trying to just learn some information, and he just
Hold on.
handed it to her.
Yeah, and I agree.
I'm on my
Like I
channel
said,
right
I mean,
now.
The lack of an overall strategy is something that was
So,
apparent in this
let me know if you can come
cross-examination.
over.
I mean, a good cross-examination is basically the attorney making a long statement with the defendant or the witness saying a yes or
Okay,
no.
let me see if
response
she's
to
going to
the
come
point.
over.
That's how you conduct a strong cross-examination. Get them to admit the key points in your case. Get them to admit the weaknesses in their case. I mean, that's all part of it. It's basic 101. And for whatever reason, there was just a lack of preparation here. And once again, I'm dumbfounded. I just don't see the explanation for how, in a case of this magnitude, something like this will happen. This is not a small, case where there are no cameras and in a small courtroom down in the lower court. This is a substantial case. There's going to be a lot of pressure, a lot of publicity, and that's normally when you kind of raise your
Ooh,
head.
how do you join the stream with a Mac? What stream are you talking about, sweetie?
Totally.
I'm not sure. I
Absolutely.
think you just
A
go
trial
to
of
my
this
thing and
magnitude.
come on
Another
in.
thing to think about here, and again, I know what it's
Wait
like
a minute, Kiss.
to be a
Keep
prosecutor. I
it
know what it's
simple
like to
and
be
stupid.
overwhelmed,
Yes.
to have a stack of
Are the
cases
3
taller than
S's.
you when you go into any courtroom on any given day. But here, this case was supposed to go last October and was postponed because of the pandemic. So there was so much time. And when you have a case like this with a defendant like that, where he's got public
That's
social
what I
media,
wanted her
you
to
can
do
watch
too,
him,
Rebecca.
you can
Walk through
study
those
him,
pictures.
you can do your homework on
That's
his
what I wanted her to
mannerisms,
do.
how he behaves. I mean, you can really size up a guy like that and
Girl,
know,
Julie,
okay, this
she
is how
said
he's
he's
going to come in
handsome.
here. This is probably going to be how he reacts.
I know, not
when I
Geoffrey.
ask
She's
him
talking with
things.
the
I
other
mean,
guy.
there were so many things advantageous to the prosecution in this case, just because of of who he is, the fact that he
Nope,
is,
she never
I
asked
guess,
him
somewhat
about
of
the
a
injuries
celebrity.
or
I'm gonna be
anything
honest,
yet.
I've never heard
She
of him
never
before.
did.
I didn't watch
Never
the show,
ever did.
but for those who
Never
watched
brought
it
it
and
up.
didn't like him and wanted to
That's what I'm
petition him
pissed
to get
about.
off,
She didn't walk that
he's
case
somebody
through.
known. He's got a ton of Instagram
You got to
followers.
walk it through from
And
what
that's
you
what she
presented
started
yesterday
with.
to what you
She
did today.
started
You
making
walk
him a
it through.
star. Like maybe people on the jury had never heard of him. She would know
Put a
that
gun to his head, so to
in the
speak.
voir dire with the questioning. But I just, to me, why she didn't put that photo up. The first thing she did, even
so
before
you
asking
have to
him a
go
question, because they're
through
already admitted
Google
into
Chrome.
evidence.
You
This is
have
a
to go
teachable
through
moment for
Chrome.
all of our viewers. Once the evidence is in,
Okay, go
something
through
like that, she
Chrome.
doesn't have to ask permission
Because you
again
can't go
to put
through,
it back
I
up on the
forgot
big
what's it
screen.
called,
She just
Safari and
starts with
nothing.
it up.
You have
I
to
would
go
take a
through
long
Chrome, Trish.
pause. I would be very serious. I would look at it.
Oh, the
study
reporter
it, look at
guy.
the jury, make him
Oh,
so
I don't know. I
uncomfortable
forgot his name.
in
They
that
put it
seat
up
before
there a
even
minute
ask him
ago.
a question. And yet she starts with him in his income.
She wasn't
and his
getting to it.
TV
She
work.
was trying to
Daryl, I
say
can't.
that the text
Take it away.
messages,
What about
she
the way
was
she
walking him
started?
through it,
What were you
and
thinking?
she was
please?
lying. I mean, to show he
Julie,
was
you
lying, but
can't
she
make
didn't do a
this
good
stuff
job.
up. His income means nothing. Making him a star does one of two things. Some jurors will want
Yeah,
to
we have
convict
to look
him
at it
because
all,
he
and
is
I'm
a
agreeing
star.
with you, Maria.
Other jurors will want to acquit him because he is a star. And that's the way it works. I thought she was awful. You start with, isn't
No,
it true?
she's going to call a
Show that
rebuttal
picture.
witness, and then
And
she's
you
going to
wait,
do her
and I
close.
agree with you, and you hesitate.
So she's going to walk
and
him
you
through.
make
That
him
should be the
uncomfortable,
last thing
and
the
you watch
jurors
his
see
body
when
language.
they go into
So
that
tell
room
me,
are
how
those
did this
pictures.
happen? I don't understand. I heard before. I really don't understand. Help me out with this.
We all need her
Tell
damn
the
number.
jury how she received these damages. How was she physically damaged? Tell us
Yes.
how it happened again. I'm
The
sorry,
door,
I
the
don't
wall, the
really
sidewalk.
remember.
Come on,
Isn't
Shelby.
it true? And that's the fabulous 4 words. Isn't it true? That's a compound word, so it's really 3, I guess. But isn't it true? Tell the jury. She never once involved the jury. She never once even looked at the jury. She never once paused. It was staccato. It was uncomfortable. It made me wonder where she went to school, not graduating law school, but where she went to school to learn how to be a prosecutor. And as
Where
you
did
point
she
out,
go?
this is old. This case should have gone to trial 1 year ago.
Yep.
And
They kept
then
putting
I
it
heard
off.
her ask on cross-examination, isn't it true we didn't get this until September 2020? Well, this is now October 2021. So, Julie,
years.
I am amazed.
2
I'm
years, 5 months.
disappointed, but it does show our viewers
July, August, September.
what you should not do as a prosecutor.
2 years,
and
4 months.
hopefully they realize that, and that will be very dispositive.
Yeah, I'm with you, Daryl. You know, in this case, it's just, I'm at a loss for words. I guess you could just, when you
We all
watch
at a
something
loss
like
for
this and you
words
see
here.
that the evidence is
You see,
there,
she's still
but the
screaming.
advocacy is not. It's tough to watch, and I know you gentlemen agree with that. We're going to continue the conversation. Daryl Cohen, John Mobley, so great to have you both on the program today. So great to have you with us at home. We're streaming this live on YouTube. You can chat there with us. You can tweet at me. I've been sharing my thoughts since he got up on the stand today. And that
Okay, Tish, where are you? I don't
anxious to
see
hear what
you.
you think of how the prosecutor ended this cross-examination. This is Court TV Live. with Rock
We
Rosie
all gonna be
to
catching
Justice.
charges. Marie, come on up. I'm gonna mute them really quick because I really want to discuss this. What we just saw, this train wreck that she was putting us through. We just went through a damn train wreck. Harping on them damn text messages. Were they legitimate? Were they not? I know it's lunchtime. This is crazy, guys. Oh, I'm so upset. She didn't, I don't know. She didn't know the rules of evidence. She didn't know. He did. He got under her skin. Oh, okay. You're still downloading. That's fine, sweetie. Yes. Okay. So here's what they can do. She's going to call. I'm more than sure. Oh, let me get myself on camera. I'm more than sure. I don't want to stop sharing. I just want to bring this down. I want to remove from. Okay, so I am more than sure. She says she has a rebuttal witness. Now she can call him back up, but then I don't. His lawyer can bring him back up. I don't know if she can, and I can't remember the rules for that. I really can't, and I need to look it up. Yep, if there are jurors, but from what we're hearing from Beth in the courtroom, I don't know if you guys know who Beth is. Beth has the curly hair, and she has that accent, and she is really, really smart. Somebody just sent me something. Let's see. But she's really, her name is Beth. Do you see the person in the court TV chat? What the F? I don't know who's in. Michael Saltz. Oh, girl, I don't know. Okay. Oh my God. There is somebody in the court TV chat. And this is disgusting. I want you guys to see this for yourselves. Do you see that username? Do you see that? That is disgusting. Oh my God. Yes. Okay. Shelby is still over there. I see her in the chat. She's asking, how does somebody actually give herself bruises on her neck? Disgusting. And they're allowing that stuff in the chat? Oh my God. Yes, in the court TV chat. Yeah, she is bad, Renee. I'm waiting for Tia. She's downloading Chrome right now so she can come up. Renee, I put the thing in the chat if you want to come up for a minute. It's disgusting. It really is. That is so disgusting. Serena said they're saying a lot of stuff in the, matter of fact, oh my God, they are so disgusting. Okay, I'm going to pull up the chat. Oh, Cassie, thank you for becoming a member. Okay, let me pull this back up so you guys, let me add it to the stream. Let me bring up, hold on, let me get this talk. I'm going to put the
state arrested, and today it was the defense's turn to put on a case.
Okay,
and
I put the chat back up so we can see it.
The defendant himself. He got on the stand, told
you
his
guys
story.
won't
He
be
was
able to
pretty
see
brief,
it.
direct,
Let's
and
look
then
at
he
the
just
chat.
saw the cross-examination that did not go through with him, how those injuries were caused, the photos of her injuries after the
Oh
fact,
my
or
God,
even
you see
attempt,
this?
to cross-examine him.
Why
about how
are they
his story
bringing up
doesn't
John
make
Yates'
sense.
name
We
in
didn't see
this
any of
chat?
that. What I want to do is go back to some of what he said, because his story is that she was the aggressor.
Mary
that
King
she was
said
angry
she needs to
about
go back
him,
to
thought he
thing.
might have been involved with someone else, and in his words, went to 0 to 100 is what he says. Let's take a look back at some of his direct now.
Oh my God, yes, he is a career
She's
criminal.
apparently watching me talking on the phone.
Oh my God.
It was at that time, it went from 0 to 100. It went from everything was absolutely great, everything was absolutely fine, to I'm communicating with
This
another
is
female.
crazy.
Can you describe to the jury
People
Ms.
actually
Wilson
think that
Chapman's
that's
demeanor
John
when
in
you
the
entered
chat.
the house from talking on the phone and walking the dog?
It was very aggressive, very loud.
Oh my
Very
God.
accusatory. That was her demeanor when I came in.
So things
Yeah,
changed
his lawyer
dramatically.
looks good
They did.
today
They did.
What happened
compared
next?
to what he did
I walked
yesterday.
in, and then she tore into me. And at that time, she was loud. She was getting in my face. You know, I'd slowly push her back.
This is
just
sad.
kept
You
getting
have
in my personal
people
space,
in
my
a
personal
chat
space.
talking about John
Scratch
in a
and
court
slap. I mean,
TV chat.
she was doing things to me aggressively, but I don't think it was
John, I hope
an
the
attempt to be aggressive. I
prosecutors
think she was just she was
will
upset,
get in there
thinking
and
that I
get
was
somebody else
actually
to
talking
do a
to another
rebuttal and
female
closing.
out there. And
That is not, oh
I
my
guess we both
God.
had hopes that our relationship was going to progress from that night, since we were on the offs already.
What the hell?
Did the arguing and physical contact escalate?
The arguing escalated. The physical contact really didn't. In the
Somebody
sense
is
that,
in
it
this
kept
chat
pushing our way. It
as
was
John
the
Yates beats
argument
his
where,
husband.
Kind of enough is enough. I don't want to do this anymore. I'm gonna go home.
Shelby is in there.
Point,
I'm mystified with one.
She,
with
prior to
no,
that, she was.
Wait a minute. I'm mystified
screaming
with
and carrying
no
on throughout
one.
the house,
Ha!
but
I healed
at
alone.
that point,
Yep, she
I
healed
went to go
alone
leave.
ago. Oh my
She
God!
attempted
I
to grab
think
my
this
keys.
is
Well, she
so
did grab my keys
sad.
and tried to bolt out the door. And as
Who
she
would
went
go
to bolt out the
into
door,
a chat
the door
under
the
somebody's
door
name
opened.
and
She
write some nasty stuff like
ran
this in this
smack
case?
into the door, side of the door, as she walked out, as she ran out. So she grabbed my keys and turned and hit the door.
Are you buying what he's selling? Let me bring in our legal analyst guests, see what they think. Defense attorneys Daryl Cohen and John.
Let me
Motley
just
are
close
with us.
that.
Daryl,
Let me
we'll
just
start with
close
you
their
here in this
chat because I can't
conversation.
with that.
When he was up there
Yeah, I
testifying,
can't close with
were you
that.
buying
Yeah.
it? What
I
were you
can't have
thinking?
that. Hi, Beverly. Long time
I
no
was thinking
see.
we've got to keep that door still. It keeps moving and
Oh,
getting
Trish
in
is
her
here.
way.
Okay.
It's just
I
not
can't
acceptable.
close with that.
Buying it?
I
Morning,
do
honey.
not like
Hi,
it,
Beverly. Long time no
but
see. Close your other
I do not
YouTube
like
tab.
this testimony.
Oh,
I think
Trish
it's
is here.
incredible.
Good morning, honey.
It's
I
not
can't
acceptable.
close with that. Okay, close your other tab. Oh, Trish.
Gotcha.
Thank you. Okay, what do you have to say, sweetie?
Whoa.
I hear you now. Can you speak up?
Is that better, Heidi?
Yes, much better.
Good morning, lady. How you doing?
Good morning. I am fine. What's going on, sweetie?
Yeah, I don't understand this case at all. Why aren't they showing the evidence?
That's what I'm saying. She was so hell-bent. Okay, they got under her skin. Now she can't get out of herself because she feels like they made a fool of her. But you got to know, I'm saying it again, somebody said in the chat about Kenny Rogers, you got to know when to hold them, know when to fold them.
Amen.
Get off that topic. Put those pictures up there. Make sure those jurors, the jurors see what he's calling. She tripped and hit the door when she was leaving the house. The bruises on her face, her foot that looks like it was fractured, the bruises on her knees, everything. Put everything out there.
Why in the hell did that lawyer just sit down? She's being paid off. It has to be.
Who's paying her off? Jeffrey don't have no damn money.
I don't know. This does not look like a clean case to me. That lawyer does not just sit down for no reason.
I hope they wouldn't do nothing stupid like that. But then again, who knows? It's just sad that you got grown people that act like that. Seriously. But what do you think she should have done, Tish?
I'm not really sure at this point because it looks like she's going to lose because her lawyer doesn't want to defend her.
See, it's not her. It's the state that is actually going for him. So let me see it this way. If this man is found not guilty, she got re-victimized. Yep. If she was victimized all over again, you had to look at all of this. You had to sit there and look at him. She never, ever, ever lost her composure. He, on the other hand, eyes blinking really fast. He was getting nervous. He didn't know where she was going.
I was married to a narcissist for years and he acts just like him.
So it's just not us thinking he's a narcissist. He is a narcissist, right?
Absolutely. Yep. I was married to one for 14 years. He's absolutely a narcissist.
Oh my. Okay. So John Yates is actually in there. Okay. I didn't see, because John goes under his name. He goes under John Yates, not just John, not John beats his husband, but he goes under John. I mean, John Yates. Sorry. Huh?
Is John going to come up?
John is over in Court TV's thing. And then after the case is concluded today, we're going to go back on John's channel and we're going to discuss everything because I was on with John last night, John and Monica.
Oh, I missed that one.
Yeah, so we went on last night, 9:30 Eastern. It was 8:30 Central. Hi, Shaylin. Yeah, so she had no idea where she was going. You're right. She got flustered. She let this man get under her skin.
Absolutely.
She needed to get out of her head, get back on her game. But she couldn't do that because she knows she caught him in a lie. So then in her head, she's going, how do I trap him? How do I trap him? But you didn't do a good job of it at all.
Nope. Not even close.
So, yes, let me send, hold on. Let me send John a message real quick and ask him if he would jump over here really, really quick. Because he's over there in Court TV. But we went last night and we discussed it. And, you know, John was being, because of his friendship with Geoffrey.
See, that's wrong. I watch you and John all the time, and I am so sick and tired of the crap that people talk about John. I am so tired of hearing it. I watch it all the time. The wig, all of them. I don't understand.
See, but he's gotten a whole lot better. He's a whole lot better because he's not letting all of these people affect him the way it used to.
Good.
And thank you, Beverly. But, you know, yes. Okay. He's asking if I'm live now. Yes. I told the man I was going to be live. I was covering it.
Oh, come on. He should know you by now.
Yeah, but he actually watched yesterday when I was live, but he didn't want to comment in the chat. He told me that. So, because he didn't want to get, and I get it, you know, the people he's friends with, people don't like them, but these people are good to him. And like I told him last night, you know, Geoffrey's not going to go up to a man and start talking crap.
Nope.
Look at the people that he's had issues with. Always women.
Yep.
Women. He manipulates them. So it's just sad.
Absolutely.
But to put that in the chat, I mean, you go in there under the username, John beats his husband. Really? That's disgusting.
That's defamation of character.
Well, no, because they didn't say John Yates. They just said John.
Oh, they did the cop out.
Yeah. They only used the username John beats his husband.
That's bullshit.
On Court TV chat. Hi, Chantilly. How are you? Oh, my God. You're having surgery? Okay, John's coming up. He said, give me a minute. Let me get dressed. Okay. Yeah, so he's coming up. But this is just, it's disgusting. It's despicable. And mods, if I have any mods in here, hi, Yvette. If I have any mods in here, and I know Susan was here, I know Sassy, our Sassy Gamer Girl is here. If anybody comes in this chat speaking any bull ass about John, they are to be blocked.
Amen.
If you don't want to do it, let me know. Send me a message, and I will block them.
I back it 100%.
Because I do not have that in my chat. If you can't respect the people that's on my panel, you do not need to be here.
Amen. Tell him, Heidi.
So I'm not going to have it. So you got an issue with John, you take it up with John. Don't bring it to my chat. I won't have it. So that's it. I don't play that. So, but you know, that's his friend. I get it.
Yep.
He's been accused, not convicted. He's been accused.
John's friendship with him has nothing to do with
nothing
John.
to do with this at all. Nothing to do with this case. Oh, it did say his full. You know what? I'm sorry. I'm looking at it too. I had to go back and look again. Let me go back and look. I thought, let me go back and look. Let me go back and look. Let me go back and look. It does say John Yates beats his.
Oh
my
defamation
God.
case right there. Defamation.
Yep, it does say it.
Yes, ma'am. Yeah, John. Another win.
Yep, it does say it.
The winds just keep coming for him, and they're going to keep coming.
Oh my God, this is crazy. Thank
Yep.
you guys very much.
Hell yeah, that was rad.
Yeah, there will be no disrespect in like that. If you got an issue, if you have something to say, you can say it in a construct.
First of all, this is not talk about John Yates.
Yes, it's not about John
We're
Yates.
talking about the case. It has nothing
Hi,
to do with John.
Debbie. We're just doing the trial of Geoffrey Paschel. Oh, good, Barbie. You reported. Okay, good.
Good for you, Barbie.
Good.
Oh yeah.
Yeah, so once you block it, you can't see what they're writing at all. Oh, John is here. All right, let me drop the link for John. All right, John, come on up. Hi, Yvette. Thank you for the super chat, my baby.
Good morning, Miss Yvette.
Yeah, I was on with Yvette earlier. I just dropped the link, baby. Yep, so let me take this off the screen real quick so we can get John up here and remove from screen. Trish, you stay right there. Don't go anywhere.
Yes, ma'am.
Yeah, it was painful to watch. It really was.
Yeah, I was sitting there saying what you were saying. Show the pictures. Show the pictures.
I was screaming, put those damn pictures up there. Hi, Natalie. Put the pictures up. Put the pictures up. Leave them up there.
Right?
That's what I want you to do. Leave them there. Let us all see how
It's
she
already
tripped
been
and
said
fell.
as evidence. Why not show it?
Yeah, let us all see how she tripped and fell.
Right?
How she hit herself as she was going out the door. You know,
Right?
I don't know what happened to her foot. I don't know what happened to the foot. Just don't know. Natalie, I hope you're doing well, sweetie. Look, I don't know what happened to her foot, the bruises on her arm, the bruises behind her neck. She must have been beating herself against the stairs.
Right?
You know.
Oh, she's an epileptic, right? She was having seizures.
Yeah, because my mom.
Hi,
John.
Good morning, John.
The bruises behind her neck. She must have been beating herself against the stairs. Now you got to turn off your other thing. All right.
Sorry. Okay.
That's
Good morning,
okay.
John.
Hey, everybody.
Hi. How do you feel the trial is going so far this morning?
I mean, you know, I was in, obviously, I know a lot of people are in the comments on the, I still have the comments here on, like, you know, the court TV thing. I have it on my TV. I'm watching it on cable.
Uh-huh.
I mean, I don't, you know, I'm getting a lot of heat because, oh, you said Geoffrey's a kind guy. Well, yeah, Geoffrey was kind to me. I met him. He was kind to me. I didn't date him. You know, I don't know that side of him. But, I mean, I think that prosecutor just handed him the case.
John.
Amen. Amen.
John, Geoffrey got under her skin. Got under her skin. She couldn't come back out of her own head. I would have those pictures front and center the whole time. How did she get that bruise? How did she get the marks on her neck? How did she get the marks on her arm? What happened to her foot? I mean, you know, she hit the wall. She bounced off the wall, hit the door, flipped out the door, hit the concrete, jumped back up, banged herself into.
Heidi, was there a switchback?
Yes, the switchback. I'm telling you. I was so proud of her yesterday. I couldn't stand Geoffrey's attorney yesterday. Today, he ran circles around her. They knew what they were doing. She wasn't equipped to come up there, and she has a second chair sitting there. Why didn't he take Geoffrey?
Well, plus, when the jury wasn't present, the judge was saying to Geoffrey, if you take the stand, she could ask you more questions, blah, blah, blah. I'm surprised Geoffrey has his past convictions with the drugs. Like, why didn't she bring that up?
They can't.
They can, because.
No, they said the priors were not allowed. His prior behavior.
He painted a picture. of I went to, the college, and then I
Yeah.
moved into homes. I mean, that was a big chunk of Geoffrey missing. And I thought that would be missable once
he said that.
on cross.
Yes. She should have said, okay, was there anything that happened in between? If he would have brought it up, then she could have put it in there. But she missed that opportunity too. You're right. I forgot about that because he did bring that up about himself. And
what else? The text and the squirrel, and the text and the squirrel, and the text and the squirrel. I mean, the squirrel is the MVP of this whole trial.
My chat was saying, they were saying that the squirrel would have did a better job as the prosecutor and the judge. Oh my God.
Where did she go to law school? Like the Lacca Fiore Beauty Academy? Like, I don't know where it's,
All right, hold on a second. Renee, there's a Google bot that's running rampant. Every time I go live in the daytime, Google bot goes crazy. Go back out and come back in. You should be okay. None of my mods are timing you out. It's called Google bot. Sorry about that. Yes, John. And thank you for the super chat. I'm sorry. Yes.
It's definitely interesting. I mean, now the cross is done. She didn't talk about anything but squirrels and text messages. And that's it. I mean, Geoffrey, when this is over, should go to church, say 10 rosaries, and thank God that he got this lady as a prosecutor.
But
Amen. Yep.
Okay.
I know who I want when I decide to rob a bank or do something bad. I want her.
Me too.
I'm gonna have to do a crime in Tennessee.
Did you hear what Beth Kara said? She said that the jurors are not looking at him; they're clenching their fists. I mean, that still could be because they're not buying it, but she's not doing a good job at sealing that deal. She's not.
All it takes is one juror. That's it. Just one to say, there's not enough for me, and that's it. And if I was on that jury, despite my relationship, if I would be like, I can't, that's not enough for me. I wouldn't. I mean, you're talking about 30 years.
Even Geoffrey looked confused as to why she stopped asking questions.
Yes. But then you saw he was getting nervous. He was blinking his eyes so fast, like, okay, where's she? He was trying to think ahead of the answers that she might be coming up with. And I was like, oh my God, I need to be in there to nail him to the wall. I'm sorry, John. Look.
No. I mean, it is what it is. And she kept going on about the interviews, and I'm like, oh my God, are they going to pull up my interview?
I was waiting for your interview to come.
I was like, I will shit if they pull up like my YouTubes with Geoffrey on there. But I don't know what's considered like technically like an interview. Like I don't know what. But then I've been watching court TV since yesterday morning, and it's been on a loop. And they were even showing clips of Geoffrey on Dom Natty's show on court TV. They were showing the clips.
Yep. And they had Dom Natty when Dom went. I think the first time they were there, they interviewed Dom about it too. But when they said, didn't you go on, weren't you interviewed and you said that it was about she was trying to help your ex-wife. So, and I was like, oh my God, please don't let him bring up John. Please don't let him bring up.
Well, I'm like, it would have been great publicity. I'm like,
it would have been.
I was like, okay.
But I was waiting for them to bring you up. I was like, oh God. And somebody in my chat said, he said that on John Yates, didn't he?
I mean, you can't buy publicity like that. That would have been great. But,
oh my God. But John, everybody said in the chat today that you did a great job with that, with last night, with the live you did last night. They said you did a good job on that live. Everybody was really impressed with the live you did last night.
It's hard because, me and Geoffrey had a relation, like we're friends, I don't even know how to categorize it, but at the same time, you have to report what's going on and you can't turn a blind eye to it. So,
yeah,
it's a crappy spot to be in, but it is what it is. So, and then when we're done with this, I know they're going to do the rebuttal and then the closing. They're probably going to do the verdict tomorrow, I would think.
Tomorrow. And I
Yeah.
told them earlier that after the close of trial today, that you're going to go back, or you're going to be on your channel and you're going to do a recap.
Yeah,
once
me,
the trial-
you, and Monica.
Yes, once the trial is done with, we're going to do a recap. So we don't want to discuss too much of that.
Yeah.
But I see, so you were in the chat. I got a text message, well, I got a DM. Somebody is in the court TV room chat under the name of John Yates beats his husband.
There's like 5 of them. I just keep blocking people. You know, it is what it is. And they're really making it about, they should be commenting about Kristen and Geoffrey.
Yes.
You know, but, you know, because I have all my lives on YouTube set to members only, this is all their chance to pounce on me because, you know, I don't have it on my channel.
Yes.
I don't even care. I just
You're not going to block your information.
block, and then that way it's fine.
Okay.
I don't care.
I sent Shelby an invite. I know she's in there, and I know. So I sent her a message. I said, "Hey, we're on break right now." I said, "Do you want to come up and discuss? If you want to come up and discuss the case?" And I guess I still see her typing in the courtroom. But I remember last night she wanted to come up on your panel so she can discuss the case. So I'm giving her the opportunity to come up and discuss the case. So
Yeah, I've seen her in a chat. I mean, I don't know if you can see. Like, okay, so let's see. There's my TV.
I see you.
There's my TV with Court TV on it right now. Then I have, then I have my iPad with the comments rolling. You know, I'm trying not to miss anything. And the TV is a little bit ahead of the YouTube stream.
Yeah, of the YouTube thing. So I have it on my phone. I'm watching. I actually have it here, and I had it on my TV. And somehow or another, I guess, you know, I have my TV set to go to sleep. So I need
If
to
anybody
go
has like a Samsung Smart TV,
yes, I have a Samsung
you
Smart.
get like all those free channels, and Court
Yes.
TV is one of them. In case, so if anybody has a Samsung Smart TV,
Yeah.
you can watch Court TV, and that's how
So-
we're doing it.
Yep. So when I move, I'm not going to get cable. I'm just going to do the internet, and I'm just going to use. I have to learn how to use my smart TV because everything I do is with. I just don't like.
If I can learn it, anybody can learn it. And yeah, we have Hulu and Netflix and HBO.
HBO Max.
Hi, Cody.
Hi, sweetheart.
Yeah, so I'm actually looking forward because they're getting ready to go back in about 15 minutes. I'm looking forward to hearing her rebuttal witness, which is probably going to be Kristen again.
I'm hoping it's the squirrel. I'm hoping it's the squirrel.
I call the squirrel to the stand.
Imagine the squirrel walks up with like little briefcase with
Oh my God. John, even the commentators on court TV are criticizing her behavior in that. Yesterday she knocked it out the park. Today she didn't eat her Wheaties or something.
That was a
Something is
complete
going on with her.
fail. And if you know, if Geoffrey walks away with not guilty, then he should send her a big old edible arrangement, like some type of cookie buffet,
Like
something.
a $2,000.
Cody has a fan.
Dinner, Red Lobster.
Yeah.
Cody, you have a fan. Kindlin says her mom is such a Cody fan. She was about ready to throw something through the TV screen at that chat room because they were talking about you.
Yeah, I know, but I just blocked everybody. But I'm like, you know, they kept shouting. I'm like, well, you know, thanks for the publicity. You could go to my
Yep.
YouTube channel and watch, and it is what it is. You know.
Yep, that's what they're doing, and that's like crazy. They keep bringing up your name. You're giving people more and more publicity. And when John goes live on his members only, every night he's gaining new members. So you're just helping John.
Yeah.
I just became one the other day.
Yeah. Welcome.
Head hag.
Welcome.
Head hag.
So
Welcome
I'm
to
just
the
saying,
madness.
every night you get 2, 3, 4, 5. So one night I kept seeing, I said, oh my God, look at the new members you're getting. Because everybody's got your name on their tongue. and they
Yes,
want to come in and see who is
It
this
is
John
everywhere.
Yates?
I scout channels all the time looking for John Yates' name just to see the garbage they're talking. Yep.
I make my rounds. What can I say? Yeah,
I'm
I'm
gonna get up.
curious.
I took my pills, Susie. Look, I took my pills. You know, them bones getting old now. But yeah, so yeah, but they're getting ready. But I just wanted you to come up, and I saw you because they said no, John is in there. I'm like, where? And I started scrolling. I kept seeing all these. I'm like, these people need to stop. But I don't, you know, just don't. I think you're handling it really well. You don't engage, and I think you're doing an awesome job because now they're not getting. It's old stuff. It's repetitive stuff. So
Old hat. Like whatever.
It's garbage day after day. Yep.
Oh my God, I have more than John's name on. Oh Lord, Christy.
Oh,
Oh Lord.
my.
John, I think you might have a stalker. You might want to get a bodyguard.
Well, welcome to the stalker club then, because I've got plenty of those.
We need to get you a bodyguard.
Oh yeah, you've been live this whole time. You've been streaming the video the whole time.
Since 9 o'clock.
Oh, I didn't even know that. Shit.
I told you yesterday I was going to be up, and I did a live.
No, but I got up. I was like, I'm like, is Geoffrey on TV yet? And then as soon as
they started at 9 or at 10:10 their time, so they were 10 minutes late.
Yeah, because they're Central, right?
Oh no, they're Eastern because it was 9:10 for me and it was 10:10 for them.
Oh, okay. I thought they were Central.
Oh, so wait a minute.
No, they're Eastern. So, but they were a little late because I did Yvette's live when I came on. Yeah, they went on.
Oh, so it splits down the middle.
Yeah.
Oh,
Yeah, but
okay,
anyway,
okay.
yeah, but they're getting ready to come back. I'm gonna run to the restroom myself. Put up Court TV.
He said, put your butts in the chair at 1:59.
Oh, look. They're only showing everyone how sick these idiots are promoting John. Yeah, it's just disgusting, but we don't pay that no mind.
There's no such thing as bad publicity. It's all good.
No,
again,
all
and
good.
I mean, this is so old. Oh, it's
Yep. And that's all they talk about is the same crap I've been listening to for about 6 months.
No publicity is bad publicity.
Well, we have the stalker line outside our door. We have the list. So sign up on our door. We have the list.
John has a list outside of his door.
Yeah, we got two.
For everybody to sign up. Y'all can take shifts on being out there hoping to catch him. You can find him on the boardwalk,
Oh, I miss Seaside Heights, baby. Come on. I was there for 3 years.
Got the list set. Where you
I
go?
didn't realize that you had all these people crazy and stalking you and stuff. My goodness.
Yeah, I'm in. It'll be something to see how the rest of this plays out. They should show this to law students and say, "This is what you don't do."
Yep.
Like
Amen.
Yep. Sex ed video.
Absolutely.
Oh my God. I don't know why she didn't just.
Oh, look, Whitney Lee followed me from the chat in this one to here.
Oh my God, Whitney Lee. John, do you want to answer Whitney Lee, or do you want? Do you want to answer that question?
First of all, Harita. I'm going to tell Harita that I beat my husband. Yeah. Okay. Yeah. Right, Whitney.
What is
Sure.
this garbage? God.
That's the blocked her there, and then she came. I told you got to take shifts. I got the list out, Whitney. So this is on the door.
Oh, we need Annalise Keating. Yes, we need Annalise Keating. That's who we need.
Yes, we do. Yes.
Oh my God. Why does Christian win? What? Sassy. You know what? I'm thinking she is gonna I see it. She's not being rude. If she's not rude, she's good. She starts being rude, I will personally block her myself. So she asked the question, John answered it, and that's it. Now if she starts being rude, I will be the one to block her. There will be no questions asked who blocked her. I will be the one to not even block her. I would just hide her from the channel. So that's the way I play. But as long as she's not rude and she's not saying anything off the wall, good.
Absolutely.
I wouldn't tell Harita what I had for breakfast. But I'm gonna say, oh yeah, Harita, I beat my husband. Yeah.
Well, John, I've known you longer than Harita, and you have never told me that you beat Cody. So
right, yeah, because I don't.
Know.
And
Yeah, because he's been walking around all day and say that he beats his husband.
Yeah. So Cody, if you need to be rescued, blink a few times or send a squirrel out so we can come get you.
I'm in Phoenix, but I'll come pick your ass up.
Yeah, people want to help you right now to
We're here to help you, Cody.
All I have to say is that, you know what? With him beating me, I love all this plastic surgery that I'm getting. So, I mean, come on.
Yeah, Cody, way to roll it. Yeah.
He needs to start, instead of hitting me in the face, he needs to start punching me in the stomach so that way I can go and get lipo and get the sleeve and everything else. And like, you know, I'm already done with the face. Like, so now move down my body because I need some lipo done. I need to start punching me like in my butt so that way I can maybe get like a Brazilian butt lift.
Oh my God.
Like, I don't know.
You're going too far.
John, you're not John, you're not doing a good job at beating.
I'll take
Cody.
advantage of it. I'm thinking that so that way I can get hit even more, so I get even more plastic surgery.
Or Rita, who has a DV case on every day that ends with Y.
Well, you couldn't beat him too bad. He still shows up on camera all the time, so he's obviously not beaten too badly.
Yeah, John, when was the last time that you actually beat Cody? I haven't seen a bruise in a while.
What, Heidi?
When was the last time you beat him? I haven't seen a bruise in a while.
Oh, I don't know. It seems like he's due for one. So.
Oh no, he just knows how to hit to not leave a bruise. That's how it is.
Yeah. You got to put the bars of soap in the pillow, and that's how you do it. There you go.
Oh my God. We are bad.
Life lessons.
Oh my God. So that's how you do it. I've been doing it all this time. Okay.
Secrets in the sauce. That's how it is.
Oh my God. Y'all are crazy. Oh my God. Wait a minute. Maybe he likes to smack booty with a whip. Y'all are getting out of hand. Hi, Jay Freak. Oh my God. You know what? For somebody that gets beat, Cody always seems happy. So that means he loves it. He loves it, and I like it. Shit.
And clearly, I'm
Oh my
still
God,
here. I got
John.
my own car keys. Like, I could leave anytime I want to. And it's like, really? Come on.
Oh my God. John, they're saying that you need to teach somebody how to do it. So
I'll do a tutorial on YouTube.
Right? How to beat somebody.
Oh my God. Make no mistake, we're not making fun of DV victims at all. What we're making fun is it's the dumb shit that people put into a chat. This is crazy.
I grew up in a domestic violence household. Believe me, it's not a joke, but this shit's funny.
Oh, Angel Wings. Okay, Angel changed her names. That she used to be Ethel Tweet. She loves you and Cody, John. She used to be Ethel.
Hi, Ethel.
Oh, Maggie. No, we're not making fun of D. We're just making fun of what they're saying, sweetie. That's all. That's all. The dumb stuff that comes out of people's mouths.
Yeah, just rolling with it. That's it.
Yep. We're just making fun of the comments that was put out there about John.
There's like about
it's not funny. And
5-10 people in that stupid Court TV chat.
Yeah.
Oh, is that all, Whitney? Because you were kind of the same nasty bitch in the comments in this Court TV chat to me, but okay.
Why would you even ask that on this conversation?
Like, whatever.
Yeah, it's okay. Let's see. It went on 160. It came back and bank account was hacked. What? Oh my God, Jay Freak. Oh my God, I'm sorry to hear that. But yeah, so John, so you answered it, so that should never come up again. So we're good. All right, guys. So I'm gonna let you go back so you can watch it.
All right. As soon as I have an idea when this ends, then I'll set up the live. Are you doing your Thursday night thing tonight?
Yeah, I'm doing it at 7:30. It's my farewell to Houston. It's my last live in Houston on Thursday night. So
7:30 is 8:30 my time. All right, we'll figure it out when this ends. All right, I'll see you guys in a little bit.
Okay.
Bye, John.
Bye.
Love you. Bye. Yeah, no, Miss Maggie, we were making fun of what was said about John. That's it. That's all. That's all. But Whitney, thank you for being respectful. I really appreciate that. I really do. So we're going to get Court TV back. I think they're back in at to stream. Okay, not yet. So they're talking about this other case, but they should be back in 2 minutes. And oh, hold on a second. Where do you join, Heidi? Oh my God. Hold on, sweetie. Let me see. I'm always bad about this. I never have nothing up. You see, Trish, I'm bad. I never do.
I just got a computer I could actually use. So
yeah, so I never do. There you go, sweetie. I put the link in the chat. Yeah, but John would be on his, but I put the link in the chat for you guys. I used to pin it, and then I'm like, well, if they want to join, they'll ask, and if they want to join, so I only do a few. I'm gonna do a few more things for members only, and we're gonna just be having fun. But if you want to join. But I'm never gonna put my chat on. Well, hold on, I'm not gonna say never because something might happen. But right now, I have no plans at all of turning any of my live streams into just members only, except for the stuff that I have set up for my members. So, but then because I'm quick to block people, I'm quick to block them. I don't care. I'll block them in a heartbeat, hiding from the channel. But I like to come in and have conversations with everybody. I like everybody to put their opinions out. So as long as you're respectful, I don't have a problem with that at all. And that's always been my motto. So, Trish, do you have anything else to say before we get ready to get back into this courtroom, baby?
no, I think we covered everything.
You sure?
Yeah.
No, Krista, you didn't offend anybody. No, Chris, I'm not talking about that. No, we were laughing about that. No, you're good. I'm just talking about people coming in here and being disrespectful towards others. I know, I just mean like the nastiness. You were fine. Trust me, if you weren't fine, I would have been blocked. Time out.
And you can't offend me easily at all, so.
Yeah, but no, we're not talking about that. Not at all. So you were fine. And guys, again, if you are getting timed out, go out and come back in. It seems like anytime I go live before a certain time, Googlebot just starts running rampant. No one is timing you out. If somebody times you out, it'll show you. It wouldn't just say a moderator. It'll tell you the person's name that timed you out. So no one is being timed out. Yes, I hope things get better when she comes back in. It's 1 o'clock. They should be taking the bench really soon, and I'm ready for it. And I think they're going in now. Trish, I'm going to drop you down, baby, okay?
All right. We'll talk to you soon.
Bye, baby. Thank you.
And Sergeant Raymond Beltran, who the state says is a victim. So they want this adverse instruction read to the jury about destroying evidence. So the judge is hearing arguments over that. We know that the jury is going to be back in the Tennessee case. And so we're going to take a break. We'll get you into the court. I'm so sorry. I'm having some difficulty hearing. I'm being told we're going back into the Nicholas Cruz case.
Why?
Should the evidence be excluded? That is entirely separate from instructing a jury as to the fact that there was evidence that was destroyed.
Thank you,
and
Rachel.
The defense is permitted to present its theory of defense.
I'm going to
Whatever
take
that may
myself off camera. I'm going to give you
And
back a
this
full screen.
should be instructed to this jury or should be read to this jury.
I'm glad you guys
it
are sticking
supports
around
the
with me. I
defense
really am.
theory of defense.
Because I'm
The
enjoying
fact
this
that
and
a
I'm supposed to be
pretrial
packing.
hearing where the court previously found the information not materially exculpatory, or
Tia
I believe
K.
the court's language in the
Hi,
order was
welcome.
something to the effect of not relevant or wholly irrelevant.
Hopefully
that
she
factor
has.
has nothing to do with whether or not the court should be reading this instruction to the jury. I would also cite back to
He said they were
Albury,
coming
which was
back
again
at
9:10
2,
second,
so it's 2 o'clock their
9:31,
time. Right
which
there, you
states,
see it.
the court further noted that
So they're
Albury
a
was
little late
entitled to
again,
have the jury
but
instructed
that's
on his
okay.
theory of the case, and that's whether or not the court believes that the theory is, or the state believes that the theory was not legitimate or ludicrous or was irrelevant, because relevance is not the standard, is not the legal standard for purposes of whether a jury should be instructed. So I'm asking the court to be able to instruct this jury based on the defendant's theory of defense, not a self-defense argument.
Anyone who wants to come and help me pack up my
can you
house? That's
argue
right. You've
that
been
you're
moving.
not going to
You've
be
been there
asking
for
for
40
self-defense,
years. Oh my God,
but
girl,
that
I
at the
feel for
same
you.
time you want me to instruct the jury that the portions of this video from before the incident would have been material and unfavorable to the state? How can you make both of those arguments? How could it possibly be material and perhaps unfavorable to the state if it's not going to support a theory of self-defense? How else would you meet that standard?
Because the fact that evidence was destroyed and the fact that things took place on that video prior to what we have had.
Okay, but if the things that took place prior to are material and unfavorable to the state, give me an example of what type of thing. Maybe I'm missing it. What type of
Hi,
things you could be
Sarah
talking
B.
about if you're
Long
not
time
talking
no
about
see,
self-defense?
sweetie. Hi,
Judge,
welcome.
the actions or comments of Sergeant Beltran. And I will also state.
And how can the comments of Sergeant Beltran be both material and unfavorable to the state if they don't support a theory of self-defense?
Judge, we're asking, the instruction is an adverse inference jury instruction. It is not, it is asking a jury based on the evidence that is presented or that comes out during trial to infer that what if they have seen evidence that there has been a destruction of some sort or a mutilation or a concealment of evidence, that they can infer, if it is presented that BSO was the party which caused that concealment, mutilation, etc., they can then infer that whatever was destroyed would have been favorable to the defense.
But your instruction says, and the evidence would have been material in deciding the issues in the case.
Correct.
So my question is, how would this missing video be material in deciding the issues in this case? Because you're suggesting that they say that Sergeant Beltran was calling your client names or something to that effect, and how would that be material in deciding the issues?
My point is that it is for a juror to determine if it was material to the extent that they want to make that inference. That's what I'm saying. If, for example, for argument's sake only, if the defense were to put on a defense and there were members of the jury who decided that whatever evidence we presented, despite not being required to, made the determination that whatever evidence we presented was enough for them to believe that evidence had been destroyed, that evidence was material, then they can make that inference. I'm not telling the court as I sit here for the court to decide whether that evidence was material. The instruction is for a juror.
Okay, guys, they are running late. I'm ready for them. I know this is about the Parkland shooting where he was
All right,
he
we are going to leave
he
this
assaulted
motions
an
hearing in
officer
Florida for now. We
during
have
that
a crew
time.
there
Hi,
watching,
just
so we'll let you
the
know
T,
ultimate
please
outcome here
welcome.
on Court TV Live. But we need to go back to Tennessee now because the jury is back, getting ready to hear the closing arguments in the case against defendant Geoffrey Paschel, formerly starred in the show 90 Day Fiance. Before the 90 days, he's being accused of domestic violence. The alleged victim is his ex-fiance. Let's go into court now. There's the judge. Let's see if we can listen in live. And our producer in the courtroom tells us that the audio is down because they're waiting for one of the jurors to come back into the
Oh my
box.
God.
Apparently that juror
Somebody
left
was
his
just
or her
kicked off of
hearing aids,
Twitch.
elsewhere, probably in the jury room.
Oh my God.
And we're going to be hearing the final arguments from both sides. We got some
Oh my God.
intel from our field producer, Beth Hemphill, who says that these arguments are not expected to take long. We saw the opening statements were pretty brief. Both sides did a pretty succinct job in presenting their cases in open. And it's our understanding both sides are expected to take about 30 minutes each for close. And then, of course, the jury will be instructed, and they should get this case this afternoon. This jury will be deciding Geoffrey Paschel's fate. The lead charge on this case is aggravated kidnapping. Why kidnapping, you ask? Well, because the allegation is that he was holding the alleged victim in this
Yes,
case
Beverly.
against her will.
I
by
just
stopping her
received that
from leaving
message.
her own home.
Next witness.
May it please the court, at this point, the defense rests.
Okay, the defense has rested its case.
Ooh, the defense rests now.
They will, Judge.
All right, call your first witness.
Second off, Kristen Chapman. Judge, I will need this.
Yes, it was. Same one.
Ms. Chapman, still order up. Have a seat.
Hello again.
Hello.
Ms. Chapman, I want to talk to you about some of this stuff that we've talked about here in court today. You've been in the courtroom all day today, correct?
Yes.
Okay. I want to first bring your attention to these text messages that
We've already
Mr.
discussed the
Paschel
text messages.
states that you sent him after June the 9th of 2019, okay? And have you seen those text messages and heard about them here in court today?
Yes, I have.
And did you see when they were actually put up on the screen and read?
I did.
Ms. Chapman, did you send these text messages to Mr. Paschel?
No.
Have you contacted him at all since June the 9th of 2019?
No.
Have you, when you learned about these text messages, did you voluntarily give your phone over for a forensic examination?
Yes, I did.
Did you agree to have your phone records subpoenaed?
Yes, I did.
And why did you do that?
Because I needed to prove that I did not send those messages.
And have you ever sent anything like this to Mr. Paschel since this incident happened?
No, I have not been in contact with him at all.
Okay. And also, I want to ask you about some of the statements that Mr. Paschel made on the stand about what happened that night, okay?
Okay.
Specifically, he stated that he walked your dog. Would you agree with that?
No, absolutely
I
not.
don't think this is appropriate rebuttal. It was inconsistent, but an inconsistent.
He said it's not an
narrative is the
appropriate
basis for
rebuttal.
And then it would go on ad nauseum. Rebuttal, sir, rebuttal. Obviously, the phone records were different, but
Well, this is within the scope of the defense proof, so I'll allow it.
at any point in the evening, did Mr. Paschel walk your dog?
No, he hated my dog. He was not nice to her at all.
And did you see him on the phone and become angry?
No.
Did you?
Object to leading, Your Honor.
How is it leading?
Well,
She wasn't really suggesting an answer.
Thank you.
I'll overrule.
That's not leading.
at any point in the evening, did you? Well,
He hated her dog.
I can show you some of the photographs that we took a look at yesterday. Okay.
And Judge, she did not go into those in her direct of that witness, in her cross of Mr. Paschel. We would object to this as rebuttal.
It is rebuttal.
I mean, as rebuttal. We would object if this is not appropriate rebuttal. She never showed Mr. Paschel any of those pictures. She's gone over these pictures at length with this witness.
Well, she hasn't asked a question yet, so I don't
Thank
know
you.
what the question is or whether it'll be relevant.
May we approach?
Sure.
Oh my goodness.
All right, so this is a good surprise that they are choosing to present a rebuttal case.
Yes.
Smart move here.
Very
by the
smart.
State. It's about time those photos got up there. And by the way, defense counsel lodged 2 speaking objections already, or maybe 3. I lost count, but that's inappropriate to just say, Judge, I don't think it's inappropriate to show this right now because no, You have to articulate a basis, objection, relevance, objection, speculation, objection, whatever the case may be, hearsay. So he's wrong too. This case, the advocacy has been really, really sloppy. John Mobley, you're watching this. How do you think the judge should rule? Defense counsel doesn't want this photo to come in now because she didn't present it on the cross. What do you think?
Well, I think a couple of different things. I think one, I disagree with your perspective regarding defense attorney. While there may be some technical violations regarding the manner of objections, at the end of the day, the goal is to break the momentum of the examination, which he has done. At the end of the day, she's not testifying right now. She's not going to her version of the facts. So
nope, she's just squirrel. Oh God, Scotland.
Grounds for it later. That is what you need to be doing when there's a powerful witness about to testify. So I kind of disagree with you on that, respectfully on that. Also, I think
very good. It might be a small dog. Maybe that's why he didn't like it.
One thing I'd like to see more from the prosecutor, although she's kind of recalled this witness.
John, we have to listen in live, okay? Thank you very much.
Yes. And you heard him state that you fell into a door.
I did hear him say that.
He said that she ran into a door. She didn't fall into a door. Mischaracterizing the testimony.
The evidence is the evidence. The jury will recall what the evidence was, and then been instructed that the statements of attorneys are not evidence. So go ahead, Jim.
So looking at your forehead here, was that injury caused from a door frame?
No, I never ran into a door frame.
There you go.
How was that injury caused?
By my head being hit into the floor.
Okay.
Rebut, girl, rebut.
And the injuries here on your arm, were those caused by you falling down?
Being pushed down and dragged.
Did you ever fall into any bushes outside your home?
No, I did not.
The injury here on your knee.
She's
was
doing
that
it.
from falling down?
Being pushed down and dragged across the floor.
And your lip here?
Is from my face and my head being hit into the floor.
Did you
There we go.
willingly, you heard Mr. Paschel state that the two of you went and laid down at some point. Did you hear him say that?
I did hear him say that.
Did you go and lay down with him
Willingly?
on your own?
Not willingly. He told me to.
Thank you.
And I felt very forced because I felt like if I didn't, he was going to just start hitting me again.
Did you take his keys from him at any point in the night?
No, I did not.
Did you have your own car keys?
I did. They were in my purse, but when I returned from Lauren's house after he had been arrested, my keys were not there. My grandfather later found them on top of the fridge, and I did not put them there.
And you didn't have your purse with you at Mrs. Gooch's house?
I did not, no.
And did you have your cell phone?
No.
And did your cell phone break from falling on the ground?
No, it did not. He broke it. He took the screen off it and disabled it.
Okay. And when you testified previously, you stated that he had deleted some things on your phone. Can you tell us exactly what was deleted?
Text messages between us. Every text that we had sent for our relationship, I didn't delete them. And the whole text thread was gone when I got my phone back. Voicemails that he had left me were deleted. Pictures, some pictures, not all pictures, but some pictures were deleted off my phone. I had some, I don't know if I can say this. I had pictures of marks that he had left on me previously from previous. Okay.
Yep, shouldn't have said that one, but you're good, girl. You're good. You're good. Another approach. That's a rebuttal. That's a rebuttal witness. Loving it.
That was a moment. Wow. Big moment. Let's listen.
A discussion about the case outside of your presence. If you please not discuss the case and go with the officers. All rise for the jury.
What in the world is happening now?
Okay, so this is big here. So the judge sending the jury out because the attorneys are going to argue about what just happened here. Because under the rules of evidence in cases, you can't introduce propensity evidence unless you have a viable exception under the rules. For
Yep.
instance, if somebody's on trial for stealing and they've stolen before, you can't just come into the trial saying, well, once a thief, always a thief. They stole before on this occasion, so they're stealing again. But if there's a specific way in which they steal, they leave some kind of a trademark, there's a pattern,
Your Honor,
there's something you can show.
as the
Let's
court is
listen.
aware, at the bench, I strongly objected to the state's scope of rebuttal. In no way did we go into prior bad acts, any issues of 404B evidence. I think the state, after hearing the proof thus far, has regrouped. I would assume they met with her because before she blurted out what she did,
And you need to be careful here.
Oh, yep, he's accusing the state. That's what he's
I
doing.
didn't say what they said. I said they met. And she said,
Again,
I'm going to be very careful.
Whether you know what happened.
Okay. At this point, there was a statement made by Ms. Kristen Wilson Chapman of clearly 404B evidence that we have not had any notice that was going to be used in this trial. It was not a subject of our case with Mr. Paschel. Obviously, it is incredibly prejudicial.
I knew that
I
was
can't
coming.
cross-examine her because we've not had a hearing to determine by clear and convincing evidence as mandated under Tennessee law whether it would be appropriate 404B. Now, if the court issued a curative instruction, I do not think that it would be sufficient in this particular instance. This instance is a case of he said, she said, and the credibility of Mr. Paschel and Ms. Wilson Chapman is paramount.
I'm thinking
for this
mistrial.
jury.
I hope
The state
not.
chose, and I'm not making assumptions. I'm not
Oh, I hope
casting
not.
any aspersions to put her back on the stand to go back over what Mr. Paschel.
It's a
testified about.
rebuttal.
Now she has talked about other instances of abuse. So here's my dilemma. Do I ask when, how, where it happened, how it happened? What does she call abuse? I can't effectively cross-examine her. I do not feel a curative instruction would be sufficient. This is when you open Pandora's box. This is what the risk is. You know, the state chose not to show Mr. Paschel a single photograph.
She said
during
that
his cross.
she had a bruise from
But yet in
previous abuse.
rebuttal, we're going back over this grounds that the state had an opportunity to do it. The issue of prior
Nope,
abuse
it hasn't changed.
in this context of my client choosing to take the stand is something that cannot be cured, and we are respectfully, we're not making any accusations, we're not casting any aspersions, but they chose to put her on. I'm sure they talked to her about 404B before, about 6.
How are you sure? How are you sure?
This bell respectfully cannot be unrung. The fact that we're having a jury out is created as soon as we just got started. Respectfully, my client is charged with a serious Class B felony, aggravated kidnapping. He's charged with assault. He's charged with interference with a 911
Please,
call.
no mistrial. Please.
We are doing everything we can to zealously represent
She was
Mr.
just
Paschel
talking.
within the confines of the rules. And the fact that we have now, and before she said it, she said, I don't know if I can talk about this.
Yep, she said that.
And she looked up and she smiled. Well, she chose to talk about it.
But the state didn't ask her to talk about
We
it.
are imploring the court, because again, this is clearly a credibility issue versus whether the jury believes Ms. Wilson Chapman or believes Mr. Paschel.
Not credibility, the pictures
so
are
now
there.
I am faced with a tactical choice on well, I've asked for a mistrial, but if you say curative instruction, I can't touch it. I can't cure it. I don't know what conduct she's talking about. It is clearly 404B. I was not afforded the mandatory requirement of having a hearing to determine by clear and convincing evidence whether this
Yep,
evidence
you can't
is
bring in here.
probative,
They ruled
whether
that
it
no
is
past
reliable, whether it is trustworthy.
behaviors were to be brought in.
But that inference is before this jury, and that bell cannot be unrung.
And the prosecutor
state
should have
called
told her
the
that.
rebuttal witness at her own peril. And it's significant to me that she testified in direct. She didn't mention it. I cross-examined her, and she didn't mention it.
You didn't
Now,
ask
after
her
listening
about
to
that.
Mr. Paschel's testimony, she's been in the courtroom a few pews away. sitting with her parents with the emotions flowing, a few feet away from this jury. She blurts out saying, I don't know if I can say this.
That's right. She blurted it
It's
out.
not the first time it happened. That is incredible because we had, that didn't come in at all in this trial. And we made a tactical decision to put my client on the stand because we didn't receive any notice of 404B. You were here when we did the moment invocation. And the court asked if we'd explain to him the strategic implications. I asked him if we'd explain the strategic implications.
Okay, she was never
And
asked that.
At this point, at that point in time, it was a he said, she said. And Mr.
And it's still
Paschel
he
felt
said, she said.
comfortable in giving up his right against self-incrimination and his presumption of innocence. If we had
Would you
known
shut up?
that
You've
there
made
was
your
going
point.
to be
Let the judge rule,
404B
please.
evidence interjected, that decision may have been dramatically different. So I am, and I think sometimes defense counsel precipitously to protect the record makes a motion for new trial. I've made some before during the course of this trial. This is not a preserve the record motion. This is, I want a fair trial commensurate with due process. The court has been very fair for both sides. The state has tried a good case. This was a calculated risk. We cannot unring the bell. I respectfully request that at this point, the court grant the motion for mistrial.
Thank you, Mr. Rogers. General?
Well, Judge, first and foremost, I would like to note for the record that nobody from the state of Tennessee
Thank you.
met with Miss Chapman at lunchtime. We parted ways right out here. I walked and got lunch and I sat in my office. If we need to have witnesses to come and testify to that, then that's what we need to do. Second of all, as we talked about at the bench conference, I did not show those photos to Mr. Paschel.
Sorry,
because
Holistic.
Mr. Paschel
Go out and
plainly
come back
testified
in.
that he had no knowledge of those injuries and was not going to have any information to give me with the photos. I used the
Okay,
photos.
let me move my logo. Hold on.
I've ruled on the scope of rebuttal. This is specifically about images and pictures that were on the phone.
And the reason that I asked her to specify what exactly was deleted from the phone is because Mr. Isaacs, on numerous occasions now, has argued, well, she must be lying about that because she said that she had, and he asked Mr. Paschel about it specifically. He said, did you delete text messages? Did you delete this? Did you delete this? Mr. Paschel said no. He then said, you heard Miss Chapman say that she had a picture from that night. You know, if you deleted it, how would she still have a picture? So I was trying to just make sure that the record was clear that she never testified on direct that he had deleted every picture from her phone. She said text messages, voicemails, and some photographs. I did not elicit that testimony. And I would.
Yes, it can be tried again.
That's all I want to say.
As long as
I
it's
did not
released
elicit
without
that testimony.
prejudice.
Nobody from the state met with this victim. Everything that I asked her was well within what Mr. Paschel testified to. I do not believe that a mistrial is appropriate at this point. She did not say he beat me before. She said it's photographs of marks from him before. And so that's, yeah. And I do believe that a curative instruction, would be fine.
Briefly, we are saying it's clearly rise to the level of manifest necessity, which is the standard under Tennessee law. And courts typically, if it's the same conduct, exclude it, even if we had received notice. So first of all, it is evidence that, without being presumptuous and saying what the court would do, our courts routinely would do. For example, in the body cam footage, part of it that was never played, she indicated to the officers that he has never done this before. I mean, we've just, and again, I'm not, and I want to be very clear, making any accusations toward the state. I am not accusing them of anything whatsoever other than the risk of recalling.
You
this witness
said they
who had
met
already
with her.
had testified on direct and cross. But this is manifest necessity because that evidence, even if the state wanted to get it in, our courts routinely do not allow it when it is the same conduct. It's kind of like the 609 issues that we discussed. The state gave us notice of impeachment that we discussed. We had hearings. For her to say that she was a prior victim of domestic violence in a domestic violence case it is clearly manifest necessity, and it's done in the context of rebuttal. And think about this. I can't cross-examine her about it. I don't know when it
We
happened.
heard that
I don't know
before.
what the allegation of abuse was. So if the court decides to give a curative instruction, if it's just something that's de minimis, something I feel was overblown, something that Mr. Paschel would have an alibi for, I could explore it. But we're knocking on the door of closing statements, and then we parachute in unproven, speculative allegations of domestic violence, and I think the court should take into consideration the fact that if the state had tried to get it in, Tennessee courts would have not allowed it because it's the same conduct that he's on trial for. We've invested a lot of
guys, what do you
time and
think?
effort.
What do you think?
The state has invested a lot of time and effort. The court has invested a lot of time and effort. But this individual is facing a Class B felony. Obviously, 404B is a material evidentiary ruling, something that is taken very seriously in our rules of evidence and procedure. If he does not get a chance to explore, rebut, or whatever, and there's just a curative instruction, he'll be denied fundamental substantive and procedural due process. I mean, I want to say unfortunate. It is unfortunate for the state, but it's a travesty as it relates to Mr. Paschel. And again, when we did the moment invocation, if I said, she's going to say this, if you testify because you're going to do rebuttal, different issue. So I can't say I explained to him strategically that if you take the stand in rebuttal, they are going to get in prior acts of abuse. Because I will say for the record, I did not. And I will say for the record, if I'd have known it was coming in, he probably wouldn't have taken the stand. It's manifest necessity. I'm asking the court to grant this.
Okay, now you're not making any sense to me.
All right. We call balls and strikes here at Court TV. That's our job. If something
Okay.
is sensational, we acknowledge it. If something is terrible, we say that too, as we have today earlier with the cross. In my opinion, and I'm going to explain why, the court should grant that motion for mistrial made by the defense, and this is why. With prior bad act evidence, you can introduce it under limited exceptions. You can't have what is called propensity evidence.
That's
Once
right.
a batterer, always a batterer doesn't fly unless you have specific exceptions. And the rule does allow for some of that. If there's a certain way in which the battery takes place every single time, that could be one, for instance. But if you don't give the other side notice, it's considered an unfair surprise, and this can prejudice the jury. And typically, when you give advance notice as required under the rules, then there's a hearing before the court to see if it's admissible. And
But
here,
they didn't know. But
the
there's no
alleged victim in this
excuse.
case blurted that out. The defense had no warning. The state did not give them the required notice under the rules.
But the
that this
state
would be
didn't know
introduced
she
ahead
was
of
going to
time.
blurt that out.
And so now this is a big problem.
Yeah, he can appeal it.
I'm being told we're going to squeeze in a break. The judge obviously is going to consider these arguments in chambers and a way where they are here.
Oh,
And worst case
damn!
scenario, a mistrial is granted, and then they pick another jury and just start all over again. That is the worst case scenario.
Yeah, and get a new
here. Or the
prosecutor.
judge might do what he said is the other possibility, a curative instruction. So we will see. Stay right there with Court TV Live.
Oh my God. Oh no. Oh, do we know? Okay, do we think the state knew she was going to blurt that out? Do we think the state knew she was going to blurt that out? That's all I want to know. Do we think the state knows that she was going to blurt it out? Thank you, Ashley. I'm having fun too. I'm supposed to be packing, girl, but I was told to stop packing because he was coming to finish it up for me. So I'm going to stop. I don't think the state knew. You don't hit them both, eh, Marie? Yeah, but she's right about that, though. A mistrial can be granted, even though you can give the instructions, to strike that part of her conversation. That bell has been rung. So if they get a retrial, oh my God, why don't he just do the right thing and just, because now it's there. I don't think the state knew Crazy Cat Mama at all. Hi, Wisco. I just followed you on IG, sweetie. I just saw your, oh, it's okay. He's asking, the defense attorney is asking for a retrial. A mistrial because of what Christian said on the stand. So they were asking her about the bruises on the picture. And she stated, I'm not sure if I can say this, but talk about this. And she blurted out that one of the bruises was from a prior incident. And that's when the defense attorney jumped up. Yeah, the damage has been done. I think John is over in Court TV or he's watching it. I'm sure he's just that, that hurt them right there. They were going to conclude this today. See, she wasn't given the speech like Geoffrey has because it's his case. He has the right to testify. If he chose not to, that was his choice. She is up to she's up there as a rebuttal witness to the statements he made when he was testifying. So the defense attorney cannot cross-examine her on stuff that wasn't previously brought in. And he's correct on that part. Yeah, it'll be a better prosecutor. Yeah, it was one bruise she had, and she said it was from a prior incident with him. What is he paying her off with, though? Because he don't have any damn money. This is crazy. Okay, let me raise this. Let me put this back on.
And if you're just now joining us, first of all, we welcome you. And second of all, we have to say we are on the edge of our seats as the judge called a recess, sent the jury out, heard arguments from the attorneys in the case against former 90 Day Fiance star Geoffrey Paschel. It is very possible the court could declare a mistrial at this point because of what just happened on rebuttal. The alleged victim in the case essentially told the jury in so many words that the defendant has hit her before. She said he deleted photos on her phone of her with marks on her body from him. So the jury could potentially be thinking something very prejudicial, that if he has hit her on prior occasions, then he has hit her in this instance.
She was talking about a bruise that was on her, not just the pictures.
For a mistrial, as in my opinion, they should have. And while we're waiting for them to all come back in the courtroom, let me bring in our guest analyst on the program, John Mobley. He practices criminal defense in Columbia, South Carolina. John, what do you say?
Oh, that's who Mod 148.
Well, in this case, I agree with you 100%, Julie. A mistrial should be granted. There's no doubt about it. I mean, the defense attorney articulated the rule regarding 404B and prior bad act evidence accurately. The prosecutor really didn't have any legal arguments against it. And I think, the fact that this came out.
So you think the state knew?
So many questions and thoughts that come to mind. I mean, number one, the prosecutor, I cannot imagine in a case involving domestic violence.
Yes, Jay, I'm moving.
Any prior allegations of domestic abuse did not come up in the interview and the preparation of the alleged victim in the case. And you kind of have to ask that. It's kind of routine.
Right.
And when it does come up, I mean, the prosecutor has to make the decision as to how they're going to deal with it. Of course, first thing, you try to get it in, but you deal with all that pre-trial. You make the motion, you have a hearing on 404B evidence or prior bad act evidence, or even use it for impeachment, in which is the case it could be admissible. It never got addressed. And also, if it did get addressed privately with the alleged victim, I mean, it's the prosecutor's job to talk to your witness and say, here's the deal. These are things you do not say.
Yep.
You do not say things like this in the trial. It will cause a problem. And clearly that wasn't done, because if it was done, the prosecutor said, hey, we talked to her about this. We told her not to bring this up. You know, we had no control over that, but the ball was just dropped altogether.
Oh my God.
And the defense did
John,
an
thank you
excellent
so
job.
much. Forgive me for cutting you off. The judge is back on the bench.
Oh Lord, let's see what he has to say.
In my opinion, was not at all elicited by the prosecutor. I want
Thank
to be
you.
clear about that point. I think the prosecutor had asked an appropriate question, and I think she was surprised by the witness's response. I will note the response was very brief. It did not go into a lot of detail other than there being marks from a prior occasion. And it does not really, I think the prejudicial effect is lessened here because it still gets back to a statement that Ms. Chapman made. And still at play is her credibility. So the jury is really, in this case, they're either going to believe her or they're going to believe the defendant.
Yep.
So even if they were to consider this statement, it would still be a matter of whether they're going to believe anything that she had to say about the events that happened that evening. So at this point, I do not think that there is manifest necessity for a mistrial. The defense objection is noted. It's included in the record.
Sorry.
But I'm denying that request. In light of the court's ruling, will the defense be requesting a curative instruction to ask the defense to disregard that statement?
Oh, yes.
Yes.
Okay. I think that's appropriate.
And I guess I'm concerned about the remainder.
Hi,
of her
Selfie
testimony
Queen.
because her
Welcome.
statement was prefaced by, I know I probably shouldn't do this. So if I've got a witness that now we know is making
She didn't say, I know I shouldn't do this. She said, I don't know if I can talk about this. Stop putting words in her mouth.
I'm extraordinarily concerned if the court is not going to grant the mistrial. I would ask the court to admonish her outside the presence of the jury. And again, I've objected to the scope of this rebuttal. But you know, the curative
No, she wasn't on
instruction-
90 days.
Could the court share with us what you propose to do? Because it's obviously extraordinarily significant as we are going forward making decisions.
I'm going to tell the jury that they're instructed to entirely disregard the last statement made by Ms. Chapman, put it out of their minds, and do not consider it any at all going forward. Pretend as though it was not said.
And would you admonish Ms. Chapman, please?
Judge, I'll be completely candid with the court. That was literally the last thing I was planning on asking her anyway. I don't have any more questions for her.
Okay, very well. I do think it is appropriate. We all understand. And
He just
so
wants
we're
this
clear
over with.
here, and I'm not saying that there was any sort of curative admissibility taking place here, but it is worth noting that the defendant during his testimony.
Yep, she was honest about it
able
not
to
being
put
from
in front
that
of the jury
incident.
that his child died while under the care of Ms. Chapman. I'm not saying that that makes it okay what Ms. Chapman said. It does not. But I think that I think this has happened during both of their testimonies at this point in the trial, and I'll just leave it at that.
Yep. Because
It
he
is very
mentioned his
important
child.
going forward,
Yes, he
and
did.
I'm going to let Ms.
Damn
Chapman
sure
know, and
did.
any other witness that the state will
He
be
said his
calling
child
over
died
the
while
law, if they have
had
any
an incident while in her custody.
But I'm
He
instructing
did
the
say that.
state to speak with all of these witnesses. If there are more witnesses, there can be absolutely no discussion about anything that happened prior to the events in question here. We're here simply to try the case, what happened on the morning of June the
Hi,
9th,
Velvet.
2019. We can't be talking about any other bad acts, any other character aspects of the defendant. There can be absolutely nothing like that going forward. as we continue the proof in this case.
That's what Geoffrey said.
Is the state ready for the jury? The
Yep,
defense
we're ready.
All right.
Whoa, I'm surprised at that. John Mobley, I want to bring you in. You tell me, I keep worrying that this could present an issue for appeal. If
It
he
is an appeal
convicted,
thing, but let it go to
I
appeal.
worry that this could wind up coming back because of
Oh,
of
well,
this
let it
issue.
come back.
What do you think, please?
I think it should come back on appeal. I'm shocked that he didn't grant the mistrial.
I know the judge ruled
he-
wrong.
if
It should have
this
been a
judge
mistrial.
effectively denied the defendant effective assistance of counsel, because
Yeah,
now
it should have been a
there is new
mistrial. I
allegation
agree with that.
prior domestic assault, when he's on trial for domestic assault, and the defense has the Hobson's choice of either A, cross-examining the witness.
If he's
on
found
that
guilty,
allegation
then he
with
has
zero
grounds for appeal.
preparation, Zero evidence, or B, saying nothing at all about it and it goes to the jury unchallenged.
Right, great
that's
point,
a
no-
John. Thank you,
Instructing you to put that statement entirely out of your minds, pretend that it did not occur. Do not refer to it any at all for any reason during your deliberation in this case.
That's like seeing a
Ms.
train
Chamberlain,
wreck and
if you
then
please come
saying,
back to
oh
the
no, I
stand.
didn't see it happen.
Okay, Jenna?
Judge, we have no further questions. Pass the witness.
Amen. Cross-examination?
Yes. Good afternoon,
Good afternoon.
Ms. Chapman. The state asked you a series of questions regarding some topics. And some of them seem to be de minimis, some seem to be very important. For example, the state thought it's important to ask you who walked the dog. Mr. Paschel says he walked the dog. You say you walked the dog, correct?
Correct.
So we know obviously there's some disagreement in a lot of the things that we've heard here today. You would agree with that?
Yes.
You would agree that there are some things that are stubborn facts that can't be changed, such as we all know that you went to the brasserie, correct?
Yes.
We know that you were there for nearly 5 hours, you and Mr. Paschel, correct?
We were there for several hours.
Yeah, we know
Yes.
that you were drinking for that period of time for 5 hours served by your friend, correct?
He keeps saying
I
5
was not
hours.
drinking the entire time consistently, but
were
we
there
were
for 5
consuming alcohol.
5
yes.
hours served by your
He
friend.
keeps saying
correct?
5
We were there
hours.
for
Why
several hours
5?
and we were served by my friend. Yes.
And we know that at some point in time, there was an issue about phone records that Ms. Good asked you about, correct? She just asked you this a few minutes ago about text messages sent to Mr. Paschel.
She was asking me about those text messages. Yes.
And let's talk about that. There was state issued subpoenas for records, correct?
Yes.
Phone dump of your phone, that means it was a mirror image of the phone was created, correct?
Yes.
And this happened nearly a year and a half after the Saturday evening we're talking about in this courtroom.
Because he didn't turn the shit into a year later.
9th, 2019. This happened sometime October or November of 2020, correct?
Talk about this taking your client
I
a
don't
year
know
to
the
turn
date, but
his
it
shit
happened
over.
after I found out about
The
those
screenshots.
And when the state, you agreed to have the forensics on your phone, you knew that your cloud had been deleted. And I'm not talking about that night.
I should have been a
Saturday.
lawyer. I was going to
When
school
you
for it.
agreed
Seriously,
to
I
let your
was.
phone be subpoenaed, your cloud had been deleted, correct?
No.
You said earlier that the state asked you about this information and they couldn't, it was inconclusive because your information wasn't on the cloud. Do you not remember that?
No, I don't.
I don't believe that question was asked at all.
Well, I believe it was. Now, let me ask you this. After the subpoenas and the forensics, the truth of the matter is, Ms. Wilson Chapman, no one, that's what we've heard. We've heard from no witnesses, no one from Verizon, no one from anywhere, in any way, shape, or form, prove there was anything inappropriate about these text messages, correct? You're aware of that?
I don't think anything came back to prove or disprove those messages. I don't think they were able to determine.
Well, can you answer my question? My question was, they didn't prove that these were. Can we just, unless it's something.
Oh, he's getting flustered. Oh my God.
I got to tell you, I've been in courtrooms where judges would not tolerate disrespectful advocates like that. What defense counsel is doing with these speaking objections, arguing right with the prosecutor. If there's an objection, you articulate the basis, the other side responds. The court controls it all. You don't just yell and say, I think this should happen or that should happen. That is totally inappropriate. Counsel is never allowed to testify in a trial. So this is getting really sloppy, obviously very heated. And by the way, the state should have been up and objecting initially because he started out asking her things that were beyond the scope of rebuttal because he's confined to what was brought out when she did the direct questioning. Let's listen.
And the state showed you a copy of Exhibit 61, and may I approach? We'll show you that, Ms. Wilson-Chapman. And these texts span almost the entirety of the year from September, October, November, and December. Would you agree with that?
Those texts do, yes.
And you would agree that if they were sent from yourself, there are some statements and admissions that are different, contrary, or just completely inconsistent with your testimony today, correct?
I don't think those messages talked about our testimony or court case at all.
Well, on September 18th, where it says, I really feel bad about everything, Geoffrey, I think things have gone too far and I'm in too deep. I'm not sure how to make things right. You don't think that would be harmful if you acknowledge that came from your phone?
It would be, but those did not come from my phone.
Well, and let's talk about what would happen if you said that came from your phone. Did anyone inform you that if you provide false information during the course of the investigation, it is a Class D felony under Tennessee law that carries 2 to 4 years in the penitentiary?
I did hear you say that earlier. Yes, I am aware of that, but I did not send those messages.
So you're aware if you say these texts came from your phone, that would be a crime that carries 2 to 4 years in the state penitentiary,
Yeah,
correct?
no objection to that.
I'm nothing further.
Who is going to rest?
Thank you.
State rest and rebuttal. Will there be any rebuttal proof from the defense?
None.
Okay, ladies and gentlemen, the proof in this case is closed, and it's time now to proceed to the closing arguments in the case. During closing arguments, you'll hear actually 3 arguments. The state will have
that's
their
what he was
first
trying to
closing
do.
argument. The defense will then be allowed to present their closing argument. And then after that, because the state carries the burden of proof in criminal cases, they will be able to make the last argument to you. So with that, at this time, I recognize the state of Tennessee.
Yeah, they need to get a forensics person to actually examine both phones because her carrier couldn't prove whether or not the messages were sent from her phone or not. There was no record showing one way or the other,
Ladies
which
and
is
gentlemen,
weird.
a picture really is worth 1,000 words, especially in this case. A couple days ago, or yesterday morning, I guess, I came up here and I told you that through these witnesses, you were going to learn that the victim, Kristen Wilson, and the defendant had been in a relationship. They were engaged.
Yeah, Shaylin, the defense asked for a mistrial,
June 8th of 2019.
but it was declined.
they went
It was
and had
denied.
dinner. Ms. Wilson has never denied the fact that they went and had dinner, that she had alcohol. This whole case, we keep hearing about how much she had to drink. What you never heard was her deny that they went to dinner and she drank alcohol. Not
I
that.
think so too, Cheryl.
What she also told you is when they got back to the house, after that, they planned on going and meeting some friends. They were going out to another bar. Nothing wrong with that. It's a Saturday night. But what you know now is that she never made it to that other bar. Because of this defendant, because of what he did to her. She didn't get drunk and fall downstairs or fall outside of her house. Ladies and gentlemen, the best thing you get to take back to that deliberation room with you is your common sense. We talked about it in voir dire. These photographs.
Thank you. Put them up there.
1,000 words.
Let them be the
There
last
was
thing
more
they
words
see.
than any of us attorneys can possibly give you.
Let it be the last thing they
She
see.
didn't fall into a door and get a knot the size of a fist on her forehead. She didn't fall into some bushes.
Jeffrey's not even looking at the pictures. Look at
and
it.
have bruising on her hands, scrapes on her elbows, scrapes on her knees, bruises on her foot, bruises on both arms, scrapes down her back. She didn't fall into a door front and back.
Thank
She
you.
also has bruises on the back of her neck, scrapes down her back.
30 years.
That's what the defendant
If he's
wants
found
you to believe.
guilty, 30
he wants
years.
you to believe that this was all because she got too drunk.
The maximum
Ladies
is
and
30.
gentlemen, you have the body cam and evidence where you see Officer Johnson initially encounter Ms. Wilson. And I would ask that you watch that when you get back into deliberation.
Yep, watch it.
When you see her huddled up in the floor, curled up, scared to death, listen to her. Listen to her answer questions. And then you be the judge as to whether or not she was so drunk that she caused injuries like this to herself over and over and over. Now, I want to go back over the actual charges that we're dealing with again before you take time to deliberate. And like we talked about the first yesterday, you're going to actually get some instructions from the judge on what the law is and the law is you have to apply in this case, but I want to go over a little bit of that with you as well. Aggravated kidnapping. What you're going to read in jury instructions is that for you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt two things. That the defendant knowingly confined another unlawfully so as to interfere substantially with the other person's liberty, and that the victim suffered bodily injury during the removal or confinement. You're also going to hear that the law says a removal or confinement is unlawful if it's done by force, threat, or fraud. Now I'm going to go back and hit on some of the evidence that you heard in this case in support of this. I want you to think about when Ms. Wilson's on that stand. And when she said the very first time he grabbed her by the back of her head and started slamming her head into the floor, she screamed. She tried to get away, and she couldn't. He's bigger than her. She said it. He overpowered me. Nothing I could do. Drug her from the kitchen into the living room. She blacked out here and there, went upstairs. She said that this went on for what she believes to be about maybe 30 minutes, until finally she came to, and she was sitting on her couch. Blood was dripping on her couch. And he said, hey, go wash your face. Follows up to the bathroom, won't turn the light on, so she can't see her face at this point. She wipes it off as best she can and says, hey, go to bed. So she did. I want you to think about why she said she did that. She did it because she was so terrified that he was going to keep attacking her. He took her phone from her, took her car keys. She had nowhere to go. She was still in the clothes that she went out to dinner in when she took off running at 2 a.m. barefoot to her neighbor's house. Still in the same clothes. She didn't go and lay down with the defendant and calm down after everything had happened. That's just simply not what the evidence has shown. She ran out without her phone, without her car keys, without her purse, without anything. 2 a.m. I want you to think about where he was when she told you that she was laying in bed pretending to be asleep. He wasn't downstairs. He wasn't in
Yes,
the
from the
room.
Young and the
He was
Restless.
sitting
Yes,
on the
him
edge of the
too.
bed where she was having to lay there and try and remain conscious and try and make sure that this wasn't going to keep happening to her. She couldn't leave. And she sat there for nearly 2 hours while he went through her phone, disabling it, until finally he got tired and he went to lay down. And she took her chance.
It wasn't forensics. It was
Ran
her.
in the neighbor's house.
It was her carrier.
You heard Miss
They
Goose.
subpoenaed it, so they needed
Heard
a
her
forensic
testimony
person
of
to
how
look at those. I
Miss
guess
Wilson
they
was
didn't
when
do
she
that
came
from
to
what
her.
I
Well, she's
hear.
terrified. They wouldn't even open the door for the police initially because she was so scared that it was him coming after her. You'll see her on that video cowered down behind the cabinets in the kitchen. She wasn't angry, belligerent, jealous. She was terrified because of what he had just done to her.
No, she hit herself. She fell. She
Again.
did that.
Ladies and gentlemen, use your common sense, okay? The defendant's version of how Miss Wilson sustained these injuries simply does not and will not add up. Think about what he said on live cam.
Oh, we got another missing
He actually
person.
showed the officer, oh yeah, I was maybe around kind of in this area of the wall. Not the door frame. Like he told you today. He was actually looking at an area on the wall. And when I asked him about that, he said, oh yeah, well she did it there too. She's doing it everywhere. Bang her head everywhere against the wall. Think about how he never told the officers on scene about her falling into the bushes and him having to pick her up and then going and laying down. No, I'm saying he said, oh, this just happened. She ran out the door and then here you guys are. Think about that stuff, guys. Think about how this is a defendant who, in multiple prior sworn depositions in the months leading up to this, denied he was even in a relationship with her. Denied texting her, denied dating her. But here, he wants you to believe that they had the happiest of relationships up until this point. And it's kind of unclear, honestly, from his testimony, what he really does want you to believe their relationship was at that moment. Because initially, they were life partners. Then, as the testimony went on, well, they were kind of on the outs right when this happened. Although he was staying with her at the time, had a lot of stuff in her home. He also wants you to believe that in that particular moment, they were on the outs. I want you to think about how Mr. Paschel couldn't remember a lot of stuff.
Nope, couldn't remember a lot of stuff.
He couldn't remember what he said in a deposition 3 weeks prior to this.
Now, I'm not sure if he's going to go into custody right away, because if he appeals, maybe not, and maybe he would have to put out a
But
bond.
you sure could remember what he wants you to believe happened that night. Ladies and gentlemen, the defendant committed the crime of aggravated kidnapping when he made Kristen Wilson go lay down and he sat at the foot of the bed so she couldn't leave for nearly 2 hours. She had no way to call anybody. She had nowhere to go. She was trapped in her own home. Under the law in the state of Tennessee, that is kidnapping. And whether or not she sustained bodily injury, I think that's pretty apparent here. We would ask to find him guilty as charged as to that count. Second count, domestic assault. Again, we've heard testimony that Ms. Wilson and the defendant were in a relationship for 2 years. That he was living at her home for a good portion. They were engaged. And again, I think the bodily injury here is pretty clear. It also asks to find him guilty as charged on this offense as well. Finally, count 3, interference with an emergency call. Ms. Wilson told you He took her phone. He disabled it. So what was the only choice she had? She had no other way to get help. She had to go run and ask somebody else to call. Guys, you also find him guilty as charged as to count 3. Now, ladies and gentlemen, I want to talk to you once more about this beyond a reasonable doubt standard that we hear so much about. Okay? As you're going to see in the instructions, the law defines that as to a moral certainty. Can you go home at night and lay your head down and rest comfortably with your decision? Ladies and gentlemen, you can rest comfortably knowing that these were not self-inflicted wounds. These are not injuries caused by somebody falling into a wall or a door frame or a bush. They're simply not. Kristen Wilson took that stand twice, and she told you exactly what happened to her.
Yes, she did.
She told you how she got these injuries. We ask that you find the defendant guilty as charged, all 3 counts. Thank you all for your time and attention over the last couple days.
Thank you, Thanks, Bud.
Woo!
Can we switch over to the screen, please? Good afternoon. On behalf of Geoffrey Paschel and Mr. Ammons, I'd like to thank each and every one of you for your patience throughout the course of this trial. As I said at the beginning, an opening statement is a roadmap on what the proof is going to show during the course of a trial. Now that journey is over and we're at our destination. And now comes the time when, after hearing the proof, looking at the evidence, that this case will be decided by a jury of Mr. Paschel's peers. But in the past few days, there has been a lot of talk. You've heard a lot of testimony.
Oh my God.
You've seen a lot of pictures.
Please don't bring up
And
the
now
text
comes the
messages
time
again, please.
The issue of Mr. Paschel's freedom, his presumption of innocence, passes from me and the process in this courtroom to each of you. And we talked about what an awesome responsibility that is when we were talking with
Thank you,
Geoffrey
Rebecca. I'm glad
And
you're
each
here
of you at that
too.
point said, when you looked
Yes,
at Mr. Paschel,
Velvet, he
as the
testified.
law required, you presumed him cloaked in his presumption of innocence. Now, you've also learned there's a lot of moving pieces to a trial.
Okay, I'm blocking you, Cody Peens Balls.
It's
Don't come in here with
something
that
that's-
bullshit.
Sometimes it works very smoothly. Sometimes, like audio devices, it works sporadically and you need help. Sometimes the IT information won't work. Sometimes we have to ask you to be excused while we're talking about evidentiary issues. But the point is, there's a lot of complexity that you have to consider. And at this point of the trial, I want to be very clear about one thing. You heard 2 different versions on what happened on June 9, 2019. You heard Miss Kristen Wilson Chapman sit in that chair and tell you what she said happened. You heard Mr. Paschel decide to forego his presumption of innocence because we don't have to prove anything under our system of justice. And he let himself sit in that chair and be poked and prodded by this prosecutor and asked every question, whatever. But now that the road goes from North Shore to the Brasserie to here in this courtroom, one thing I want to be clear about, and that is the pictures depicting injury to Miss Kristen Wilson Chapman. As an individual, my heart goes out to her. The defense team, it's not easy to look at pictures that way. But being a juror sometimes can be a tough job. But it can be a rewarding job when you follow the law.
Thank
and
you,
the
Renee,
facts.
for the super
But
sticker.
what the prosecution wants you to do is look at the pictures and disregard everything else. In fact, under the state's theory, we don't need you.
God, he takes forever.
We don't need him. We don't need a judge. We're going to look at those pictures and we are going to rush to judgment and we are going to convict this man without no discussion of motive. Doesn't matter where they've been, what they were doing, whatsoever. Doesn't matter if there's text messages
Yeah, I blocked
that
it.
say, oops, sorry this happened. We want you. What did she tell you? I want you to look at the pictures. Well, here's what I want. We want, on behalf of Mr. Paschel, you to be, we want to be transparent. We want you to look at all of
Thank
the
you,
evidence.
sweetie. I love you too.
We want you to look at those injuries. Now, I have learned during the pandemic and a lot of things not to get on Google MD or to ask questions. You pretend you know more than you.
He's been sitting
think
over
you
there
know
being a
about
pump his
medical
ass with his
issues, but
client.
one thing's pretty certain from having 4 children. When you have bruising, it can present itself in a lot of different ways. Bruise is a term for a hematoma, which means that's where the
Well,
blood
Cooch, you're going to have to send me a
capillaries
DM and let me know what
comes
name
from.
you're going to be under.
And as a bruise or a hematoma ages under ecchymosis, the skin becomes darker, the wounds become bigger. And during this very courtroom where you're sitting, jurors sitting where you're sitting, now no juror, it's kind of like Star Trek, has ever gone before and sat in those pews, because before the pandemic, you all were in the same chairs and that was the jury box. But there have been cases involving significant injuries, horrific injuries. And again, I am not, will not, and please don't construe anything I say as in any way being demeaning to Ms. Kristen Wilson Chapman. But when you look at those pictures, you factor in bruising, the hematoma, you factor in the ecchymosis that happens when things become more pronounced. If you notice the pictures when it first happened, there's a pump knot. There's some bleeding right here.
Oh, some bleeding. Hold on. Let me show you the bleeding again.
And then
He
in
said
terms of
some.
how the
Yeah,
injuries
it's just a little bit.
happen,
Hold on.
you
There's
heard
the
2
bleeding.
different versions. People sitting in that chair,
Look at that.
raising their hands, swearing to tell the truth.
Some bleeding. Okay.
Newsflash.
There we go.
Someone did
Let me help him out since he don't want to show the
And
pictures.
some things, the
Let me
stories you
help
can
him.
reconcile, some things you can't. But let's look at what the proof was as it was presented by the
Oh,
state.
damn. Sassy, you are on one
One,
today.
as we said, the opening statement's like a roadmap. We all were in agreement. It was Saturday night, June 6th.
I haven't been
2019.
cursing, so I've been good.
A couple was engaged.
Yes,
They
that's
got in the car at
that's
6
what he
o'clock,
did to
go
her,
to a
selfie
bar and
queen.
grill called the
You know, a little
Brasserie
bleeding.
on
She ran
North
into
Shore
a
of
door.
West Knoxville, Tennessee.
Just a little bit.
We're on the same road. We know they got there, and Ms. Good asked you to use your common sense. I will tell you, it's been a long time since I've been at a bar and a restaurant.
He goes back to that damn bar
for 5
again.
hours.
They've already
And
said
you
she
know,
wasn't
they split
intoxicated.
one entree, and we know they were served by a friend, Miss Wilson Chapman. And here's where the story, as we're going down our opening statement and we're going down North Shore, it starts to diverge a little bit. Because Mr. Paschel is saying, we were there, had a enjoyable, great night, but
Mr. Paschel is an asshole. How's that?
He's not pointing the finger at her and saying she was a drunk. It wasn't me. I'm saying what he said was, by the time we left at nearly 11 o'clock, she should have drove. I should have drove because we had been there 5 hours.
Okay, Selfie Queen, I just subscribed. I forgot to do it this morning. I just subscribed to your channel.
Start to verge, which makes more sense. Was it a normal dinner where people just had a few drinks, didn't drink a lot, and then they sat and tied up a busy table on a Saturday night where the server couldn't turn her tables or make any money? Or, your common sense, were they enjoying the evening, stay too long and drink too much? Well, that's what Mr. Paschel says happened. So
I'm not going to show the pics
they get in the
anymore unless he
car.
pisses me off some more.
Again, you heard Mr. Paschel saying we were both too intoxicated to drive. And he talked about.
He didn't say that.
It was just a normal evening with a couple that had some problems. But it's interesting when you look at the state's story, other than the pictures, there's not a lot of substance.
Hi,
in anything
Joanna.
that happened. I want you, when you get back there, I challenge you.
I challenge
to tell
you.
me any details you learned from the state other than a fight over who walked the dog as to what happened. Because Ms. Chapman said she didn't really talk about what they talked about at dinner. Didn't talk about the dynamics of their relationship, whether they were on again, off again, or getting back together. Said they didn't argue, but they were there for nearly 5 hours.
5 hours. They have numerous drinks.
We're all in agreement on that. So
No, we're not in agreement. You're the only asshole that's in agreement with the number of drinks. She said several hours. Geoffrey said 5 hours. Make up your damn mind. Pull the tab. See when you first put it in and when you paid the check.
It's kind of odd.
They're unprepared.
The stories start to diverge based on that seemingly innocuous point. But then we get to what brings us all here together in this courtroom. What happened next? Well, Miss Kristen Wilson Chapman says that after she walked the dog, they hadn't been arguing, even though Ms. Gooch said that she said they
Yep, they should have called the bartender. Thank you. They're not prepared.
Intoxicated.
Neither side.
And suddenly she walks in the door, her fiance, Geoffrey Paschel, father, and I guess we didn't want to get into.
They haven't showed the
reality
jury,
TV.
so I don't know. I'm not sure. I can go look it up.
We wanted to talk about the courtroom, whatever, but a person that is a reality TV personality who is a responsible person. You've heard the state over and over talk about, you do interviews, you're on YouTube or whatever.
I would want to convict him just listening to his attorney. Shit. Hi, Wisconsin gal.
Story was that suddenly he lunged at her, grabbed her by the head of the hair, and pummeled her head.
She said from the back. She didn't say about a
30
head.
to 40 minutes.
See, he getting shit wrong.
And she can only remember 50% of it.
It's irrelevant. Yes, Selfie Queen, it is.
And she said she was drug upstairs, but she doesn't remember getting upstairs. Then she's in the corner of a kitchen, but she doesn't remember how she got there.
Yep, she said that.
And there's some blood under her lip.
Correct,
And
Celia.
there's some scrapes on her knees, in her hands.
Bruises.
And she goes to the emergency room. Now, hit pause. Mr. Paschel sat in the same chair, and he was at the same restaurant, sitting at the same table, and he tells you, no, she didn't walk the dog. That he walked the dog, and he's on the phone talking to his son.
Yep.
And he walks in, and she goes from 0 to 110, and she is angry.
So he had one mark on his cheek, and she's got all of that. Should I show it again?
You can tell there were some bristles that went up. And
Shit, I drank a whole bottle of Snoop Dogg.
Mr.
I'm
Paschel
wasted.
says she came at him. She
And
was
champagne
angry,
is not strong.
Kind of pushed around, kind of cat fought, scratched, and that she ran out the door. She bounced off the wall. That she was intoxicated, and he was intoxicated, and that she hit her head. She stumbled out.
She hit her head, bounced off the wall, rolled out the door, hit the concrete. Damn, she's a klutz.
Completely consistent with the pictures. I would venture to say that if somebody, based on my common sense, knowledge, and experience, had grabbed someone by the head, pounded their head,
Sorry, I'm not laughing. Yes, I
to
am.
40 minutes, the injuries, the nose would have been broken, the orbital eye sockets would have been broken, bones would have been broken.
That's not
They would
true.
have been thrown up,
That's not
thrown
true.
down.
That's not true. That is not true.
But if you ran into a door frame, you bounced off the wall and you fell, scraped your knees going down in front of the house, you would have a pump knot. And that's why the state had to keep showing you pictures day after day after day as the ecchymosis
There we
became
go.
pronounced.
Size
It
of a
looked like she
fist.
had
Size of a
black
fist.
eyes, whatever.
There we
That's
go.
the hematoma as the blood rushed to the capillaries.
There we go. Size of a fist.
But what's interesting under Mr. Paschel's story, and you have to reconcile this, is it more likely that both individuals had drank a little too much since they stayed there for 5 hours? And he told you what they talked about. He told you it was pleasant. They were talking about reuniting. They were on the skids. He gave you a real version of somebody that was telling the truth.
Thank you.
Great liars give details.
No
Good
reason.
liars don't. Facts are stubborn things. I mean, she didn't really add anything other than the pictures to the story and walking the dog. Now, there are no other injuries. The injuries I would submit, and again, the pictures, my heart simply goes out to Kristen Wilson Chapman.
We
with the
would definitely
exception of
have to meet in the
falsely
middle.
accusing Mr. Paschel, are consistent with what Mr. Paschel told you in that chair. And in fact, they're more
He was
consistent
drinking double
than
whiskeys,
someone
yes,
getting
with
beaten
Coke.
for 30 to 40 minutes.
And
Remember,
Geoffrey
half of
cannot
it.
drink. He got in trouble in Gatlinburg.
thing-
He gets in
you're-
trouble in
you're-
every
you're
place
trying
he
to
goes.
fact.
Got kicked out.
Is the flashes in her memory because of her injuries?
Yeah, he
Or
beat
is it
that
because
woman.
of the 5 hours of alcohol? Are
What
you
does
willing,
Southern Queen
the
say?
state's asking you to look at some pictures and find someone guilty of serious felony beyond reasonable doubt based on the pictures? Now, you would think
Key Largo.
if you
Ooh,
were injured
I
that
went
severely
to Bermuda,
from somebody,
Bahamas, come on.
that you would have seen proof from a medical doctor, an
Went down
ER
to
doctor, a
Bermuda.
medical record, an x-ray. Again, we don't have
They
to prove
did.
anything. You don't, one of the greatest birthrights our founding fathers gave us, we never have to prove our innocence in a court of law. So I didn't have to go hire an expert regarding medical injuries, whatever. All you have to do is call the doctor that saw Kristen Wilson Chapman on that night and say, well, in your medical opinion, to a reasonable
Why didn't you call them?
certainty, tell us what happened.
Why didn't you call them?
And could it be that
You
what
had the
happened
same
was
right
she ran into a
to
door
subpoena them
and
as
insisted she had
witnesses
a
as
pump
everybody
knot?
else did.
And because of ecchymosis and the hematoma, that 2 days later, it looked like the entire face was bruised. I don't know.
Oh my God. Yep, she kept beating herself. She kept hitting herself
No.
on the door.
In criminal cases, and you hear if you watch TV about motive. Leonardo da Vinci said every action by man is prompted by a motive. You think about it, why we do what we do. Are you mad? Murder cases that have been tried in this courtroom. Why did someone shoot somebody? Why was there a fight? Was there jealousy? What was it? Under Miss Wilson Chapman's version, after she walked the dog and was suddenly attacked from behind for 40 minutes that she remembers half of, there's no motive. Because I asked her, I said, were you all arguing at dinner? No. Did you argue when you got home? No. Well, you told Miss Gooch that you were arguing. No, I didn't say that.
He's talking to hear himself
So
talk.
Mr. Paschel, father of four, reality TV star.
Yep, he should have
just
subpoenaed the
suddenly out
doctor.
of the
Exactly.
blue, violently attacked her for 40 minutes. Or if
I mean,
we
subpoenaed the doctor, not the
rely on
attacker.
common sense and listen to the age-old words of Leonardo da Vinci, every action needs to be prompted by a motive. Is it more likely that she was upset because she saw Mr. Paschel
Thank
talking
you.
on the phone and they had
He was
issues
checking on the
with
dogs.
fidelity
That's
and
what he was
jealousy,
doing.
And they shouldn't have stayed at the brasserie for 5 hours drinking. And then she got jealous and they had an argument and she ran out and she hit the door and bounced off the wall. that's a motive as to why this happened, other than we had a great dinner, which we don't know what happened at dinner. We also don't know what the doctors told her about her injuries. Because the state didn't want you to look beyond the pictures. And then we had the text. Mr. Amos, if you could. And if you see the text,
The prosecution didn't take that long.
Tonight that we're talking about, and on the 13th, there was some modification where there was a change in sharing location. Then,
Yep, he said she nibbled, she had some shrimp
2 months later,
and nibbled on his french
happy belated
fries.
birthday. It's been so long, I really miss
So
you.
that's eating, right?
A week later, I really feel bad about everything.
Yep, they let the
Geoffrey.
ball
I think
drop.
things have
They
just gone
both
too
should have called the
far,
doctor.
And I'm in
Have
too
her
deep.
medical stuff.
I'm not sure how to make things
That's all
right
they
with
have to
you.
do.
I had to get a new phone, by the way. The next day, really looking forward to seeing you today. Hey, was really looking forward to seeing you today. Hey, sorry for the late text and thinking about you a lot. I feel like I'm just
Hi,
saying this
Zelda.
a few weeks later, which is
I'm
3 months
trying.
after
I want to
June
mute
9th.
him, but I
Really wish you
can't.
would have ignored me.
He's taking too long for his closing argument. This is why, but the prosecution can get up and go after
5
him
months.
to
You should have
rebuke
responded to me. This is my fault.
and they'll get
Your
the
fault
final
by
say.
acting like you're above me. I told you not to believe me. All you had to do was take care of me. This has blown up now, and I can't stop it. In fact, I don't even want to from now. I'll do everything I can for you.
That sounds like some shit that Geoffrey would write to his damn self. That's my opinion. He could have had another phone and sent those messages. Subpoena everybody's phones. His sons, his ex-wife, Varia, everybody. Oh, I didn't do that. That's court TV.
Back to me. Good luck proving everything. Erase the pics and texts. I'll tell the truth. And then, even though there were text messages that were sent sporadically after this happened, you heard Mr. Paschel said a few feet away to you, and that's
Don't know if
saying,
she had bushes, but the neighbors didn't hear anybody out there fussing and screaming the way Geoffrey said she was out there doing. So that's lying.
You
He
heard
said, she
Miss
said.
Kristen Wilson Chapman say once again, all made up.
She got married. She got attacked in June, and she got
And
married in
there was a
October the same year.
forensic phone analysis. Now, this is not the Scooby-Doo.
That's true. That's
We're all
true,
right.
Rebecca.
Subpoenas, Verizon records,
I didn't mute him. I
everything
swear.
sent to the state of Tennessee, its representatives, to
Yep,
determine
rip them apart.
whether
That's what she's good at.
these text messages were legitimate, because
Not-
they would contradict that there was a
not
problem
questioning.
and this happened this way, whatever, or not. And you heard Miss Wilson Chapman tell you it came back.
Yes, we
inconclusive.
could have, because we know what we're talking about.
After all the analysis, putting it
And
under
we're
a
going to
forensic
meet this Monday
Hubble
coming up, guys.
telescope.
Sorry.
Can't prove that they're made up. But you know, it's interesting. Not only did we not hear from the doctors, medical proof, et cetera, no one came here to tell you that.
Why
those
didn't you
messages
subpoena them?
were Not correct,
You could have subpoenaed them.
that they were fabricated, that they were nothing but somebody that was having.
I don't want to
buyer's
break my
remorse
computer
about what she
screen. I'm
told
sorry, I
police
would.
On June 9th, 2019. So again, what was the motive in terms of June 9th, 2019?
Geoffrey was
Now,
a
let's
drunken
talk
bum,
about
and he beat that woman to a
burden of
pulp.
proof and what the state has to prove for
That's what happened.
all 3 charges.
Because he saw her texting her
kidnapping,
friend.
domestic assault, and interference with the 911 call. Now,
Yep, he could have called the doctors his damn self.
and we were doing more dire. Mr. Paschel sat there at that chair, cloaked in the
Oh
presumption
God, like
that-
me to strike him.
And so now it's the state's job.
Yes, he's
Again,
still
Mr. Paschel
talking.
didn't have to prove anything. to try to convict him and provide you proof beyond a reasonable doubt. Now, the issue is, can they move the arrow to be level? And the judge will instruct
Neither
you
side got a medical
on the
report.
definition of reasonable doubt. And we
Maybe
talked
she's gonna
about
pull
what a
one
high
out of her
standard
sleeves.
is
I
in
don't know.
our system of
But
justice.
if there's an
example,
appeal and he wins it,
to
well
stop a
then
vehicle,
they better
if
get some
you're
doctors in there and some
neighborhood,
real forensic
if
people
you're
to dump them
speeding,
phones.
the law enforcement officer has to have reasonable suspicion. They got to move the
Yes, she
needle
did.
that much.
She damn sure did.
Then
For
after
abuse.
doing an investigation
That's a
to
prior
arrest
act,
somebody,
and he couldn't bring
you
that
gotta
in.
move the needle even more and have probable
His
cause.
other girlfriend, abuse.
That's when the
Him
government
and
is
Mary,
intruding on our fundamental
fighting.
freedoms and our liberties. Then in a civil case, like some of you indicated you've been on the jury, you move the needle anymore.
There was none.
And you have to have
No
a
forensic
preponderance
expert,
of the
no
evidence,
doctors, no nothing.
51 to 49% to prevail. If they're going to take our children, they being state, the needle has to move even farther, and the standard is even higher, and it's got to be by clear and convincing evidence. So pull us over, driving down the road, law
I
enforcement.
miss what my 148 said. Yeah, he blinks a lot. He does.
There has to be a finding by clear and convincing evidence. But in a criminal case, whether it's Mr. Paschel, whether it's myself, whether it's one of you, a loved one, the state must prove.
He got up there and talked about his son and the sad fishing.
So
Jeez.
she said here today, after hearing all of the proof, the testimony from both Mr. Paschel, the testimony from Mr. Wilson Chapman.
We need
your
the
job
squirrel.
is to determine whether the state move the needle from this
We definitely need the squirrel.
spectrum, where he sits there cloaked in his presumption of innocence, all the way.
I have
across
stopped paying
the road
attention to him. I'm serious. I'm waiting for him to
beyond
shut up.
reasonable doubt. And I would respectfully submit that when you look at the evidence,
Shit, I wasn't even drunk and fell down the stairs in my home. Cracked it on the floor. You had to get stitches on the side of my eye.
they did not prove that Mr. Paschel did what they say he did under their theory.
Paschel. Why do you keep
Let's
saying?
talk about why.
He can't even. You got me saying his name wrong.
Now, Judge Hickson is going to tell you that reasonable doubt is the doubt created by the investigation of all the proof in the case and
It looks like she hit a wall.
an inability after such investigation to let the mind rest.
Maybe because he slammed her into the wall.
As to the certainty of guilt.
So she hit a wall and a
Doubt is
door.
doubt based upon reason and common sense.
Yep, they need all the phones that were involved.
Impartial consideration of all of the evidence.
Yep, and the police gave her
Yes.
permission to go with the neighbors instead of going in the
Are
ambulance.
there reasonable doubts in this case? Absolutely there are. Because Mr. Paschel and Ms. Wilson Chapman.
I have some duct tape,
testified
guys.
on some
Well, I got
points very
packing
similar
tape.
And then dramatically different.
Blah blah.
But what is important,
Same stuff.
as Leonardo da Vinci said many years ago, every human action is prompted by a motive. If you buy the state's theory, Mr. Paschel
Motive and alcohol.
went on a complete violent spree with no provocation whatsoever.
I'm
Not a
sorry.
bad word, not an argument. Just from 0 to 110. No. It did not, could not, would not happen.
He got him at the bar.
You heard
That's where he got him at.
that Ms. Chapman
He probably was standing on a corner passing
became
out his card.
jealous after being at the brass
And he
ring
went
for
have a
5
drink
hours.
and he hired him. He goes, look, man, I
And
can get you on court
that
TV.
because of the alcohol
I used to be
and
on
him
90
not
days.
pointing the
He can
finger
get you some
at
exposure.
Ms. Chapman, Wilson Chapman, we're pointing it at both.
Yep, the reasonable
Mr.
doubt is the
Paschel.
motive and
I think that's one thing that
it's
judges will
alcohol
talk to you about,
and motive.
judging the credibility of witnesses. Were they honest and open? And you should use your common sense in assessing whether the witnesses, when they responded to the state's questions and my questions, and when they looked at you on the witness stand, did they tell you the good?
He's
and
being paid.
the
He's got to
bad,
look
the
professional.
ugly? Did they make a story, tell you a story
Motive and alcohol.
or a narrative
That's
that was
reasonable doubt.
truthful and made common sense?
Let me see this again.
In this case, the state's theory has no motive. It's a violent attack.
She didn't know what
that
the
they
motive
can't
was.
explain
You
or
wanted to make
precipitated
one
it.
up?
The reason you can't explain because there's no.
Oh, I can't with him. Can somebody shoot him through the screen, please?
It doesn't make sense.
Damn, I never thought of that. The squirrel.
Conversely, Mr. Paschel,
The squirrel attacked him.
his story makes perfect sense. And one thing that is interesting, and I'm very glad that the state chose to play
The squirrel
the
attacked her.
body cam footage of the officers.
Yep, they could have called an expert witness
Because it's
too.
very significant. And
Jeffrey
when they
doesn't have
tell
the
you to
money,
go back
so
there
they want to
look at it,
piggyback
listen
on
to
what
it,
the state was doing.
don't just look at that, look at everything. Go back there and leave no stone unturned. But what's interesting, if things would have happened the way the state say they happened, that Mr. Paschel had.
Well, I'm gonna go get
beat
drunk
this
tonight,
woman
and I'm gonna beat some
for
people up and
35,
see if that'll
45
work
minutes
for me.
with her head against the floor, against the wall. Now think about that, but yet no broken nose, nothing else except the pump knot and an interior bleed right here. And you saw the blood driplets. Now ask yourself, were those the blood driplets for somebody that had been attacked?
Yes.
On the banner?
Yes, he
40
lost his
minutes?
son, and he
Or is
said
that
that
somebody
the child
that hit
suffered a
her
seizure,
head
whatever,
and
in
was
the custody
bleeding?
of Christian,
Mr. Paschel helped
of
clean
Kristen.
up.
So he actually said that on the stand. So that
Yeah.
should have been well.
It's up to you
The prosecution didn't want to call
to
that out.
determine what is more plausible as we
Yeah,
sit
he had
here
Botox done.
today,
He was
not
going to be on
standing
camera.
Tennessee.
Oh yeah, if you want to,
Now,
if you want to get
I
what do you call
have,
those?
and
Those
again, the
packages?
phone records, the text messages.
When you share vacation
Do the text
houses,
messages look
you
like
go
something that
listen to the
somebody sent,
presentation. That's what he's doing.
that were fabricated, or did it seem like somebody that after a few months or a few glasses of wine said, "Hey, happy birthday, I miss you. Hey,
We
I
all
screwed
do.
up for what I said."
Damn, the squirrel did it. Oh my
That's for you to
god.
decide.
Well, she damn sure didn't do it to herself, so the squirrel
Even
must
though
have
there's
did
the
it.
pictures, we have not a single medical provider that's going to put the pictures into any factual medical context.
Thank you, Doreen.
to say
Hi,
it's more
Doreen.
likely than not it happened this way or that way. And I would submit to this. I will tell you this. I don't think I'm the right person to tell you how it happened. I certainly don't think the state's the right person to tell you how
That
it
might be the
happened.
motive
But
right
what you
there.
need to remember
He
is,
lost
and
his
let's go back
child
to
while
that
under her
chart.
care. That could be a motive right there. He beat her to a pulp because
It is
because all of the
their burden to
aggravation
prove
and the
beyond
hurt.
a reasonable
That could be a
doubt
motive.
that
Nobody
Mr. Paschel
decided
did
to
what he's
argue that,
charged
huh?
with.
We're not gonna give the squirrel
One
a bad
case a
rep.
few
Sorry, Queen.
years ago, and it was interesting. The Court of Appeals, they normally send a case back.
Anastasia, I
whenever the
love
state
your name.
versus
That's my
Pack.
sister's
And they
my
said
sister's
at the end of the
confirmation
opinion,
name.
we
Anastasia.
speculate.
I'm
people
gonna have to
in-
object.
Thank you.
I'm objecting.
Thank you. Shut him up. Thank you. I was wondering how long. I was getting ready to call Court TV and ask for that courtroom. Shut him up.
Well, it's unusual to hear an objection during the closing argument. One was certainly made by the prosecution, I suspect because the defense attorney did start talking about case law and what it said, and I think is arguing things not in evidence. At least
Thank
that would
you.
be my assumption. Never assume. I know what that can mean, but certainly they are addressing it up at the bench with the judge. Just a reminder, both sides obviously have
Yeah, thank
rested.
God,
The prosecution made her closing
you're right.
argument.
You don't
We are
need to
now
visit me
currently
this
listening to the
week.
closing argument by the defense attorney, and then we will see if the state takes the opportunity to have a rebuttal closing or
Yeah.
not. That's always the opportunity provided to the state.
I don't know if they've heard of the show or saw him in the show, but Knoxville, I've been there. It's a nice size, but it's not that big.
And I want to be clear that it is our position. And back to the video.
Timeshare. Thank you.
What I
That's what
said
it's
is
called.
important, and I
Timeshare.
agree that you should look at it. If you look at these two versions, which are hard to reconcile, one thing's important, and in some cases, there's a instruction about flight, but it's not in
The
this case.
cops
which means
arrested him.
basically if you run, that can be some evidence of your guilt. But I would submit to you, if Mr. Paschel had
Thank
violently
you,
attacked
Paschel. Thank
and
you.
beaten this Wilson Chapman for 35 or 40 minutes, he would have gotten the car and gotten the heck out of there. But
That's what he's doing. He's
If
putting
Mr.
everybody to sleep.
Paschel
I just want to go for my free
Tell
product.
the
That's
truth.
it. And then I can leave.
about how the injuries occurred and what happened after they left the brasserie, it would have been
That's what I was
reasonable and
thinking too. Nobody
commonsensical
argued
for
that.
him
That
to
was a
have
rage
stayed
factor to
there
me.
getting ready for bed. Because you heard Mr. Paschel tell you he didn't have any reason to leave the house because he hadn't done anything wrong. He didn't get in the car. The police didn't have to go find him. So ask yourself about the behavior that you encountered when the police arrived and spoke with Mr. Paschel. And
Oh my God.
did he hesitate in terms of telling them what happened? Did he say, well, I don't know, we've gone here, we've been drinking or whatever? No, absolutely. Let me tell you how it happened.
I'm thinking that's the motive. That's where the rage
They
came
came in
from.
unannounced.
It's behind the
Good
death of
liars
his
give
son, but no
details,
one
great
put that
liars
into
don't.
argument.
You're telling the truth. Facts are stubborn things, and you don't have to worry about it. He immediately responded, and he responded and said, that's how it went.
That's it?
Now,
Oh God.
I've had the responsibility of protecting Mr. Paschel's fundamental freedoms and constitutional rights, his presumption of innocence, and now comes the time in the trial where that
Where's there a troll with your
responsibility
name?
passes to you.
Am I missing a troll?
In just a few minutes, because the state has such
Guys, if
a
there's any
high
trolls in here,
burden,
block them. I don't see a troll
beyond
with your
reasonable
name,
doubt, they're
Sarah.
going to get to talk to you for a second time. I don't get to say anything else to you. This, on behalf of Mr. Paschel, is the last time that I will get to
Thank you.
address you.
That's
during
why
the
you
course
keep
of this
talking.
trial. But when the state does make a point, ask yourselves
Hi,
what
Lisa.
Mr. Isaacs would say. Or ask yourself, does that really make any sense?
Blame it on
Ask
alcohol.
yourself, for example, if they talk about the phone records,
Yes.
maybe somebody that was looking at making a false statement that carries 2 to 4 years.
Yes, he had a
might not
seizure
want to
under her
change their
care.
story if they were caught. But at the end of the day, I again, on behalf of Mr. Paschel, want to thank you for your kind
Oh my God, he's
attention and your
finished.
attentiveness during the course of this trial. I want you to go back there, and I know Mr. Paschel wants you to go back there and leave no stone unturned as you.
They didn't
review
bring that up.
evidence.
That's what I want to know.
We
That
want you
could be
to
the
listen
rage
to what
factor.
the judge
He
charges
mentioned it when
you.
he was on the stand,
And we're
but
confident.
no
after
one picked
reviewing
up on
all
that.
of the evidence,
That's where that anger and that
listening
rage
to
came
what
from.
the standard legal
And then with
standard
that, he
is
saw
you
her
have to
texting
decide.
or on the
And
phone
you'll
or
go back
whatever.
there and you will hold fast to your individual verdict. Remember we talked about that in voir dire? That each of you will go back there and do in your heart of hearts what you think the right thing is. Because if you think, well, the 2 people testified, it may have happened that way, and it may not have happened this way, then the state loses. They have to prove this
I
happened
found it,
beyond
Sarah.
a reasonable doubt. And you heard about the phone, the kidnapping, whatever the phone. What's more plausible?
So they will be
That Mr.
permanently
Paschel
blocked
sat
as
there and she had her
well.
eyes closed and heard him plugging the phone up to a UV port. And she was
Everybody
plugging
got
her
a
eyes
problem with
closed
John.
and
Maybe they
doing
need
this.
to go see
Or
John.
that he
That's
picked
where
it
they
up
need to
after
go. They
she
need to
fell
go
outside
visit
and
John
brought it
and
upstairs
talk to John.
with the screen pop.
Don't come in here.
And serendipitously,
John doesn't
the
reside at this
phone,
address,
under the
people.
state's theory,
Get
could
your
do
life
anything. It
together.
could take pictures, it could do this, do everything to call
I don't
911.
feel like opening up a street sweeper today.
It's not reasonable. It's not probable. And when that phone was put under a Hubble telescope on those text messages, nothing emerged. But we were going to ask you to go back. We're going to ask you to review the evidence. And after doing so, we are going to ask you to return a verdict of not guilty.
And
as
they just
it
changed
relates
their
to
names
Geoffrey
because there's no
Paschel on the
email
first
address
county
associated
indictment
with
for
it.
aggravated kidnapping because he did not substantially confine her for her liberty. On count 2 for domestic violence because he did not assault her. And count 3 because he did not interfere with her calling 911. Thank you for your attention.
Thank you. Bye. Shut up.
Find out what you're going to say.
His address been plastered all over IG. Shit.
Two things that Mr. Ivan said that I want to hit on, but one of them is within the last couple
Matter
of
of fact,
sentences.
I'm gonna block the name
sentences
John
here.
in my
I
chat
believe
real
Mr.
quick.
Ivan used the words, nothing emerged.
Nobody's in here with the
We're
name
talking about
John,
these text
right?
messages
No.
that Mr.
Okay.
Paschel wants to
I'm gonna block the
rely
name
so
John and Cody
heavily
in
on.
my chat.
Think about who gave their phone voluntarily to be examined. The person who purportedly sent these messages.
Balls, peen, whatever
gave us
else.
her
I'm blocking
phone
all of it.
so that we could find these messages and nothing emerged. Miss Wilson sat there and told you she had nothing to hide. She voluntarily said, subpoena all my records. Nothing emerged. Records that both the state and the defense have access to. Nothing emerged. They want you to look at screenshots provided by the defendant that no one else has anything to do with but him, that merely just say a name. Half of them don't even have full dates on them. The whole back page, just December 22nd, no year. But they want you to look at these screenshots provided by him over a year after he was charged and say that she's lying? Nothing emerged from her records. I also want to talk about something else that Mr. Isaacs said, that they want to be honest and open. They want to be transparent with you all. I want to talk about some of the things that Mr. Paschel was not very transparent about. First things first.
Yep.
If you remember,
She can go
when
after him
I was questioning Mr. Paschel about even the simplest
to
things,
rebut everything he
the
just
simplest
said.
things. I want you to think back at the answers that he was giving me. I asked him, have you ever done an interview on a YouTube channel? No. Oh, well, I don't think I have. I mean, interviews, I don't know. Interviews, I don't know if you call them interviews, I don't know. Maybe some people post them, things like that. The second I gave him a date and a name of the specific interview I was talking about, oh yeah, I forgot about that one. Forgot about that one. Think about how I asked him about his testimony
Lisa,
in his prior
Marie, you're
deposition,
funny.
one of which occurred in 3 weeks before this assault took place. 3 weeks.
So the jury's going to get it. We're not
He
going to get a
read
verdict
it.
today. They'll make us wait for
He sat
tomorrow.
down and stand, he read his own statement, and he still wouldn't answer my questions. Well, I don't even know if this is the Kristen. I don't know if this is Kristen Wilson. I know a lot of Kristens. He knows a lot of Kristens. This just says Kristen. How do we know who these messages came from?
That's what I want to know too, Marie. 4 months after the fact.
Think about how open and honest this defendant was on the stand when I was asking him the simplest of questions. He couldn't remember what he said in a custody dispute for his own children, but wants you to believe every single detail of the night in question as he gave it to you. He couldn't remember anything, couldn't remember doing interviews only a couple of months ago, couldn't remember any of that when I asked him about it. I want you to think about how honest and open the defendant's been.
Yep.
Go back and watch the body cam. He claims today that, yeah, she had some redness on her forehead. It was a little bit raised. Talking to the officers, he hadn't seen her face. I didn't show Mr. Paschel the pictures of the injuries that he claims he didn't see. And remember, again, there's been a lot of talk from Mr. Isaacs about the fact that you didn't hear from a doctor, things like that. We talked about that in Fort Dyer, didn't we? This is not how you see it in the movies, folks.
Neither would I. I think she was
Ms.
needy.
Wilson got up there and she said, I went to the hospital. You hear her say it in that initial
You're right, Marie.
body cam when she's talking to the emergency personnel. She said,
You're right, Queen.
You heard Ms. Gooch say, yes, I took her.
It was
Wednesday,
4
when I
months.
drove her.
She got married in October
Got a concussion.
2019.
Not like that. No one's surprised. We didn't need to call a doctor in to say she had a concussion. She told you. That doctor couldn't have told you how that concussion came to be. judge would have let a doctor say, well, this is from an assault or this is from running into a doorway. She's not right. She told you she had a concussion. So the fact that a doctor was not put on the stand is really quite irrelevant. And I just want to make that point.
Yep, October 2019 is when she got married.
So we talked about this before. That's not how it happens in the real world. She told you she went to the hospital. Miss Gooch told you she took her to the hospital, and she told you she had a concussion. Simple as that.
And they have the
Look
medical
at those
paperwork.
pictures, look at that knot on her head. No wonder. No wonder.
Maybe so. Don't know, Cassie. Maybe so.
Ladies and gentlemen, this case has been long and drawn out mainly because of the arguments of the attorneys. And there's a lot of things that Mr.
Objection, can we approach?
There's a lot of objections going on here.
Well, I'm assuming the objection by the defense
Because
attorney
it
in
was
this
long
part
and
of the
drawn
state's
out.
rebuttal argument is that it sounded bad to say because of arguments by the attorneys. Let's listen.
Just the truth.
Past couple of days mainly because the arguments between all of us sitting up here at the table, the attorneys and everything like that. There's a lot and a lot of things involved. But at the end of the day, this decision is going to be based on the evidence and your own common sense, like I said before.
So the judge overruled him.
I want you to think about Ms. Wilson's testimony. Think about how scared she was. Think about how this has affected her, not only then, but all the way up to now. She took that stand.
Yep.
She told 13 strangers with cameras in here and everything. Defendant's used to cameras. Ms. Wilson's not. She took that stand. She told you exactly what he did to her. She didn't waver.
Not one time did she waver.
Yeah, of course. She blacked out a few times. She'd be the first person to admit that. Again, an assault like this, no wonder.
No, he doesn't get to
She
speak
didn't
again,
waver
Cupcake.
on the facts of that night. Not once. This man who she was engaged to, who she had been with for 2 years, who basically lived in her home,
Basically. Objection.
brutally attacked her. Brutally. And yes, admittedly, she says, I don't know why it happened. She told you that. She said, yeah, I can't tell you why it happened. I don't recall us having an argument. I don't recall anything wrong happening. But does that mean that it didn't happen? Of course not. People do things all the time for no reason at all. And on this particular night, this defendant attacked his fiancée in her home. And then he held her in her bedroom against her will because she was too scared to leave, thinking he's going to keep doing it. That is aggravated kidnap, ladies and gentlemen. Plain and simple. We ask that you find him guilty as charged. And once again,
He gets to make one closing argument, and he just did his. And then she gets to go after him, and she does a rebuttal. That's what he said.
This trial, I have about 15 pages worth of those. I do want to check with you. Before I get into those, does anyone need a cup of break? Okay, let's take one. We'll take a brief recess.
Okay, John said that the show goes on the regular TV, the interviews.
After you hear these instructions, please go on.
They're taking a brief recess while the court prepares to read the jury instructions. As we know from all trials, that's the next step in a trial. I want to take this opportunity to bring in our guest legal analyst today. We have Jason Wingfield with us. Jason, tell me your thoughts about closing arguments.
Yeah, thanks for having me. So those closing arguments were pretty fiery.
Who's closing
I
arguments?
think each side made some pretty important points. I think when it comes to the state's burden, certainly putting forward the testimony of the victim and talking and trying to sympathize and empathize with the jurors about what her emotional state might have been and trying to really amplify how she might have been feeling up until this point, going all the way back to June when this occurred. So, yeah, I think that was really powerful. I also think it was very.
You think it's going to be a hung jury?
To point out, hey, listen, we don't have a whole lot of expert testimony here. While I agree that, you know, one of the things that jurors often are concerned with is that, hey, you know, we know that these tests exist and there's this forensic stuff out there and we watch CSI. It's not always like that. But here we have a case where the state is asking us to believe that these injuries are pretty extensive and significant, and that the trauma is pretty extensive and significant. And so I'm surprised that we're not seeing medical doctors. I'm surprised that we're not seeing a psychologist or some sort of counselor to talk about the effects of this traumatic moment on the victim. And then the other issue that I think the defense brought up is, hey, listen, when you have a victim like this and the state is showing pictures of these injuries, wow, that looks really bad. And nobody is going to look at those images and say, well, you know, something had to have happened here, right? So the jury is going to look at that and they're going to really be moved by it. And jurors often are very protective of victims. And so when you see those things, it's very, very difficult to create distance between your client and those emotional reactions that the jurors are going to have.
And Jason, I felt like that's one reason they may not have called an expert, because of the photos, because it's very obvious she sustained an injury and not a good injury. But now I think it comes down to the jury weighing the credibility of the victim, the credibility of the defendant, because bottom line in my mind, it's which version do you believe? Do you believe
why call the
that
police
he's the
if
one
you
that
fell
did it,
into a
admitting
wall?
that she doesn't remember everything about the night? Or do you believe his version that
Why
she
leave
went
your
from
house
0
at
to
2 o'clock in the
110
morning
and ran
to go to your
into a
neighbors?
door? I really
But
think
y'all
it boils
outside
down to
screaming
that.
earlier,
I want
but
to
nobody
hone in
heard
a
you
little
fussing.
bit in the last couple of minutes that we have before needing to take a break, and that is to talk about the demonstrative aid, which I always like as a judge. I always appreciated when they break those out, that the defense used in closing argument, because we look for themes in closings, right, to bring it home to the jury and convince them of our version. But he used this map to go from the presumption of innocence, and he literally walked across the room to say, you have to pass all these standards of proof to get all the way to beyond a reasonable doubt. I thought that was a very effective way to demonstrate the standard the state has to meet.
Yeah, I would definitely agree with you. I thought it was very powerful. I too really enjoyed how he started on one side of the room.
She said he hit her head against the wall and the door. She said that.
Through each, burden of proof, and got to the other side of the room, that the state had to do that as well. That the state had to carry the burden from Mr. Paschel's presumption of innocence all the way past all these different mile markers to arrive at reasonable doubt. I thought that was a very powerful demonstrative.
Me too, absolutely. I want to listen now, because this trial has been full of twists, turns, objections, and there was actually a motion for a mistrial earlier in the day. Let's listen together to that.
Please, we don't want to hear him talk anymore.
My client is charged with a serious Class B felony, aggravated kidnapping. He's charged with assault. He's charged with interference with a 911 call. We are doing everything we can to zealously represent Mr. Paschel within the confines of the rules. And the fact that we have now, and before she said it, she said, I don't know if I can talk about this. And she looked up and she smiled.
No, she didn't.
Well, she chose to talk about it. We are imploring the court, because again, this is clearly a credibility issue versus whether the jury believes Ms. Wilson-Chapman or believes Mr. Paschel. So now I am faced with a tactical choice on, well, I've asked for a mistrial, but if you say curative instruction, I can't touch it. I can't cure it. I don't know what conduct she's talking about.
So the judge denied that motion for a mistrial. I know that you're going to stay with us because I'm going to want to talk more about that later, and the fact that it is true this witness referenced past marks left by the defendant. Is there surprise or not that mistrial was not declared? So stay with me so we can continue to break it down. Here's where we are in this trial. Closing arguments have completed. They took a quick break. When we come back, of course, the judge will read the jury instructions, charging the jury with the law that they must apply to the facts as they find them to be true beyond a reasonable doubt. We will take you there live. We'll take this opportunity to take a short break. Don't go anywhere. We'll be right back on Court TV, your front row seat to justice.
I don't think she's making it up. Now, my thing is, let me just put this on. I'm going to turn this on mute for a second. My thing is, we heard Geoffrey on the stand speak about his son, and he had that episode while he was being cared for by Christian. That's what we heard. Why didn't anybody think he's out drinking? And I know a lot of people, when you're drinking, things start running through your head. Some things make you mad. Why didn't they think this man was having, he's looking at it, he's having fun. They're laughing, talking. She goes, walk the dog. He walked, whoever. I think she walked her own damn dog, but why would you be with somebody and have somebody in your home who couldn't stand your dog? But then again, I look at Married at First Sight, and the woman he's married to doesn't want shit to do with his dog either. So I think it snapped in him about his son. He probably had some anger towards her. He probably thinks that she wasn't, paying too close of attention to his child, or whatever the case may be. That anger could have came out at that time. But he also has been accused of being abusive to his first wife. He's been abusive towards Mary. He's been abusive to another woman before then. So how much is it that we're going to say, no, she did this to herself? It's a pattern of behavior. That's why they didn't let it in. He has a pattern of behavior. He's an abusive little man. I've been in what? 6 relationships now. Never, ever, ever put their hands on me. That's what I'm saying. So why would you go walk her dog if you don't like her dog? She said it, but he has dogs. And then somebody in the chat brought it up about how he says that the dog is always trying to get out. What is he doing to the dog that the dog always wants to leave? Yep, he's abused them. Yes, he has a history. He has a history. Yes, him and Mary got into it. Yes. Yes, 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 yes. Okay, Marie, I would like to know, seriously, I want to know, why do you say that she's not credible? I mean, I really, really want to know that. Tell me what it is. And you saw the way he was treating Varya even on the show. It's either his way or no way. So, Marie, I really want to know what makes her not credible to you. I really want to know. No, he's not married now. Not as far as we know. I don't think he is. No, he's not married. That's what I'm saying. Look at his even on the show. No one even liked him for the way he behaved on the show. And then you find all of this out. He knew they weren't invited to the tell-all. Oh, let me take this off of mute.
Afternoon, where we are following three big cases today. first 90-Day Fiance reality star on trial in Tennessee. Geoffrey Paschel is accused in the brutal beating of his former fiance. Today, he took the stand in his own defense. Then the trial takes a stunning turn.
So I woke up probably around like 7:50, I want to say, because I heard yelling from like right outside my door.
And that was 16-year-old Tylee Ryan talking to police in Chandler, Arizona, after her stepfather, Charles Vallow, was shot and killed in their home. Hear her recount of what happened.
Oh,
on that tragic
Tylee
day.
is gone.
Next
Oh
up,
my God.
Arbery's family speaks out
Arbery
about their
family
heartbreak
speaks,
after he was
yes.
gunned down while out running. Our Julia Janae sits down with the Arbery's for an exclusive interview. And first case on the docket this afternoon, Tennessee versus Geoffrey Paschel. The jury could start deliberating the fate of the former 90-Day Fiance reality star today. He is accused of allegedly attacking his former fiance. Paschel took the stand in his own defense today to explain what happened on the night of the alleged attack. According to an affidavit, the victim in this case, Kristen Wilson Chapman, claimed a drunk Paschel grabbed her by the neck and slammed her head against the wall several times. The victim took the stand on rebuttal, and that's when the trial took a shocking turn. Chapman testified about alleged previous abuse at the hands of Paschel. Let's take a listen to what happened after that bombshell moment.
It was not a subject of our case with Mr. Paschel. Obviously, it is incredibly prejudicial. I can't
I'm missing a lot of
cross-examine
stuff because I
her
had to
because
walk
we've
away.
not had a hearing to determine by clear and convincing evidence as mandated under Tennessee law whether it would be appropriate 404B. Now, if the court issued a curative instruction, I do not think that it would be sufficient in this particular instance. This instance is a case of he said, she said, and the credibility of Mr. Paschel and Miss Wilson Chapman is paramount before this jury. The state chose, and I'm not making assumptions, I'm not casting any
Yeah, that's what they didn't
put
get a
her back on the
forensics
stand
expert, from my
to go back over
understanding.
what Mr. Paschel testified about. Now she has talked about other instances of abuse. So here's my dilemma. Do I ask when, how, where it happened, how it happened? What does she call abuse?
Now, should they have gotten a
cross-examine
forensics
her.
expert?
I do
Yes.
not feel a
They should
curative
have,
instruction
but they
would be
didn't. They
sufficient.
just subpoenaed her
This
records.
is when you open Pandora's
What
box.
came
This
of
is
those
what the
records, they
risk
said they couldn't determine.
You know, the state
If
chose
it
not
came
to
from
show
her or
Mr.
not.
Paschel a single photograph during his cross. But yet in rebuttal, we're going back.
All right, we are going to take you right back into court. The judge is
Thank
on
you.
the bench.
Yeah, something set this off.
So I'm going to mix them up and randomly select one name.
So now, okay, they pick. So they picked the foreman of the jury now. Okay.
In this case, I want to thank you so much for your service this week. Your work is.
Yes, they said he spent time deleting himself from her phone.
Done this without you. Thank you so much for your help. You're now excused from this panel.
If you have a printed copy, I can't hear a thing he's saying. Fix the camera. Oh, okay. They got the juror walking.
All right, as is norm in these cases, the alternate gets excused. The judge randomly picked. Audio went out, so we didn't hear the name. That juror's excused. Back to court.
The offense necessarily includes the lesser offenses of kidnapping and false imprisonment. The defendant is charged in count 2 of the indictment with the crime of domestic assault. The offense necessarily includes the lesser offenses of assault and domestic assault by offensive touching. The defendant is charged in count 3 of the indictment.
Oh, now that says a lot.
The defendant pleads
Especially
not
coming
guilty
from
to each
your
and every
husband.
offense embraced in the indictment. The evidence in this case has been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, as well as the preliminary instructions I provided at the beginning of the trial, and any instructions I may have given during the trial. It is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others. but should consider each one in light of and in harmony with the others. The indictment in this case is the formal written accusation bringing criminal charges against the
Very
defendant.
good point, Lisa.
It is not evidence against the defendant and does not create any inference of guilt. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern
I don't
yourself
know
with
Clint's
these
number by
rulings,
heart,
neither
and we've
by
been
such
together 8
rulings,
years.
these
He's got the same
instructions,
number.
nor
It's
any
in my
other
phone.
remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence.
15
If any
pages,
statements
God.
were made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court.
I think
You
your
should
husband
apply the
should have been
law to the
presiding over
facts
this
in
case.
deciding this case. You should consider all of the evidence in the light of your own observations and experience in life. As stated earlier, you must decide this case based solely on the evidence presented here within the four walls of this courtroom. Please do not try to find out any information from any source outside the confines of this courtroom through electronic means or otherwise. Please turn off your phones or other devices. Do not use them during your deliberations. When you retire to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you've returned a verdict and the case is at an end. This includes your family and
I
friends.
wonder if she will sue him
The crime
civilly
charged
now.
in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charge must be stated in your verdict.
Yes!
In
I used to
reaching your
know
verdict, you shall
everybody's
first
number.
consider the offense charged in
Now it's
indictment
just in
count
my
number
damn
1.
phone. I know
If
my
you
mom's
unanimously
number
find the defendant
because I
guilty
grew
of
up
that offense
there,
beyond a
and we didn't
reasonable
have cell
doubt, you shall
phones.
return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the
Woo!
next lesser included offense
Congratulations,
in
Natalie.
order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of
She
that
should sue.
offense.
I would love to hear
If
what
you
your
have a
husband
reasonable
thinks
doubt of the
about
guilt of the
him
defendant as to
denying that
all offenses
mistrial.
charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. Count 1. The defendant is charged in count 1 of the indictment with aggravated kidnapping. Any person who commits an aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable
Yes,
doubt
tomorrow.
the existence
I'll be
of the
back
following
for the
essential
verdict
elements.
tomorrow.
1. That the defendant knowingly confined another unlawfully so as to interfere substantially with the other's liberty. And 2, that the alleged victim suffered bodily injury.
Unless they come
during
back
the
tonight.
confinement. A confinement is unlawful if it is accomplished by force, threat, or fraud. Although the law requires no specific period of time of confinement, a confinement interferes substantially with another's liberty if the time of the confinement is significant. To
They
find the
tried to
defendant
charge me
guilty
with
of this
kidnapping
offense, you must
when I
also
blocked
find
somebody
beyond
in
a
with my
reasonable
car
doubt that the confinement
for
was to a
impeding
greater
her from
degree
leaving.
than that necessary to commit the offenses of domestic assault and interference with an emergency call as charged or included in counts 2 and 3. In making this determination, you may consider all of the relevant facts and circumstances of the case, including but not limited to the following factors. A, the nature and duration of the alleged victim's
Get the case
confinement by
now.
the defendant. B,
Maybe
whether the
tonight or tomorrow
confinement occurred
morning.
during the commission of the separate offense. C, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense. D, whether the confinement
I
prevented
think
the
you're gonna
alleged
go back
victim
and have
from
dinner.
summoning assistance, although the defendant
Eat.
need not have succeeded in preventing the alleged victim from doing so. E, whether the confinement reduced
I'm
the
hoping
defendant's risk of
it'll be done
detection,
today.
although the defendant need not have succeeded in this objective. And F,
Hi,
whether the
Batley.
confinement created a significant danger or increased the alleged victim's risk of harm independent of that posed
Hi,
by the
baby.
separate offense. Unless you find beyond a reasonable doubt that the alleged victim's confinement
Thank you,
exceeded
Brenda
that
Faye.
which was
Thank
necessary to
you.
accomplish the alleged domestic
I
assault and
appreciate it.
interference with an emergency call and was not essentially incidental to it, you must find the defendant not guilty of aggravated kidnapping. Bodily injury includes a cut, abrasion, bruise,
Motive and
burn, or
alcohol is
disfigurement,
the
and
reasonable
physical
doubt, is
pain
what
or
his defense
temporary
attorney
illness or
said.
impairment of the function of a bodily member, organ, or mental faculty. Force means compulsion by the use of physical power or violence. Fraud is defined as the term is used in ordinary conversation and includes, but is not limited to, deceit, trickery, misrepresentation, and subterfuge. Knowingly means that a person acts knowingly.
A lot of people don't know what
with respect to the
subterfuge
conduct
means.
or to
Explain it to them.
circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also
She doesn't have to
established
file
if it is
charges.
shown
The
that
state
defendant
automatically
acted
pick those
intentionally.
charges up.
Intentionally means that a person acts intentionally with respect to the nature of the conduct or to
Look
a
at
result
Tennessee
of the
law.
conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Lesser included offenses for count 1. If you have a reasonable doubt as to the defendant's guilt of aggravated kidnapping as charged in this indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of kidnapping, a lesser included offense. For you to find the defendant guilty of kidnapping, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly confined
know my
another
ex's number by
unlawfully
heart,
so as
too.
to interfere substantially with the other's
That's
liberty.
because we got our phones
And
at the same
2,
time.
that the confinement was under circumstances that exposed the other to substantial risk of bodily injury. When determining whether the defendant is guilty of kidnapping or any lesser included offense under this count, you are required to use the same definitions and instructions as set forth under aggravated kidnapping above, including the instructions for determining whether the confinement was unlawful, whether the confinement substantially
look like Michael
interferes
J.
with another's
Fox?
liberty, and whether the confinement was to a
what's
greater
his name?
degree and not merely incidental to the confinement necessary to accomplish other crimes charged in this indictment.
What's his name?
If you have a reasonable doubt as to the defendant's guilt of kidnapping, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of false imprisonment, a
Harris,
lesser
what's his
included
name?
offense.
It's a gay
For you
guy.
to find the defendant guilty of false imprisonment, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant confined another unlawfully so as to interfere substantially with the other's liberty, and 2, that the defendant acted knowingly. Count 2. The defendant is charged in count 2 of the indictment with domestic assault. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to a domestic abuse victim. And 2, that the defendant acted either intentionally or knowingly. Bodily injury has been defined previously in these instructions. Domestic abuse victim means any adult or minor who 1, lives or has lived together with the defendant, or 2, is dating or has dated, or is having or has had a sexual relationship with the defendant, not including fraternization between two individual contexts. Lesser included offenses for count 2.
The
If you
video
have a
jump,
reasonable doubt
again.
as the defendant's guilt of domestic assault is charged in this
He's on
indictment,
board.
then your verdict must be not guilty as to this offense, and then you shall proceed to determine
Tell
his
your
guilt or
husband
innocence
that we
of assault,
appreciate
a lesser
him
included offense.
coming in and giving us
For you to
that.
find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to another, and 2, that the defendant acted either intentionally or knowingly.
That's him, Sean Hayes.
If you have a reasonable doubt as the
And
defendant's
Neil
guilt of
Patrick
assault,
Harris a little bit.
the defendant's guilt of assault, then your verdict must be not guilty as to this offense.
Yeah,
and then
Neil
you shall
Patrick
proceed to
Harris.
determine his guilt
Doogie
or
Howser,
innocence
that's
of
him.
domestic assault by offensive touching, a lesser included offense. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant caused physical contact with the domestic abuse victim. And 2,
That's who he
that a
reminds
reasonable
me of.
person would regard the contact as
Yep,
extremely
Doogie Howser.
offensive or provocative. And 3, that the defendant acted intentionally or knowingly. Count 3. The defendant is charged in count 3 of the indictment with interference with emergency call. Any person who interferes with an emergency call is guilty of a crime. For you to find
No,
the
the
defendant
kidnapping
guilty of
is
this
related
offense,
to
the
him
state must have
holding her
proven beyond a
there
reasonable doubt
without
the
allowing her to
existence of the
leave, for
following
taking her
essential
keys and her
elements.
phone,
1,
and
that the defendant prevented
interfering with the
another from
911 callers
requesting
when he had a
assistance in an
phone.
emergency from a law enforcement agency. And 2, that the defendant acted either intentionally or knowingly. Emergency means a condition or circumstance in which any individual is or is reasonably believed by the individual making a telephone call to be in fear of imminent assault, or in which property is or is reasonably believed by the individual making the telephone call to be in imminent danger or destruction. Law enforcement agency means a division of government that has a duty imposed by law to A,
The
maintain
attorney
public
she's
order,
speaking about
or
is
B,
going to
make
be
arrests for offenses, whether that duty extends to all offenses or is limited to
Geoffrey's
specific
attorney,
offenses. And
billboard
C,
attorney.
investigate the commission or suspected commission of offenses.
Told you he was standing on the corner passing out his card. He's probably an injury attorney.
The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless from all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation
Better Call
to let the
Saul.
mind rest
I love
easily
that
as to the
show.
certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof
Hey, Mod
necessary to constitute the
146.
offense. The state must have proven beyond a reasonable doubt all of the elements of the crime charged.
Yes,
and
he
that it was
stands on the
committed
corner,
before
hands
the
out
finding
cards.
and
I
returning
bet
of the
he's an
indictment in
injury
this
learner.
case.
I
The
mean,
burden is
an
upon the
injury
state
lawyer.
to prove by preponderance of the evidence that this offense was committed in Knox County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that this offense was commenced or consummated in Knox County, Tennessee, then you must return a verdict of not guilty. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony.
My
If there
idea
are conflicts in the testimony of the different
is that
witnesses, you
Geoffrey
must
probably
reconcile
flashed
them
back
if
to
you
his son
can,
dying.
without hastily or rationally
That's my
concluding
idea.
that
But the
any
motive
witness
is
has sworn
alcohol.
falsely, for the law presumes that all witnesses
No.
are truthful.
No.
In forming your opinion as to the credibility
Benefit
of the
of
witness,
doubt
you may look to the
equals
proof, if
motive
any, of his or her
and
general
alcohol.
character,
That's
the
what the
evidence, if any, of
defense
the
attorney
witness's
said.
reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown, and all the evidence in the case tending to corroborate or to contradict him or her.
Lord, it's been that long?
The defendant having
Jesus.
testified in his own behalf, his credibility is determined by the same rules by which the credibility of other witnesses is determined, and you will give his testimony such weight as you may think it is entitled. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with his or her evidence on the witness stand. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's
Oh,
credibility.
you meant mod
and not as
146 because
substantive
there's no
evidence of the
mod
truth of the matter
246 in
asserted
here.
such out-of-court statements. Further, a witness may be impeached by a careful cross-examination involving
And no, the
witness in
moderators are not
contradictory,
related.
unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses
She's in the
do not
courtroom,
affect their
Kelly.
credibility
She's already tested.
unless it
She's
should
been on the
plainly
stand
appear
several
that
times.
some witnesses willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved
Well, you
by
don't
the
need to
trial.
be in here, Florida girl. Take your ass to
The
court
verdict must
TV.
represent the considered judgment of each juror.
That's where you
In order
need to
return
go.
a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and
Dumbass
to
people
deliberate
coming in
with
my
a view
court.
to
Don't
reaching
come in
agreement
here.
if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest opinion as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return with it
We have
to this
nothing better to
courtroom, and
do.
your foreperson will announce it. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find the defendant not guilty. You will be provided with forms for all possible verdicts in this case. The jury will complete the appropriate verdict forms, and your foreperson will sign them. You may now retire for your deliberations. All right.
Woo! 15 pages done.
Retired for
Yep,
the
my
deliberation.
courtroom.
The judge just finished reading the jury instructions, as you heard, going through the law for each of the counts and the deliberation that they have to do. And the jury has now been sent out. I hope that I can bring in my special guest at this time, Jason Wingfield and Richard St. Paul, so that they can come in and talk with us about this. Richard, let me start with you if I could. So those jury instructions were very straightforward. There was nothing unusual about them, I don't think.
No, look, I mean, the jury instructions the judge is going to go through the jury instructions and see
Okay.
he's going to tell the jury what elements they should be looking at to match the facts up with the element. When you look at the different elements, the facts that you heard, the evidence that you heard, does it match those elements? If so, then you can find the person guilty. So, the jury instructions are very long sometimes, depending on the matter. Some judges allow jurors to take notes, which is very helpful. But during the process, a lot of people who are watching or have seen, sometimes the jury will ask a question to the judge. Because again, the
I am
jury
the
instructions
officer.
they're very plentiful. And so sometimes
They only
you
came in
forget,
here because
especially
John
if
was
you don't
here.
have notes.
That's how dumb they are.
Right, absolutely.
And it's the
other
same
thing is
person
this
that keep
judge
changing
did
their
tell the
name because they
jury
keep
earlier
blocking the
on when
name,
we were
so they
watching
change it to
earlier in the
something
week
else.
that the
Idiots.
items that were introduced into evidence would go back into the jury deliberation room
Okay.
with them. And I see everyone standing. This is a live shot. So I just want to talk a little bit before we delve
Incoming call
into
from-
this. They are in recess, I'm being told in my ear. So they are in recess. We do have our clock started, 1 minute, 39 seconds. So, I apologize, gentlemen, in advance, but I have to ask your crystal ball. Jason, what based on all of your experience in being in court and as a defense attorney, what would you think might happen by this jury following their deliberation?
Yes, he was here earlier.
Thanks, Ashley. So I think what you're asking me to do is predict the outcome, right? And certainly, I'm sure all of the viewers at home are going to have different talking points. But I'll tell you, there's a few things that kind of stand out to me. When it comes to the state, those are some pretty gruesome injuries that the jury has to look at, right? I mean, nobody sitting on that panel is going to look at those photographs and think that this young lady didn't experience some sort of trauma. With respect to the defense, they're going to go back and they're going to think, wow, we've got these text messages that are pretty controversial. Certainly, we don't know who they're from. We know who they're purportedly from, but we don't know who exactly wrote these. But if it was the alleged victim, then that sort of sours the case. And then there's the absence of expert testimony, that no medical doctor talking about the injuries sustained. We heard testimony that Mr. Paschel was banging her head against the wall and the floor for 30 to 40 minutes. Well, certainly you'd expect to see a concussion or some sort of traumatic brain injury, right? And so there's jurors that are sitting in the deliberation room wondering, hey, why didn't we hear about that? And certainly, being such a traumatic experience, you'd expect to hear testimony from a psychologist or a therapist or a counselor that talked about
Let me go. I'm going to go look, Lisa.
necessary treatment, necessary sort of support for a victim who goes through a traumatic incident like this. And those things are non-existent. So now going back to the bottom line answer, I think that there's some reasonable doubt here. I think that and sure, I would say that, right? I'm a criminal defense attorney, rooting for the home team. So I think that there's some reasonable doubt. I think that there are potential exit points, if you will, where the jury can get off and not make it to the other side of the room, as the defense attorney has said.
And I will say that, the pictures, we talked about this a little earlier, I think speak for themselves and show the injuries and the trauma as a result of those injuries. But the other thing I must say, in the color of the courtroom, we have such
They're
an
not
amazing
saying.
team there in the courtroom. And what we do know is the description provided during the time that the defendant was actually testifying is that some of
We
the
know
jurors
there's at
appeared to
least
be
3 men on the
angry, and
jury.
that one actually appeared to be kind of squeezing their fists. So let me turn to you, Richard. The credibility of the defendant and the victim are at play here. And if you have that kind of response to the defendant, does that bode poorly for the defense team?
Yeah, certainly it does. I mean, jurors are human beings, so their experiences, their personal experiences, they're going to weigh in to the trial always, and into their deliberations, and of course the credibility, the witness appearance is going to be part of their deliberation. Interesting enough, though, what the jurors take could be that this was a fight, because if you recall, they were in the partially redacted video of the body cam from the police officer. You can see the defendant had scratches on his body as if they were both in a fight.
Sorry.
So if they were, that certainly could weigh well for the defense to show that he was also a victim, that he was assaulted as well, and that they were basically fighting, and so he should be convicted of assault because there was a fight between two individuals.
But here's what's always hard for me. So they did bring up there was drinking and they'd gone to dinner, and both of them, I think, were described as drunk. I'm not sure if that's the right word, but they were both described as under the influence as a result of the drinking. But yet the issue I have is that doesn't take away from domestic violence. And so there are 4 counts against this defendant that the judge just went through. We have the aggravated kidnapping, and I think his attorney has repeatedly argued there's no evidence of that. The domestic assault, and that's when there's assault against a domestic partner, and the interference with an emergency call, taking the phone, not allowing her to make the call, and vandalism. So those are the 4 charges he faces. And I think, though, what's hard for me is if you just look at that law, and they've been advised of that, whether or not they're drinking doesn't matter when it comes to domestic violence. Do you agree or disagree? If I could start with you, Jason, please.
No, I there's no room for alcohol in a jury instruction that talks about domestic violence. I mean, if we were talking about some sort of voluntary intoxication defense or something like that, there's nobody here. We've heard no testimony that says, hey, they were so beyond intoxicated that they could not form the requisite intent requirement to be guilty of this crime. We've heard nothing like that. So in the instructions that we have, there's really no room to even mention the alcohol. The alcohol is one of those red herrings, because it would appear that they were still able to form the requisite intent, the requisite mental state in order to bring these crimes to completion.
All right. Thank you so much, Jason. And Richard, I know that you're going to stay with me and our viewers. We have to take a step aside for a break. When we come back, we're going to give you the latest information in a case against the Doomsday couple. New evidence has been released by the Arizona police, including an interview with Lori Vallow's daughter, Tylee. This interview took place the day Lori's former husband, Charles, was killed. We'll be right back on Court TV Live.
Okay, guys, the court has, they're out deliberating right now. So I'm going to leave this up, but if they come back, I'll be here. But mod 146, my mods are not timing you out. It's a stupid ass Google bot. I don't know how to get rid of it. I have no control over it. And it always seems to happen during the day, but not the nighttime. So my mods are not timing you out. I'm going to leave this up. I'm going to let it play out until they end the court session, which they're probably going to do at 4 o'clock. And then I'm going to see if the jury comes back. If not, it'll be tomorrow morning, but I am not going to cut the live until 4. So I'm going, well, no. They're going to take a break. So I'm going to cut the live. We're going to see what happens later on. And thank you guys for being here. I'm so sorry, mod 146, that you were being timed out. And I will definitely come back if the jury comes in today, because I have court TV on my TV as well. So I will see all you guys later. Thank you for being here. I appreciate all the super chats. I appreciate all the new members, the super stickers, all the subs. Thank you guys very much. I'm going to go finish packing real quick. We'll try to finish packing because I have another live to do at 7:30 tonight, but I will be back. Love all of you guys. Have a good day. Stay safe. Bye.